ಮ್ಯಾಮ್ ಅದೇನು ತಗೋತೀರಾ ಇಲ್ಲ ಹೇಳ್ಬೇಕಂತ ಇಟ್ಟಿದ್ದು ಬೇರೆ ಪದ್ಮ ಮ್ಯಾಮ್ ಹೇಳ್ಬಿಟ್ಟು ಹೋಗಿದ್ದೀನಿ. ನೀವು ತಗೊಂಡ್ರೆ ಅವರು ವಾಪಸ್ ತಗೋತಾರೆ, ಇಲ್ಲಾಂದ್ರೆ ಅವ್ರು ತಗೋತಾರೆ. ಕೊಟ್ಟಿಲ್ಲ ನಿನ್ನೆ ಎಷ್ಟು ಒಂದೇ ಅಲ್ವಾ ಉಳಿದಿತ್ತು?
ಮಂಡೆಗೆ ಡೇಟ್
48 50 ಹೇಳಿದೆ 50 ಇದೆ. ಅದು ಹೇಳಿದೀವಿ ಮೀನ್ಸ್ ಸ್ಪೋಕನ್ ಬರ್ಬೇಕಿತ್ತು, ಅದು ಹೇಳ್ದೇನಲ್ಲ. ಇಲ್ಲ ಫಾಲೋಟ್ ಆಗುತ್ತಲ್ಲ, ಇವಾಗಲೇ ಹೇಳ್ತೀರಾ?
61 ಏನಿದೆ
ಅವರು ವೈಫೈ ಅಂತ ಕೊಡಬೇಕು. ಜಸ್ಟ್ ಆಫ್ಟರ್ 2 ವೀಕ್ಸ್ ಎಲ್ಲಿ ಬರೋದು? ಪಪೂಲ ತಗೊಂಡು ಮ್ಯಾಮ್ ನೆನ್ನೆದು 125 8 9 ತೋರಿಸ್ತೀನಿ. ನೆನ್ನೆದು 125 ಲಾರ್ಡ್ಶಿಪ್ ಹೇಳಿದ್ರಂತೆ 8 9 ತೋರಿಸ್ಬೇಕು. 8 9 ಅಂತ ತೋರಿಸ್ಬೇಕು ಸಿಸ್ಟಮಲ್ಲಿ. ಅಂದರೆ ಚೇಂಜ್ ಮಾಡಿದಾರಂತೆ ಸಿಸ್ಟಮಲ್ಲೂ 8 9 ತೋರಿಸ್ಬಿಡಿ ಅಂತ. ಅದು ಲಾಜಿಕ್ ಕೊಟ್ಟಿರೋ ಡೇಟ್ಸು. ಓ ಇದದು ಗೊತ್ತಾಯ್ತು.
Humble submission, my lord.
Give all the memos. Tomorrow there is no sitting.
Monday ಬೇಕು ಸರ್.
Monday go ಆಗಲ್ಲ ಕೊಡಿ. Monday already 500 listed. ಕೊಡಿ ಎಲ್ಲ.
ಮಂಡೇ ಸ್ವಲ್ಪ ಎಮರ್ಜೆನ್ಸಿ
ಯಾವ ಎಮರ್ಜೆನ್ಸಿನೂ ಇಲ್ಲ ಏನಿಲ್ಲ ಕೊಡಿ.
ಅಲ್ಲ ಜಜ್ಮೆಂಟ್ ಗೆ 11th ಗೆ ಜಜ್ಮೆಂಟ್
ಪರವಾಗಿಲ್ಲ.
ಪಾಸ್ ಆಗಿದೆ
11th.
10 ಅಲ್ಲಿ
ಮಂಡೇ ಏನ್ ಡೇಟ್? ಅದಕ್ಕೆ ಮಂಡೇ ಮೂವ್ ಮಾಡಿ 11th ಇದ್ರೆ ಕೊಡಿ. ಮೆಮೊ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ.
ಮಂಡೇ
ನೋ ಡೇಟ್ಸ್ ಇನ್ ಎನಿ ಮ್ಯಾಟರ್. 2:30 ಬೇಕಾದ್ರೆ ಮಾತ್ರ ಇರಿ, ಮಿಕ್ಕಿದೆಲ್ಲ ಕೊಡಿ.
One sub. Lordship, pending matter.
ಗಿವ್ ಸರ್. ಏನ್ ಮಾಡಕ ಕೊಡಿ ಸರ್, ಕೊಡಿ ಸರ್. 11th ಬರುತ್ತೆ.
One
ಶ್ರೀಧರ್
sub.
ಪ್ರಭು ಸರ್ ಏನದು? ಅಲೋ ಆಗಿದೆಯಾ? ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ?
One submission.
ಪರವಾಗಿಲ್ಲ ಕೊಡಿ. ಐ ಟುಕ್ ದಿ ಮೆಮೊ, ಐ ಡಿಡ್ಂಟ್ ಗಿವ್ ಅ ಡೇಟ್. ಗಿವ್ ಇಟ್. ಎಸ್, give all the memos.
One submission, Milords.
In 6. Wait, give it. No, tomorrow and day after tomorrow, no sitting, sir. Can't help.
Madam, Monday, madam.
Monday, no. Monday, I told you, they're already 500. I can't take beyond that.
My lords, pending matter. One
Pending matters, give all the memos.
one humble request, my
Give
lords.
all the memos.
The pending matter issue is that, my lords, the issues frame. I have filed additional application.
No problem, sir. Give it, sir. Give
But
it.
got allowed, my lords.
Give it, sir.
Now the matter before trial court is for final arguments.
ಈಗ ಸ್ಟೇ ಸಿಕ್ಕಿಲ್ಲವಲ್ಲ ಮುಂಚೆ.
The petitioner has sought stay. I am for the respondent. Now
Respondent.
the matter is for final arguments and I am the plaintiff before trial court.
ಹಾ, all right.
If those issues are not considered, then
We'll see. Vacating stay ಹಾಕಿ.
my lords, it's filed, my my lords, lords, may be
If
taken up
vacating
on-
stay is there, it will come. Leave it.
My lords, this is with regards to an taken up on acquisition. 11th, my lords.
Huh?
11th, next week, you need it.
No, sir. It will come on vacating stay will come. That according to its seniority, it will come.
My lords, this is with regards to an.
Milords.
My lords, this is with regards, sorry.
ಅಯ್ಯೋ ಆಯ್ತು ಕೊಡಿ. ವಾಟ್ ಸರ್ ಗ್ರೇವ್ ಅರ್ಜೆನ್ಸಿ? ಹಾ, ಇಲ್ಲಿ ಸ್ಟೇಟಸ್ ಕೋ ಇದೆಯಾ? ಆಯ್ತು. when was it granted? ಹಾ, ವೇಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ಬರುತ್ತೆ ಕೊಡಿ.
My lords, if you may please.
ಇದು ನಂದು.
My lords,
It will come, leave it. Give the memos.
Minutes.
my lords, if you may please.
ಅಯ್ಯೋ ಪರವಾಗಿಲ್ಲ, all give the memos. Tomorrow no sitting, give it.
Minutes. This is a memo for Monday.
Monday already 500 is there. No more memos for Monday. If you want, give it. Yes.
Minutes. Tuesday at
With regards
least.
to-
Where, whatever, please give the memo.
Minutes. The thing is, in this matter, we have filed an
Maybe
application.
if there is any urgency, move on Monday.
Minutes. Kindly
Monday,
minutes.
it's already full. I'm not taking a single
Minutes,
memo.
in trial court, it is
Can you
posted
leave
for
next time,
arguments.
my lords?
Minutes. That's
Maybe,
it.
sir.
It's our primary document because
Maybe, sir.
we are relying upon it. Our
Nothing
whole
doing.
case
Give
would
it.
be jeopardized. Minutes.
Maybe, sir. Can't help. Give
Kindly
it.
minutes.
No,
It is
no,
humble
sir.
request.
You move on Monday. Yes.
My lords,
Hey, give the memos. Why are you all waiting?
Madam.
Vacating idre ಬರುತ್ತೆ
my
ಕೊಡಿ.
lords, this is with regards to an acquisition.
Connected matter. What connected matter? 482 ನಾ? ಮತ್ತೆ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಯಾಕೆ? ಅದು ಪರವಾಗಿಲ್ಲ ಬಿಡಿ, ಇರ್ಲಿ.
My lords, this is
ಏನ್
with
ತೊಂದ್ರೆ?
regards to, my lords, this is,
ಕೊಡಿ ಸರ್, ಮೆಮೊ ಕೊಡಿ. ಯಾಕೆ? No, 230. Oh, yes.
my lords, this is
My
with
lords,
regards to an
written
acquisition, my lords.
ಅದು ತಗೊಳ್ಳಿ, 230 ತಗೊಳ್ಳಿ.
My lords, my lords,
The TCR is before
If
this
all
court.
of you are telling together, what's in discipline law, chaos, what is all this? I will not take a single memo if you don't be disciplined. Yes, tell me. Why? So? An urgency illa. But yes, next. No urgency. Yes, next. Ad beda. Next. Amale. Give it. Give the memo, sir. Give the memo, sir. Yes.
Lordship, stay ಇದ್ದಾಗ recovery ಮಾಡಿದ್ದಾರೆ. Substantial amount has been recovered from.
Parala kodi. Yes.
my lords, this is with
No
regards.
230. Why?
Substantial amount has been recovered.
ಏನ್ ರಿಕವರ್ಡ್?
7 crore
ಯಾವ್ದ್ರಲ್ಲಿ?
income tax department.
ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ತ ಕೊಡಿ. ಎಸ್,
My lord,
230 ತಗೊಳ್ಳಿ.
and this is with regards to an acquisition that is, I know notice has been sent, my lord, but it is not sent to the actual owners.
ನೋ ಪ್ರಾಬ್ಲಮ್, ಗಿವ್ ಇಟ್.
So, request.
ಯಾವಾಗ 50 years ago?
No, my lords, it's been like a month, before.
ಅಲ್ಲ ಅಲ್ಲ,
28
ನೋಟಿಸ್ ವಾಸ್ ನಾಟ್ ಸೆಂಟ್. ಅದು ಯಾವಾಗ?
No, it was not sent to the actual owners.
ವೆನ್ ವಾಸ್ ದಟ್ ಸರ್?
That was before a month, my lord.
give it. No,
So that is the reason, if you can give us a date, my lords.
no
not
date.
Next week,
Give it,
anytime.
sir, give it. No. Why ನಿಮ್ದು ಒಬ್ಬರದೇ ಅರ್ಜೆನ್ಸಿ ಬೇರೆಯವ್ರದಿಲ್ವಾ? ಯಾವುದಕ್ಕೂ ಡೇಟ್ ಕೊಡಲ್ಲ, ಕೊಡಿ.
Please, my lords.
Oh, sorry?
Bank account has been hacked.
Give it, yes.
And also one more, my lords, with regard to contempt, it has been a contempt proceedings against.
Tax matter. ಕೊಡಿ. 230 ತೊಗೊಳ್ಳಿ.
Pending CRP, the TCR is
Give
before
it,
this court, there's no stay, my lords. I filed an application to return the TCR. Since 2016, there's no stay and the TCR is before this court.
TCR is here.
TCR is before this court.
There is no stay.
There's no stay. The stay
Madam,
has not been extended.
you post that matter on Tuesday in admission.
I'm grateful.
My lords, request next week, any date, my lords.
Give it, sir.
Defendant 6 is alienated should schedule properties in at the.
Memo ಕೊಡಿ, sir.
My lord, one submission.
No urgency, memo ಕೊಡಿ. Monday, up to Monday, don't move any matter.
Your lordship, kindly,
Give it.
one matter for
My lord, written submission.
consideration,
ಅಲ್ಲಿ ಕೇಳ್ತಾ ಇದೀನಲ್ಲ.
one matter for consideration of interim prayer. My lords, matter is posted on 19/9. Notice is already served and a respondent is represented.
ಕೊಡಿ.
Preliminary issue,
ಕೊಡಿ, sir.
preliminary issue. my
ಅಯ್ಯೋ
lords.
ಕೊಡಿ, sir, memo.
My lord, it's CRP pending matter, my lord.
Give it, sir. Give all.
23, it is pending, my lord. Any date next.
Let it be pending since 13. No problem. Give it. Give it, sir. Give it.
My lord,
Give all the memos.
my lord, it's a fresh tax matter, my lord. Endorsement.
Fresh
notice
matter ಏನಿದ್ರು next, only on 22nd, on 15th.
has been issued, my lord. It's the threat of recovery, my lord.
My lord, regarding a written submission, my lord, is a matter for reserve or order side.
ಅದು ಕೊಡಿ, ಅದು written
ಅದು written
submission
submission.
ತಗೊಳ್ಳಿ.
Being spoken, my lord. From the honorable court,
What being spoken to?
my lord, directed to consider the application.
Madam,
within
written
3 weeks.
submissions.
ಯಾವ್ದದು?
Written submissions. ಹಾ, ಹೇಳ್ದೆ,
13
ಕೇಳಿ.
into 1 and 2, my lord.
ಹಾ, ಏನಾಯ್ತು ಈಗ?
3 weeks time ಆಗಿದೆ. Extension of 2.
ಆಯ್ತು ಕೊಡಿ.
My lord, 230.
ಮಂಡೇನೆ. Yes.
Worship, my family members are attempting to.
Give the memo, sir. Not, why? Rejected written statement. Stage is written statement. ಏನಾಗಿದೆ ಈಗ? ಅದಕ್ಕೆ ಅರ್ಜೆನ್ಸಿ ಅನ್ನು 230ಗೆ. 230ಗೆ ಅರ್ಜೆನ್ಸಿ 7 rule 11 ಅಲ್ಲಿ ಸೂಟ್ ಫಾರ್ ಅದ್ರಲ್ಲಿ 7 rule 11. Yes, anything else? ಬರ್ಲಿ ಬಿಡಿ. No 230. Yes. ಮಂಡೇನೂ ಇಲ್ಲ.
Suit for injunction, my lord. It suit schedule property and the double return statement property total.
ಏನ್ ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್?
Fresh, my lord.
ಕೊಡಿ.
ಅಲ್ಲ, ನಾನು 19ಕ್ಕೆ ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಹಾ.
ಅರ್ಜೆನ್ಸಿ ಅಂದ್ರೆ ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ ಆರ್ಡರ್ ಆಗ್ಬಿಟ್ಟಿದೆ. ನನ್ನ ಕಮಿಷನರ್
ಪ್ರೊಟೆಕ್ಷನ್ ಆರ್ಡರ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ. ನನ್ನ
ಇಂಜಂಕ್ಷನ್ ಯಾರ ಫೇವರ್ ಇದೆ?
ಅಲ್ಲ ಅವ್ರ
ಇಂಜಂಕ್ಷನ್ ಯಾರ ಫೇವರ್ ಇದೆ?
ಪ್ಲೇಂಟಿಫ್ ಫೇವರ್ ಆಗಿದೆ.
ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ ಆರ್ಡರ್ ಇಸ್ ಅ ಕಾನ್ಸಿಕ್ವೆನ್ಸ್.
ಅಲ್ಲ ನಂದು ನನ್ನ ಸಬ್ಮಿಷನ್ ಇಸ್ ಟೋಟಲಿ ಪ್ರಾಪರ್ಟೀಸ್ ಆರ್ ಟೋಟಲಿ ಡಿಫರೆಂಟ್, my lord.
ಅದು ಸೂಟ್.
I have filed application for appointment of commissioner, my lord. That application is dismissed, my lord. ಅದಕ್ಕೆ
ನೋ ಪ್ರಾಬ್ಲಮ್ ಸರ್, ಕೊಡಿ, ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ.
My lord's family
Yes.
members are attempting to sell the property.
You want to give the memo, please give.
Your lordship, fresh matters, my lords,
It
they
will
are
come, sir.
attempting to sell the property.
No,
my lords.
sir.
Your
Monday already I told you there are 500 matters. I'm not taking anything.
Your lordship may have it on Monday, my lords.
Huh?
Monday, my lords.
ಅದೇ 500 ಇದೆ ಅಂತ ಹೇಳಿದ್ದು. Next Monday we'll take 8th,
My lord,
9th,
next matter,
15th.
VDA, my lord, VDA.
Give it.
Threat of disclosure.
Give it, yes.
I have it on Monday.
Call the case.
May I mention one matter?
Adjournment.
Well, no, this matter was scheduled to come up today.
Ah.
It was tagged along with certain other matters.
Hmm.
Those other matters are on board. This matter, which was the fresh matter, which my lord had passed in order.
Tax matter.
Tax matter.
I will get it posted.
230.
Give it, yes.
To serial number 10, I moved memo for being spoken to, my lord. However, it's been listed in preliminary hearing.
ಯಾವುದು?
List to serial number 10.
Being spoken to move ಮಾಡಿದ್ರೆ?
Yes, ma'am. But however, my lord, inadvertently it has been listed in preliminary hearing. Sought, my lord, the name of the petitioner's counsel is wrong. That's sought right.
Tikkena.
In my being spoken to also, my lord, I have clearly mentioned.
10 ನಲ್ಲಿ the memo is moved for being spoken to, but the matter is listed for preliminary hearings. The correction ಏನಿದೆ ಅದು ಮಾಡ್ಬೇಡಿ. Counsel name ಅಷ್ಟೇ.
Please.
Your lordship, this is a new matter, tax
Enough.
matter.
Call the cases.
Your lordship,
Give it, give. ಕೊಡಿ.
tomorrow if it may be taken, similar orders are passed, your lordship.
Tax.
Multiple officers have passed for the same.
Oh, those matters. Give it, yes.
Tomorrow.
Fresh matter.
Yes.
Tomorrow you're coming to the court?
Monday it may be taken up.
Not Monday. We'll take it.
This is the matter where day-to-day it is running in a
Day to day running.
Day-to-day it is posted for a hearing and one of the other things. One of the defendants is placed ex parte in a partition.
ಯಾವ ಈಗ ಅರ್ಜೆನ್ಸಿ ಏನು?
Urgency is that because they are going to declare the truth, I am placed ex parte.
Ah.
Today it is also there, then that is why kindly have.
230 ತಗೊಳ್ಳಿ. 2:30.
Your Honor, I seek for an adjournment.
No adjournments. Mention when it is called. Yes. Call the case.
Order still number 1. Please,
Rectification. Disposal.
My lords, we had filed an IA for disposal in
Why?
this matter. My lord.
Dismissal.
No, not dismissal. My lord. This is squarely covered by the decision of Supreme Court, and the matter is already part heard by the previous.
We will send it there only?
No, my lord.
Ah, yes.
Let it be, my lord, be posted for hearing, my lord. Let me examine this.
Covered alva.
Allah, this is, my lord, they have raised an issue.
Ah.
My lord, during the pendency of the proceedings before the NCLT, there cannot be any, my lord, proceedings by the department.
My lords,
That is the contention.
I think that issue
My lord,
is
my
answered.
submission is that
I've already produced the.
they are only restrained from, my lord, from initiating any recovery.
Nimsha, which is the decision, madam?
Ghanshyam Mishra and Sons, my lords, that is by Supreme Court, and there is Ruchi Soya by the.
There is no Ghanshyam, no Sons.
My lord, Ghanshyam, that's Ghanshyam Mishra, my lord, once the, my lord, resolution plan was accepted and department doesn't make any claim, my lord, claim of the department gets extinguished. That's on the point, on that point.
Alien point different.
My lords, I'd like to take my lord's attention to the second matter, Patanjali Foods Limited, page number 33 onwards.
Yes, madam.
My lords, in my case, central excise proceedings, show cause notice was issued during the moratorium period, my lord. So I had applied for an NCLT CIRP proceedings, pursuant to which an NCLT order was passed, which declared the moratorium. And subsequent to the declaration of moratorium, there was a notice sent to the Central Excise Department to produce the statement of claims. Subsequently, the department had produced the statement of claims. Thereafter, they have issued the show cause notice, my lords. The CIRP proceedings was not completed, and also the resolution plan was not approved. Before the resolution plan was approved, the show cause notice was issued. So therefore, there was a proceedings initiated during the period of moratorium, and this is the reason all the decisions that I have submitted before my lords says that during the pendency of the CIRP proceedings, where the moratorium period has
Now
been.
resolution plan is approved?
Yes, my lords. Resolution plan is approved.
Yes, sir. Covered. ಅದ್ರಲ್ಲಿ ಏನಿದೆ? ಇವಾಗ ಬಂದ್ರು ಅಷ್ಟೇ, preliminary ಬಂದ್ರು ಅಷ್ಟೇ, hearing ಬಂದ್ರು ಅಷ್ಟೇ.
I wanted to see.
Yeah, Justice Pandit completely covers the issue. Patanjali Foods.
My lords, there are three. One is central excise, my lords. There's another proceeding by the Central Sales Tax Authority also.
ಇದು ಯಾವುದು madam?
So 15951.
Which is this?
15951 writ petition is for the Central Sales Tax Authority.
1595?
The first matter, my lord.
Central Sales Tax.
15459 of 21 is the Central Excise issue.
ಎರಡರಲ್ಲೂ ನೀವೇನಾ ಜೀವನ್?
For central, I appear.
In 1.1, I'll appear.
1.1 ಅಲ್ಲ 1.1 ಜೀವನ್ ಅಂತಿದೆ.
I'll appear. Status passed in order.
R2 and R3.
ನಾನು appear judgment ನನ್ನ ಮೇಲೆ ತೋರಿಸುತ್ತೆ. ಅದೇನೋ
Central tax is also there, my lords. And also there is another writ petition 19377 which is under income tax proceedings, my lord.
Where is that?
But that is not tagged in this matter.
We'll wait for it to be tagged or
Yes, my
close
lords.
this.
Yes, my lords. We would like to get the matter to be tagged. But if this is
close these two, your lordship.
No, wait. Telling something. Wait.
no, my lords. So this can be closed, my lords, since the matter is
Why you're
taken up
taking
today
cue
for
from
hearing.
his statement? Yes, Jeevan.
My lords. Some Malayalam friends say that some latest judgment has come on this.
ಯಾವುದು?
Whether proceedings can be drawn, whether proceedings can be drawn during the moratorium period. That is one thing. Recovery proceedings, we are not initiating any recovery proceedings.
Pass an order.
Not recovery. Any proceeding cannot be done is what is said.
That is what, my lords.
My lord,
You
that is
look
what
into
is
this
said in
Patanjali Foods, Justice Pandit or in detail.
That is what is also said in Ghanshyam Das, my lords.
Ghanshyam Das, my lord, says that, my lord,
My
it
lords.
puts an end to the
I
whole
have another
proceedings.
submission in this matter, my lord, 15951, where the state is the party. There, the state has not made a claim before the NCLT at all for the resolution plan. So the claims of the state is not a part of the resolution plan at all. And therefore, the proceedings or any recovery initiated by the state authority will not be taken into consideration.
Central or
You have not initiated, I.
Central or claim.
Center Madidare. Central is.
So my claim is there before the acceptance of a resolution plan. My claim was.
ಅದು claim ಇದೆ.
My claim is there.
Identical facts in Ghanshyam Das and this.
My lord, and also
No,
as per the
Ghanshyam Das, my lord, very specifically, my lord, deals with the issue, my lord, once the resolution plan is accepted. No
Illu
further
ಅಷ್ಟೇ,
claims.
it is accepted.
No further claims.
Illu resolution plan is approved.
Now, resolution plan, before resolution plan could be accepted, my lord, I had made my claim, my lord. My claim is there.
Even then, once resolution plan is accepted, this goes.
All other
Claim of
proceedings.
the revenue will
my lord, it
go.
will put an end to all other proceedings.
Yes.
My lords, before the resolution plan was approved, proceedings were not supposed to be initiated. And
No,
during the period.
That may not be correct.
That's-
That may not be correct.
One moment. There are two things, madam. One is during the subsistence of the moratorium, whether they can stake their claim, revenue can stake their claim is one thing. After acceptance of the resolution plan, whether that can be continued is another aspect. Now, insofar as moratorium is concerned, they can definitely stake the claim. No doubt. But that cannot be continued if resolution plan is approved.
Agreed, my lord.
That is the purport of Ghanshyam Das and this.
As per section 14 of the IBC, my lords, once the moratorium is declared, from the time the moratorium is declared as per the NCLT order until the resolution plan is approved, no
Anyway, in
civil
your
suit
case,
or
it is
anything
approved.
can be
So,
initiated, my lords.
in your case, it is approved. Correct?
Approved.
And then why do you go back? Well, don't put the clock back.
My lord, my difficulty is to stake a claim, there should be a determination.
ಅದನ್ನ ನಾನು ಹೇಳಿಲ್ಲ.
ಅದಲ್ಲ,
I will
so-
not enter into the issue whether during the moratorium period, you could stake your claim or demand from them. That's one thing. Once resolution plan is approved, that demand vanishes. That's all. That is the law. The latest judgment, what he is referring to is whether you can initiate steps during the moratorium. The
extent, my lord,
courts have clarified during the moratorium you can.
Yes.
But once it is approved, your
No, I
claim,
have to go
your
before the resolution
claim
pro-
ceases. You can't do this. ಅಲ್ಲೇ ಮಾಡ್ಕೋಬೇಕು.
ಅಲ್ಲೇ ಹೋಗು. That's.
My lords, one
I
last
was only
submission.
trying to impress upon that particular part where.
No, that's what I have understood. I don't know, it may be wrong, whatever.
Okay, to
No, no, no.
even during the moratorium period, my lords, we can proceed.
I can determine the, my lord, liability.
Adjudicating order. But recovery, we have to go before the NCLT if the matter is pending there.
All
If
right.
it is disposed of, we cannot initiate
Now,
any
if the
recovery.
plan is approved and the process is over, then your claim goes.
Yes, we cannot initiate any recovery against that.
My lords, I would like to take my lord's attention to the resolution plan, my lords. Page
It is
number
approved
131.
now.
It is approved, my
No,
lords.
don't
The
worry.
claim is zero in resolution plan, my lord.
That they will find it out if they want. Resolution plan, once it is approved, the claim of the revenue,
Possibility, my lord,
claim of the revenue would go qua the notice that is issued to you during the moratorium.
Yes, my lords. It was issued.
My lord,
to me.
claim
But
would not-
whether they can issue during the moratorium or not, we will not go into that.
Please.
My lord, my claim will not go, my lord. My claim will lie before the resolution.
ವ್ಯಾನಿಶ್ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ. ಅಲ್ಲಿ ಎಲ್ಲಿ ಮಾಡ್ಬೇಕು ಮಾಡಿ, ಇವ್ರ ಮೇಲೆ ಬರಲ್ಲ ಈಗ.
If lords should
ಅಲ್ಲ,
say.
ಇವ್ರ ಮೇಲೆ ಬರಲ್ಲ ಈಗ ಅಂತ ಅಷ್ಟೇ.
ಅಲ್ಲ, I cannot initiate independent proceedings under the provisions of the act.
Correct.
But however, my lord, I can stake claim before the.
All
my lord,
liberties that are there will be there.
that's-
Obliged, my lord.
ಅಷ್ಟೇ ಅಲ್ವಾ?
Yes, my lords.
The petitioner is before this court calling in question an order dated 14/9/2020 passed by the third respondent and consequent demand made on on the same date. Recovery proceedings initiate madadala on the same date. Heard so and so. What's your name?
I am Vinita M. Lords.
Barpur. Heard the learned counsel so and so appearing for the petitioner and the respondent. The petitioner. Idu preliminary hearing so I have not seen.
Lordship may need not quash the, my lord, orders.
Why?
The orders are quashed. My lord, then my lord, I cannot make a claim
ಏನು
before
ಅಲ್ಲಿ
the
ಟ್ರಾನ್ಸ್ಮಿಟ್ ಮಾಡ್ಲಾ?
resolution profile.
ಕ್ವಾಶ್ ಮಾಡ್ತೇನೆ.
ಅಲ್ಲಲ್ಲ
With all liberties you can have.
ಅಲ್ಲ my lord, ನನ್ನ ಡಿಮಾಂಡ್ ಹೋಗ್ಬಿಡುತ್ತೆ.
Demand over.
ನನ್ನ in law my lord there is no demand. Then they will say before the resolution professional that
No, that liberty we will reserve, sir. Hanganta
ಅಲ್ಲ whatever the demand my lord we have raised in this impugned order.
Approved the resolution plan and has given no claim, the claim in the NCLT order for the central
Where is
authority
that,
and-
madam? Claim. Page.
Yes. Page 106 of 15459 writ petition.
It's not there in this?
Yes. Page 98 minutes.
Where do you find it? Other debts.
So it's operational creditors,
98.
5 minutes. Serial number 5 of the
Operational
table,
creditors.
operational creditors, which includes the central government and the state government authority.
Correct.
And their claims. To the extent of
Amount claimed, amount admitted, nil. They have not claimed anything there.
My lord ಇಲ್ಲಿದೆ ನೋಡಿ.
Milods,
106 you will also make and
Companion petition ಕೊಡಿ madam.
ಅಲ್ಲಿ
ಇಲ್ಲೇ ಇದೆ 106, sorry.
ಹಾ
ಇಲ್ಲ 106 ಇಲ್ಲ ಹೇಳಿ.
ಅಲ್ಲ petition writ petition
15459 ಅಲ್ಲಿ 106.
106 of the writ petition. The amounts provided for the stakeholders under the resolution plan is as under. Your lordship, sir.
106. Yes, sir.
ಅಲ್ಲಿ ಕಾಲಮ್ ಲೋಡ್ 5 ಆಪರೇಷನಲ್ ಕ್ರೆಡಿಟರ್ಸ್ ಅಂತ ಇದೆಯಲ್ಲ,
ಹೌದು.
ಅಲ್ಲಿ ಕೆಳಗಡೆ ಗವರ್ಮೆಂಟ್ ವರ್ಕ್ಮನ್ ಎಂಪ್ಲಾಯೀಸ್
7.94.
Yes, Milods.
What do you say, Neil?
Milods, this has to be read with the resolution plan, page 131, Milods. Para D, resolution for statutory liabilities. Milods.
131.
131 Milods. So here.
Central sales tax 0.
Sales tax is 0, central excise is 22.5 lakhs.
ಎಲ್ಲಿದೆ?
And there is a clause which says the cash flows in the resolution plan are not sufficient to service all the financial creditors in full. Accordingly, the statutory liabilities might not be receiving any payments towards their claims. However, considering the nature of the liability, the resolution plan has attempted making payment towards such liabilities as specified below. The last but one paramilor, the remaining duties of Karnataka value-added tax, central sales tax and central excise shall be adjusted against the input tax credit or advances available with respective authorities. In case the same are not adjusted for any reason, these claims are proposed to be settled at nil value.
Yes, sir.
ಅಲ್ಲ ಡಿಮಾಂಡ್ ಸೆಟ್ ಅಸೈಡ್ ಆದ್ರೆ ದಿಸ್ ಆಲ್ಸೋ ವಿ ಕಾಂಟ್ ಡೂ ಇಟ್. Lord squashes the my lord demand.
Yes.
This also we cannot do it. That's my my lord.
We'll see.
We can do this only if the my lord demand survives. Adjustment of this output tax liability, the input tax my lord, only towards the enforceable demand. ಹೌದು ನಾವು ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ನಮ್ಮ ಡಿಮಾಂಡ್ ಇರ್ಬೇಕಲ್ಲ.
Milods, I take my lord's attention to page 95 and 96 of 15459 writ. This is the statement of claim submitted by the central authority.
Yes.
Page 96, Milods. serial number 7.
Let's see, it hinges on whether it should be quashed or otherwise.
Yes, that's
Heard reserved.
reserved, or reserved.
Interim order subsist, it's absolute? Interim order is absolute?
Yes.
Yes.
Number 2.
Orders are quashed, my lords, will not be able to implement it.
Yeah.
We'll see, we'll see.
In law, my lord, we cannot, my lord, enforce anything, my lord, even under resolution plan.
My lords, but quash the recovery proceedings, give it open for us to
Take appropriate
steps available in law.
Let's see. Idu nimdena? Third one, second one.
Second one is
Amendment of cost at impleading whom?
Lords, impleading on the last occasion, my lords, impleading of the director of the Yoko Bank was made, my lords.
It's allowed?
Yes, my lord, allowed, my lords. There's one more application to implead, my lords, as per the direction of this honorable court, my lords. The commissioner of the centralized processing center, my lords, of income tax department, my lord, he is also
will permit.
Please.
Hello,
Yes, my lord, it can be permitted, and the for respondent number 1 is not a necessary party. He is a PRO commissioner.
Delete Madi. Not a necessary party?
PRO is
PRO section. Why do you need PRO section?
Well, delete.
Learned counsel for the petitioner seeks leave of the court to delete the first respondent from the array of respondents at the separate order. For the reasons indicated in the affidavit accompanying the application, IA-1 of 2024 stands allowed. The petitioner is permitted to implead. Which is that respondent?
My lord, respondent number 5 minutes now.
Respondent number 5. Learned counsel, emergent notice.
Lord,
Arvind Chavan may be directed to take notice on behalf of Arvind Chavan.
Learned counsel Arvind Chavan accepts notice for the 5th respondent.
Please, we'll file the amendment.
Yes. Petitioner to file an amended petition in due course. Next.
Lords, kindly just place this judgment on first matter.
Moratorium.
Since my lords have reserved it.
Yeah, we'll do it.
Serial number 2 or date may be fixed.
2023, it will come, yes. In either 2 or 3 days, tax, yes.
number 3.
Connect Google India. Yes,
I'm told that they are going to file rejoinder, my lord.
My lords, we have to file a rejoinder and.
Learned counsel appearing for the petitioner seeks 2 weeks' time to file a rejoinder statement to the so filed by the revenue list after 2 weeks.
My lords, the interim may be extended.
Interim order subsisting will continue to the next.
4.
For the respondents, my lords.
Okay, for the petitioner, my lord.
Yes, Madhu.
Lord, this is summons has been given and he has to come for the summons. Investigation is on. There is a search which was conducted by, in fact, DGGI Visakhapatnam. Respondent number 1.
Yes, madam.
I filed my statement of objections, if that may be.
Objections to what?
Vacating application.
Vacating application,
yes.
Yes, really.
Your lordship, this is a case. Kindly, if I may draw your lordship's attention to the prayer that I've made in my writ, your lordship. Your lordship, the first is to seek quashing of the summons which is issued by the first respondent. The second is that the respondent had seized certain material, which includes my books of accounts. I've asked for making copies of it and return, because in the summons, which is generic in nature, repeatedly they will ask me for a bunch of things or give generic information and keep calling upon the managing director to appear, your lordship. The third is, your lordship, is an important prayer, which is that the respondent should specifically state what is it that they require so that I can comply with the summons.
If you appear, they will tell everything.
May I just submit, your lordship? Then I've
sitting somewhere, you're saying they're not divulging anything. You appear before them. I will direct them to give all the material that is needed to you. You furnish your reply or whatever.
May I just submit, your lordship? There subsequent proceedings that have happened after the last order from this honorable court, which have produced.
Interim order of stay. Oh, that vacating.
Interim order has been granted. As your lordship, the law.
Not to arrest
ಹೌದು. The
All
law
right.
permits that if the senior key managerial persons are summoned, then any person can authorize his or her representative to appear. Now, this respondent particularly wants only the managing director to come in person. Whoever we depute, the repeated summons are given only to the managing director.
The summons are issued pursuant to penal provisions.
Your Lordship, under section 70. Now, after
70 of
the CGST Act. Your Lordship, my statement of objections may kindly be seen.
70 and Kodi. GST intelligence, is it?
Yes, Your Lordship. My
Summons
statement of
pursuant to what?
section 70, they don't tell for what.
Search agide.
Bari inquiry anta ಹೇಳ್ತಾರೆ, bari investigation anta ಹೇಳ್ತಾರೆ, Your Lordship, without giving any other details. Pursuant to order of this honorable court, this honorable court directed.
There is protective order not to arrest.
Yes.
They will not do it. You appear before them.
I have some submissions to make it.
Oh, all right.
Your Lordship,
law is
this honorable court had made an observation that I can seek from exemption from personal appearance and depute somebody else, an authorized representative, Your Lordship. Annexure L in my statement of objections, Your Lordship.
Page.
Page number 13. Objections to vacating application.
Page 30.
13. This honorable court had directed that on 29th, in the previous summons, they had asked for a bunch of things that we need to produce all those documents. 29th January 2025, I appear before the respondent, Your Lordship, through my authorized representative, page 14, para number 3. I give all the records which this learned officer wanted by producing all the relevant details. And I have attached also the order of this honorable court, which permitted me that I can, page number 16, Your Lordship, the order of this honorable court, that I can seek liberty to, petitioner is at liberty to seek
exemption from personal appearance.
Yes, by deputing. Now, Your Lordship, the first respondent who has filed the application for vacating stay, he's not even there at that time, even though a date was fixed by this honorable court. Now, in the application for vacating stay, they say that the contention that they take is, we have not complied with this order. We should have, the managing director should have personally appeared. He is not there. But they don't disclose the fact that the very same officer was not even there as on 29th January 2025. Thereafter, Your Lordship, Annexure M, page 21, kindly see the nature of the summons, Your Lordship. I so and so making an inquiry in connection with irregular availment and utilization of ITC. And whereas I consider your attendance necessary to give attendance, there is no reason for what purpose I need to come, which tax period, no other details, nothing has been mentioned, Your Lordship. And Annexure M1, page 22, I give detailed reply saying that I've already appeared on the last date. I have given whatever documents that were required. And before this as well, on 4th of December, statements have been obtained from the very same petitioner, Your Lordship. And then again in November 2024, again another several documents and important files have been seized, which is at page number 23. And kindly see my prayer in page 25. Where I'm saying, please provide the reasons for which I'm being repeatedly summoned. And I also ask for an authorization for issuing the summons, because there are two different officers in this present case, Your Lordship. The first respondent says appear before the second respondent, who is based in Bangalore. First respondent is in Visakhapatnam. So I ask for the authorization, Your Lordship. And I make a request, give me copies of whatever documents and details that were seized. Then, Your Lordship, in the meanwhile, after I give all these documents, under 86A, my ITC is blocked by an officer, Annexure N, page 27.
Now you are challenging summons.
Yes. Now,
and these subsequent acts have happened pursuant to the summons, including blocking of ITC.
Yes.
All right.
Yes.
Now whatever information you want, they will give you.
Keeping all contentions open and not to arrest me and
That
permitting
we'll see. Let me hear him.
And permitting the petitioner to appear through authorized representative.
All that we'll hear, Madhu. Wait.
And one last submission, Your Lordship. Annexure N, page 27, the officer, Your Lordship, every investigation, every inquiry should result in some proceedings. That proceedings is under 86A, where 6 creditors have been identified, and a sum of 8.9 crores ITC wrongful availment, that is a ground which has been taken. An order has been passed. Rule 86A permits the petitioner to challenge the same before the commissioner. That proceeding also is pending, Annexure N1, Your Lordship, where
You have challenged it?
I have challenged it. That is pending. Now the respondent number 1 yet again wants to initiate, give me summons. For what purpose? No details are forthcoming. And Your Lordship, Annexure Q, page 49, under section 74, they have initiated proceedings by giving me a pre-show cause notice. When there are assessment proceedings pending, when there are proceedings pending with respect to blocking of my ITC, and a grievance redressal mechanism before the principal commissioner is pending, for what purpose are they repeatedly summoning me? No details have been forthcoming.
Right, you said that.
Yes.
Lordship, this is an intelligence action by DGGA Visakhapatnam, respondent number 1. There was a search which was initiated on 21/11/2024 at Annexure B. Just to dates minutes. I wouldn't take much time. 21/11/2024 Annexure B.
Annexure B, yes.
There was a search which took place, Milords, on an intelligence action saying that it is a fake invoice issue. Then thereafterwards, Milords, summons was served. He did not come properly. Only once he came. Then thereafter, my lords, kindly, if my lords may kindly turn to 22 page number.
Yes.
There was another search proceedings which was conducted in Yeshwantpur office, 22/1/2025. Post which we give another summons, fifth summons, which was given on page number 26. This summons was given for him to come and attend at Bangalore office. Intelligently, they have misled this court to say that I will go and appear before the respondent number 2 and made respondent number 2 as a party, which is evident from
Visakhapatnam office.
Visakhapatnam in the summons.
Second respondent.
Bangalore officer. Case registered ಆಗಿರೋದು ವಿಶಾಖಪಟ್ಟಣಂ ಅಲ್ಲಿ. ಇವ್ರೇನ್ ಮಾಡ್ತಾರೆ, ನಾವು ಸರ್ಚ್ ಮಾಡಾದ್ಮೇಲೆ ನೋಟಿಸ್ ಸಮನ್ಸ್ ಕೊಟ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಬಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ದು. ಎಲ್ಲಿ? ನಮ್ DGG ಆಫೀಸ್ ಬೆಂಗಳೂರಲ್ಲಿ. ಇವ್ರೇನ್ ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ, ಬೆಂಗಳೂರು ಆಫೀಸಿಗೆ ನಾವು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತೀವಿ ಅನ್ಬಿಟ್ಟು ಮಿಸ್ಲೀಡ್ ಮಾಡ್ಬಿಟ್ಟು ಈ ಕೋರ್ಟ್ ನ, which is evident on 25/1/2025 order. They say, yes, I'll go before respondent number 2 and I'll answer before them anbuttu. They take this order.
So they don't appear before the first respondent at all.
They just write a letter saying they don't appear. They just write a letter to respondent saying that I have given a representation letter. And when I got information from my office, respondent number 1 has given letter to respondent number 2 has given respondent number 1. Bangalore DGG office has written letter to Bangalore Visakhapatnam office saying that we have nothing to do with this case. Whereas they mislead this court to say that no, I'll go appear before respondent number 2. This is the conduct of the petitioner. Point number 1. Point number 2, my lords, they have sought for not to arrest, pre-trial arrest under 226. Because this was the law until Radhika Agarwal judgment was given. Before Radhika Agarwal judgment was given, Chudamani Parmeshwaran Nair judgment said, since this is a statutory action, therefore you should go under 226, go before 226 for pre-trial arrest. Now, para number 70 of the judgment of the Supreme Court, madam, they have overridden the para number 70
of which judgment?
Radhika Agarwal.
That is 25.
Para number 70, my lords, if I may read on that very point. Para, my lords. We also wish to clarify that the power to grant anticipatory bail arises when there is an apprehension of arrest. This power vested in the courts under the code affirms the right to life and liberty under Article 20 of the Constitution. Thus, in so-and-so, this court had held that when a person complains of apprehension of arrest, approaches for an order of protection, such application, when based upon the facts, will not be vague or general allegations, should be considered with the court to evaluate the threat, apprehension, and its gravity and seriousness. In appropriate cases, application for anticipatory bail can be allowed, which may be conditional. It is not essential. The application of anticipatory bail should be made only after the FIR is filed, as long as the facts are clear and there is a reasonable basis of apprehension of arrest. Yes. The principle was confirmed recently by the Constitution bench in Sushila Agarwal and so on. So some decisions of Gujarat versus Chudamani Parmeshwaran Nair and Bharat Bhushan, it's through its investigating officer, of this court in this context of GST Acts, which are contrary to the aforesaid ratio, should not be treated as binding. So that point of time, everyone used to knock the doors of 226 saying that it is a statutory arrest, because there's a Padam Narayan Agarwal judgment of 2008 which told there's no magisterial intervention. So therefore they came before this honorable court and misled the court and took 226 to say that don't arrest me at the time of answering to the summons. Now in view of this judgment, that overruled.
All right.
So therefore, my lords, he has to come and appear before the summons, sir. He has to give all the information. Therefore, the question is, should he come? He only has to come. After 110/2024, there's an amendment to section 70, my lords, where it says when the officer directs that very person has to come, that very person has to come. There's an amendment in section 70.
Yes, 70.
There is an amendment which is there in 110/2024, my lords,
110/24.
which is made paramateria with section 108 of the Customs Act, where they say if a officer gives summons and directs that very person has to come and attend, that very person has to come and attend. Therefore, my lords, in this case, we have asked him, let him come before because our investigation is stalled. And moreover, my lords, my one more point is, my lords, it is not even maintainable here. They have to go before the Adjudication.
226 court.
Visakhapatnam hogbeko, because the case is registered there. They only assumed this jurisdiction to say that no, I came before the Bangalore office. That is the.
Yes, madam.
Your Lordship, just 2 or 3 submissions. On the first submission that we have misled this honorable court by impleading the second respondent, I respectfully submit that it's an absolutely incorrect statement. Kindly see annexure F to my writ petition.
One second.
Yes.
Visakhapatnam hogbeku anta helidralla. There is a communication saying Vizag has nothing to do with this.
No. Bangalore is nothing to do with Vizag.
Bangalore is nothing.
Your Lordship, annexure F to my writ petition, where the first respondent in the summons which is issued specifically says you have to appear in the office of the second respondent. There was no reason for me to go before the second respondent if the first respondent has not stated that you please come before the second respondent office. So no much issue.
Now where do you want to go?
Your Lordship, my respectful submission.
But you have to go somewhere.
Your Lordship, my
Yes.
respectful submission is section 71A, the amendment that is referred, Your Lordship. In fact, that amendment is in my favor because that amendment says that any person can appear himself or through authorized representative. May I just see?
Whatever in terms
As
of
may
law.
be directed. As may be directed.
In
If I
terms
direct
of
to him,
law,
come, he has
whatever
to
you
come.
want you do,
And
but
your
you have to
Lordship-
appear. These are the calling in question summons will not entertain.
Your Lordship, and may I just submit just one circular, Your Lordship. Your Lordship, this is the instruction which is given by the CBIC as to what should happen when summons is issued. Page number 1, para number 2, Your Lordship. There is a guideline which says that officers are, the last 3-4 lines, Your Lordship. Officers are also advised to explore instances when instead of resorting to summons, a letter for requisition of information may suffice. Previously, in respect of legacy laws, the board has sensitized the officer regarding use of power of issuance of summons diligently. However, board finds it necessary to issue fresh guidelines under CGST. Then page number 2, 3-6, Your Lordship. Senior management officials such as CMD, MD, CEO, CFO, similar officers of any company or a PSU.
Now, what's the hitch in appearing?
Your Lordship, the apprehension that we face is, first, before I appear for the summons, I need to know what is it that I'm going to go for summons. One set of statements have already been taken. What the officers will do is, Your Lordship, belage kargbetu ratri tanka they will make them sit.
Correct.
And this is a manner in which they take
is how the investigation
take
goes
the
on.
statements, Your Lordship. Nothing is informed for what purpose a summons is being given. Repeated summons are given. Several documents as and when required that has been.
Like
it's
search
only
and seizure
abuse.
agidiyalla. There is a panchnama drawn. You know what is the allegation against you.
Yes.
Summons is issued for investigation, qua those allegations.
Yes.
What else do you need?
Your Lordship, already Vansati, I have appeared and given my statement.
Investigation ಅಲ್ಲಿ ಮತ್ತೆ ಕರಿಬಾರ್ದು ಅಂತ
Your Lordship, this has again resulted in subsequent proceedings by issuing a DRC 01A.
We will give 100
and the
summons, he has to come to 100
86A.
summons.
Your Lordship, once it has resulted in initiation of assessment proceedings, can the officer still continue with the inquiry against the very
It
same
can,
assessee?
prosecution
No, no,
proceedings is something
It
different.
is investigation, madam. It's not concluded yet.
Your Lordship, now they don't give any, so Your Lordship may
We will not
submit
give at the
this,
time of
that
investigation.
the petitioner
How can
will
we give?
appear. If there is summons, let them do it in accordance with law, let them give reasons and let them not arrest, Your Lordship.
No,
And
that-
let them
that
provide.
Protection cannot be.
Let
That
them provide.
they will decide. In case there is apprehension of that,
Yes.
you can always approach the court.
That may be recorded, Your Lordship. And Your Lordship, they may be directed to give me the copies of whatever has been seized. It is very unfair that they will ask me to
67(5)
produce
bars
a
me.
document.
Investigation, they will conduct in accordance with law.
Yes, Your
It's
Lordship.
not that you get everything at this juncture. They are investigating into it. You appear before
On
them, they will
submission,
take
Lords.
proceedings in accordance with law.
67(5) bars me giving the details to them.
The investigation is investigation.
Is
It's
there-
not that
you should
everything
understand
should
that.
be given to you at the.
Already 6
My
months have
own
gone, my lords.
documents, Your Lordship, what has been seized from me.
That's all it is seized from you.
Yes.
Then
Your Lordship, these are running from accounts from 2017 until 2024.
that's all.
The
Let's see.
books
It's a
accounts.
case of fake invoice. The allegation
Allegedly.
is of fake invoice.
Yes.
All right. They will give you whatever you want
Yes.
for the purpose of your defense.
Oh, my lords, my
Yes,
submission,
that may be noted.
67(5) may be Faruzma's, only one
No,
point.
not that all the documents.
67(5), at the opinion of the officer, as per the law. They cannot seek every documentation. If I.
Correct. That is in accordance with law. The accordance 67(5).
67(5), notes, if you may read. The person from whom the custody of any documents are seized on subsection 2 shall be entitled to make copies thereof extracts at a place and time as the officer may indicate in this behalf, except the making of such copies extracts may in the opinion of the professor
Correct,
prejudicially infect the
which would
investigation.
not prejudicially affect the investigation.
Let them make a application, will
That has already
appropriately.
been done, Your Lordship. I
They will
produced it.
answer it, madam. ನೀವು ಹೋದ್ರೆ ತಾನೇ ಎಲ್ಲ. Sitting somewhere, you are asking everything.
And my lords,
Lordship, if there is an apprehension, then I
You
may be
will-
permitted to
They-
approach that.
That is always there, madam.
they can go to appropriate court
That
in
may be
terms of
recorded,
Radhika
Your
Agarwal
Lordship.
judgment.
Because
The
then,
petitioner is before this court seeking the following prayer. Heard so and so. The petitioner claims to be the managing director of a company against which a search and seizure is conducted by the GST Revenue Intelligence. The seizure happens at the office of the petitioner at Visakhapatnam. Panchnama is drawn by seizing several materials, pursuant to which a summons comes to be issued on 22/11/2024 under section 70 of the Central Goods and Services Tax Act,
Fifth summons.
CGST Act.
Fifth summons.
This fifth.
Fifth
First one ಎಲ್ಲಿದೆ?
ಅಷ್ಟೊಂದು ತುಂಬಾ ಇದೆ, my
The
lords.
learned counsel for the respondent would now add that this was this summons were fifth in line. The petitioner does not appear. Another summons issued to the petitioner to appear at the Bangalore office on 22/1/2025. Even then, the petitioner has not appeared. The petitioner is now wanting to know what is the case against him for him to appear and answer the summons. The learned counsel appearing for the petitioner would stress upon that the petitioner is not aware why he is being summoned repeatedly, while the petitioner does not appear before the officer even once. Therefore, it is for the petitioner to appear before the authority. The learned counsel for the respondent submits that if the petitioner would appear, in terms of law, what the petitioner would need would be furnished with. He would qualify his statement subject to the conditions stipulated under section 67(5) of the Act. Therefore, it is for the petitioner to appear before the authority and answer the summons. The learned counsel for the petitioner submits that he may be taken into custody at the time of appearance, at the time when he appears before the authority on answering the summons. If that be so, it is always open to the petitioner to seek protective orders before the appropriate fora. In that light, keeping all contentions open, I deem it appropriate to direct the petitioner to appear before the Vizag.
Why is it?
before the first respondent and answer the summons.
Particular date may be given.
Answer, how date?
Other non date. 15 days allowed.
Appear before the authority at Vizag on 19th September.
Your Lordship, he's currently traveling, Your Lordship.
He's
Some
been
date
traveling
in-
from 4 months.
Some date in the first week of October, it may be.
No, my lord.
On 22nd max, October Allah, September.
Yes.
On September 22nd at 3 p.m. The
Your
concerned authority shall bear in mind the submissions made by the learned counsel appearing for the petitioner and the respondent and regulate its procedure thereafter. Liberty is reserved to the petitioner to knock at the doors of the appropriate fora in the event of need.
Obliged.
Obliged.
Ordered accordingly.
Obliged.
May please go ahead. Because this petition challenges a set adjustment of refunds for 2 years, namely assessment year 27-28. Sorry, assessment year 2007-8 and assessment year 23-24 against a non-existing demand for assessment year 2013-14. If my lord will first just see the judgment of this honorable court which was passed directing the officer to dispose of to grant me a refund which starts at page 22.
Page 54, 55. The operative portions.
That's right.
Yes, yes.
That's right.
Huh.
Because they were directed to dispose that the order which was sought to be passed was time barred
Yes.
and then directed to give me a refund.
Hmm.
The Lord, just go straight to page 57.
Hmm.
Now you just see the top of page 57.
Hmm.
The details of the petitioner's claim for refund in these petitions are as under. We are concerned with assessment year 7-8, my lords. The petitioner's case for refund as aforementioned is not considered and it must be considered in the light of the exposition in CIT versus Shelley Products Supra. And this court must emphasize that the respondent must consider the question of interest as well as refund. For the foregoing, the following order. The petitions are allowed in part in the impugned notice dated 5th November 2020 and 6th November 2020 are quashed on the ground that they are issued after 31st March 2017, which would be impermissible because of the provisions of section 153(7) of the Act as amended by the Finance Act 2016. The respondents are directed to consider the petitioner's representations dated 29th October 2020 for refund along with interest in light of the decision of the Supreme Court in Shelley Products. The respondent shall consider the representations within a period of 3 months from the date of receipt of a certified copy of this order. But this order was passed on 17th August 23. Ultimately, he passes an order on 27 June 24, whereby he gives effect to this judgment of this honorable court. If my lord will just turn to page 61.
Yes.
Para 2. Consequent to the order of the Honorable High Court, the order giving effect is passed and the income of the SSC company is computed as under and he determines a refund of 60.45 crores. Is my lord got that?
Yes.
Because this was done on my lord's 27 June 24, although he was asked to dispose it off within 3 months. Today, up to date, I have not received the refund as yet. Then what happens is this. Because thereafter, he issues a show cause notice to me seeking to adjust this refund against an outstanding demand. If my lord just sees the notice dated 14th November 2014, which my lord will find at page 118.
That's 18th November 2024.
That's right.
Yes.
Right. It says, kindly note the refund so determined is proposed to be adjusted against the outstanding demand shown in the outstanding demand table below, for which time of 21 days is granted from the date of this intimation. Plus, I filed my reply on 18th November saying
Yes.
that there is no demand outstanding.
Yes.
Right, ma'am? Well, you just see page 119. If you see at page 120, in view of the responses submitted by the SSE as contained in annexure to the SSE.
What happens thereafter?
Well, he ultimately adjusts the refund, which my lord will find is at page 26 December 24 at page 127. 130. Sorry, 130, my lord. I'm sorry. Refund adjusted against an outstanding demand. And he's adjusted it against a demand for assessment year 13-14, which my lord will find at page 131. Your return for assessment year 2007-8 has been processed, accounted for under section 260 on 14 November 24, determining a refund. The said refund is adjusted against the following outstanding demands for assessment year 13-14. Similarly, my lords, for assessment year 23-24 also, an intimation was issued to me determining a refund, which refund has also been adjusted against this demand for 13-14.
When was the demand made?
For 13-14?
No, 2007-8 first.
Right.
When was it made?
2007.
Or 13-14, what was the demand subsisting?
Nothing at that point of time. I'll explain to my lord what happened. In 13-14, an assessment was framed. I went to the tribunal challenging that assessment. The tribunal deleted one addition and gave certain directions to the assessing officer and the transfer pricing officer.
Where do I get that?
To deal with, yes, my lord. See the order of the
page.
Annexure C, my lords.
Page
63. If my lord will first see para 7.7.
No, 13-14, something was subsisting or not?
Nothing. The matter had been, there was no demand subsisting.
After the order of the tribunal, what happened?
He didn't give effect to it.
Even the order of the tribunal is not given effect to.
So therefore it had become barred by limitation.
Not taken it forward also.
Subsequent, my lords, I must point out to my lords.
What is the date of the order of the tribunal? 2017?
2022.
Page?
It was 5/4/22.
5/4/22.
Page 63. He purported to give effect to it, but those proceedings also have become time barred.
Under 153(7)?
Not 153(7), because 153(7) pertained to orders of the tribunal before 16, before the amendment was made.
All right.
So
now
what happens now, therefore, when he makes the adjustment, there is no demand outstanding. Now, if there is no demand outstanding, how can you adjust it? Once the tribunal sets aside an addition, there is no demand.
Yes, sir. Inadvertent mistake by saying that there is adjustment of a demand. There was no demand. That's all. The petitioner, all three cases?
No, my lords, the first one only. The other two are challenging something else. Are challenging the proceedings taken to
why are they tagged? Why are they tagged?
Because, my lords, what happened is
same SSC, but issue is different.
Right, man. The issue is whether the proceedings are barred by limitation for 13-14 and 14-15.
The petitioner is before this court seeking a direction to the respondents to refund an amount of so and so other pursuant to the order dated 27/6/2024. Heard so and so. The history to the case need not be gone into, as this very petitioner was before this court in writ petition 13953 and connected cases, which comes to be disposed in terms of an order of the coordinate bench dated 17th August 2023. Therefore, I deem it appropriate to paraphrase what is observed by the coordinate bench while issuing certain directions. The coordinate bench has held as follows. Page 23 in the come to the reason part. Page 37 to 55. The coordinate bench directed the respondents to consider the petitioner's representations dated 29/10/2020 and others so submitted to the respondent and consider refund in terms of the judgment of the apex court in the case of CIT versus Shelley Products. What comes about is a notice to the petitioner by the revenue on seeking to set off or adjust towards the liability of towards the demand that was subsisting for the period assessment years 2013-14. The learned counsel appearing for the petitioner, learned senior counsel representing the petitioner, would contend that those demands that were subsisting for the year 2013, assessment year 2013-14, had stood obliterated insofar as one demand was concerned, and the others, the tribunal had issued certain directions. The directions were not taken forward. Therefore, those liberty that was granted by the tribunal today has become time barred. Therefore, as on today, there is no demand or subsisting for the year 2013-14. Notwithstanding the same, the revenue appears to have set up the revenue appears to have adjusted the refund that is to be made to the petitioner on the imaginary or illusory demand, that is illusory subsistence of a demand of the year assessment year 2013-14. The learned counsel appearing for the respondent revenue YV Raviraj is not able to place reliance on any document of subsisting demand for the year 2013-14. Therefore, the action of adjusting the demand, adjusting the refund towards the demand that was subsisting, that is said to have been subsisting of the year 2013-14, is on the face of it erroneous. The face of it erroneous. If it be erroneous, the petition deserves to succeed, as the petitioner is already armed with an order of the coordinate bench on determination that the petitioner was entitled to a refund, but only directed consideration of a representation. The consideration of a representation has led the petitioner back to the doors of this court on the aforesaid score. In the light of the aforesaid reasons, the petition deserves to succeed, with the prayer sought to be granted. The respondent shall now process the refund pursuant to what 27/6 order, which is that?
Manoj, that the 26th December 24.
No, 20. You come to your prayer.
Yes, Manoj. Manoj, 1 and 2 have to be granted. Page number 18.
1 and 2.
Amended petition, Manoj.
Sorry.
As I said, there were 2 years, 7/8 and 23/24.
Therefore, the petitioner, which is the order annexure M, is it? Therefore, the order at annexure M dated 30th January 2025 is set aside.
So both, my lords.
Annexure H and R.
Sorry, H and R have
Adjusting
to be set
refunds.
aside.
Yes. The orders impugned, I don't know, page 6. Orders impugned stand obliterated. The petitioner thus is entitled to the refund that was sought for in terms of annexure B. B dated 26/7/2024.
And annexure M.
Refund shall,
And annexure M. B and M, my lords, there are two assessments.
B and M, all right.
Along
B
with
and M,
interest.
applicable interest,
Because they have given me interest only up to 24.
obviously. Applicable interest. Cost, the petitioner is thus entitled to refund of the amount as sought for in terms of annexure B and annexure M, ಅದು date ಹಾಕ್ಬಿಡಿ. So along with applicable interest. Yes.
Then the next petition.
These two will take it in preliminary hearing.
Where?
If the issue is different. Yes, list these on 11th in preliminary hearing.
Interim order to be extended.
Interim order subsisting would continue to the next date of hearing.
Is that okay?
Till number 6.
Lord, the state GST initiated proceedings for evasion of Lord's tax by issuance of show cause notice, and thereafter there was adjudication. May I request Lordships to permit me to refer to annexure E, page 47. If Lordships are to see annexure E, page 47.
Yes, sir.
This is for the assessment year 2021, 21, 22, 22, 23. Lordships get that at page 47.
Yes.
There is a tabular column annexure.
Yes, sir. You heard it.
Tax modes to the extent of 49 crores 34 lakhs 49,928 was determined. There are some proceedings still pending against this. But if required, I'll take Lordships to in detail.
Now, what is the challenge?
Now,
The
Lords,
complaint.
what the central GST does is, on the same, for the same assessment years, even without a notice, etc., they arrest the petitioner. They arrest the petitioner for the restating that the investigation is in respect of the same thing. May I request Lordships to kindly see page
So you have sought for holding the arrest to be illegal one.
Not only arrest, the second Lord parallel proceedings is hit by section 6(2)(b). Lordships are aware.
Parallel proceedings, you know.
So in respect of the same assessment years, but proceedings initiated, concluded, tax paid by the states, initiated by the state GST. Now central GST has initiated for the same.
State will close agidiyalla.
Close agid. We have paid the tax. So, page 76, I may just point. I'll just say something else beyond this.
76.
This is the central GST application for remand, but there is no notice issued by them, etc. Only an arrest. In the arrest remand application, they state for what year they are trying to investigate. 76 Lordships get. This is a part of their remand application. Or ivattinavarigu notice issue madilla. Page 76, Lordships kindly see the tabular column. 19, 20, same period. But I want to make this submission before your Lordships. Now, the statement of objections now they have filed, but I'll just point out something else. In that application for remand, their understanding of the law, kindly see page 71.
71?
What the central GST says.
Yes.
At the outset, it is humbly submitted that the provisions of central GST and Karnataka GST are in perimetry and have the same provisions like matter and differ from each other only on a few specific provisions. Therefore, unless so and so, this is their understanding. Now, in the statement of objections, they are saying, though the state has concluded assessment, etc., there are certain aspects which has not been gone into by the state GST. Therefore, we'll reinvestigate. And Lord, I have this statement to be made before your Lordships with all the humility. This central GST could never have behaved in this manner. That too, not going and arresting a person. But I can understand a notice being issued. I would have replied saying that state GST has concluded. Till today, Lord, no notice is issued. Arrest, Lord, they have taken me into custody. Then on an application for the remand for the first time, they say it is for those years. Of course, Lord, thereafter, after spending some time in the jail, he has been released on bail. So this is essentially 6(2)(b), Lord, it is hit by 6(2).
What is 6(2)(b)?
Of the.
Madam.
Parallel proceedings. I'm told lordships have similar matters. Lordships have. This is what mine. This is what
One.
Let's see. Section 6(2)(b) of the state GST.
Proper officer.
Lord, that is parallel proceedings is not permissible.
6(2)(b) ಯಾವ್ದ್ರಲ್ಲಿ? CGST?
Yes. Lord, 6(2)(b) lordships here. Where a proper officer on the State Goods and Sales Tax Act or the Union Territory Goods and Sales Tax has initiated any proceedings.
No
on a
proceeding shall be initiated by proper officer under CGST.
on the same subject.
SGST ಆಗಿದ್ರೆ CGST ಬರಲ್ಲ.
That is the claim lot which has been advanced.
I think SLM stationery ಅಂತ I went.
Lordships have.
ಧಾರವಾಡದಲ್ಲಿ.
Yes.
Yes.
I was told lordships have help.
Both of you have jurisdiction.
If my learned friend is courteous enough to hand over.
SLP.
Great.
Supreme Court.
Lord, sir, to the facts of the case, Lord, the first may kindly come to page number of their petition. 33. The show cause notice which is given by the state. This is the show cause notice being given by the state GST on 27/11/2024. Show cause notice.
What happens after
My lord,
this?
this is given by commercial tax audit 1.8. And my lords may kindly see the summary of the notice there. That is very important for my case.
Page
33 of their petition.
Summary of the show cause. Yes.
Restriction of ITC as per the provisions of 16(2). Difference in outward taxable supply between GSTR 3B and P&L account. Current liabilities at so and so. Now, my lords, this is for the period 2021. Now, my lords, kindly come to page number 17, page number 41.
Yes.
This is also for this is the order, adjudication order passed by commercial taxes audit 1.8. And they pass an order on the same issue.
Adjudication under 73(9).
73. Adjudication is a 73.
73 KGST and CGST.
KGST.
Hello. Yes.
KGST act ಮಾಡಬೇಕು ಅವರು.
ಆಯ್ತು.
Now, my lords.
CGST is also collected in.
Now, my lords, page number 47. This is DRC 01A. This is pre-show cause notice. This is issued by the same state government's enforcement wing again. Now, my lords, page number 52. This is the show cause notice issued by enforcement again on 28/11/2024 for 3 periods: 2021, 22, 23, 23, 24. However, adjudication order, again they pass an order on page number 59. Mm. 27/2/2025. They pass an order only for 1 year, 2021. I don't know how they given 2, but that's the fact. However, I did my intelligence action. This is based on an audit action because they are assigned to state government. So they go, they see the books and they have given 73 notice. They are given 2 notice, whether bad or right or wrong, that is up to them to decide. However, when I am concerned from the point of view of the central government, now, my lords, I do a search on 25/10/2024. Thereafterwards, I arrest him based on several documentation because my issue is based on 2 issues. One is fake invoice issue. Second is money collected, not paid. So that comes to around 100 crores. So therefore, my intelligence action issues are separate and distinct to that of their issues.
All right. What investigation have you done till now?
We have investigated and we have identified and we have told that they have to pay around 116 crores. Now, my lords, in furtherance of our investigation, we arrested, we took statements, we seized, everything has happened in our intelligence action. We filed a prosecution complaint also. And the prosecution complaint is going on. That is also been stayed because of this High Court order. Apart from that, I also file a cancellation of bail because he has got a default bail. That has also been struck. And now we give an issue of summons for my adjudication order. Because at this stage, I have to give summons to elicit information from him to pass an adjudication order. At this point of time, a stay has been taken. In similar cases of that sort, summons is given, he has to come and answer. In fact, Supreme Court also tells in the same very judgment that in case of a parallel judgment and parallel investigation, similarly as that of mine, the facts in case of armed security also, Supreme Court has told, go answer to the summons. Go answer to the summons. If they feel right, if they issue notice, you can come under 226 later. Because an enforcement action cannot be equated to an audit action. Audit ಏನು ಮಾಡ್ತಾರೆ 73 ನಲ್ಲಿ ಬರೀ books ನೋಡ್ತಾರೆ ಅಷ್ಟೇನೆ. They have distinguished between GSTR 3B returns and financials, whereas my investigation encompasses everything: fraud, suppression, identification of documents, secrecy of documents, ಎಲ್ಲಾನು ನಾವು ತೆಗೆದಿದ್ದೀವಿ. So therefore, I am still eligible to issue under 74 notice in terms of the Supreme Court order. If they feel later that my show cause notice overlaps their notice, in such a case, they are at liberty to come later, is what the Supreme Court has told. So at this point of time, when I have sought a summons and asked him to come and give information, the least thing he has to do is to come and give the information.
Does the apex court consider parallel proceedings?
Yes, they have.
Kindly see subject to what, Malan? Page 64, clause F
of
this judgment. In that very judgment, their lordships in fact squarely say this clause F, not page 64. However, if the central or the state tax authority, as the case may be, finds that the matter being inquired into or investigated by it is already the subject matter of inquiry or investigation by another authority, both authorities shall decide inter se which of them shall continue with the inquiry or investigation. In such a scenario, the other authority shall duly forward all material information relating to its inquiry, investigation.
State al mugudogidiyalla.
Mugudogide. Not only that, not kindly see. Then further lordships may kindly see. G. However, where the authorities are unable to reach a decision as to which of them shall continue with the inquiry or investigation, then in such circumstance, the authority that first initiated the inquiry and investigation shall be empowered to carry on to its logical conclusion.
Now,
the courts
are both the proceedings similar?
Certainly, but I wanted to make the distinction before. But this is not an essentially a penal statute. Lordships may have to now interpret in the light of my learned friend's submission. This is not a penal statute. This is more like essentially a fiscal statute incorporating certain provisions for recovery of the fiscal evasion. The tenor of my learned friend's argument seems to be, I will only prosecute, you collect, state. No, that is not the way. They are intrinsically interlinked with each other. The state GST, in fact, not authority found, they in fact specifically made an allegation that you have taken input tax credit without any documents and have not paid to the state government. Specific allegation. Then they found, since you do not have documents, we impose penalty and collected tax. Now they could have also initiated proceedings, criminal proceedings against me under section 132 state. It is not an exclusive privilege of the central GST. State also could have done. They chose not to do so after that. Now state GST, central GST cannot say that insofar recovery proceedings are concerned, let state GST do. I will do 138 proceedings. That is not the intent of the act at all. The intent of the act, Lords, is once.
What was the penalty imposed by the state?
About 46 crores.
Now we have determined 100 crores, is it?
We have
our total determination is around 116 crores.
46 crores plus 80 to 87.
The legal issue will answer whether.
I'll point out before your lordships. But this would lead to a very gross situation where state goes on complete annual proceedings under 130 to 133 is not a standalone proceedings for criminal proceedings. They are intrinsically linked to the tax evasion, the recovery proceedings. One authority cannot say I will initiate tax recovery. Another authority under the act cannot say I will initiate criminal proceedings. That is something that I may submit.
My lords,
And the judgment note of which my learned friend cites, in fact, covers that situation.
Lordship, in GST as well as.
And my lord, I'm sorry. And my lord, it was according to me, the manner in which, my lord, they have gone about, I'm quite surprised. When, was it not necessary for them to ascertain, at least from the state authorities, as to what is the kind of investigation you have conducted? How many years you have assessed? Nothing has been done. Straight away you go and arrest, take away the liberty of an individual. It's not that it is for something that happened for the year 21, 1920, in the year 24. So therefore, that also has been questioned before.
Right. Yes, Madhu.
Lordship, when we made a search on in November 2024, we were not aware of this at all. In fact, other way around, he must have come.
So your proceedings triggered on account of a search.
Account of an intelligence. Saying that there is a
intelligence
fake
input that led to search,
Yes.
led
And there
to
are two issues.
discovery of many things,
Yeah.
and you began proceedings.
Exactly. My lord, there are two.
But does that overlap with the
No.
proceeding years of whatever penalty
I'll
that
come
you
to
want
that.
to
I'll come to
impose?
that. That's answered in the Supreme
If there
Court
is
judgment.
overlapping, then what?
I'll come to that. My lords, our issue is with regard to two aspects. One is fake issue of invoices. Second is amount collected not deposited to the extent of 100 crores. Now the point is, if my lords were to, that's why I just pointed out one aspect of this in page number 36, my lords, if kindly, that says page number 33, their issue is something different. They have only audited the books and told there is a difference between GSTR 3B returns and financials, they ended it. And therefore the issue on notice
When
under
section
7.
6
If I make submission.
Submission.
So therefore, their assessment is only based on books. Therefore, the Supreme Court has told, if it is an assessment based on the books, that is only under 73, where is the question of prosecution they're launching? I go, I search, I get the information, I seize, I raid, I get the information, and then I get to know, yes, these are all the things. Therefore, I'm constrained, I'm compelled to raise 74, and upon, if I arrest, in terms of BNSS, my lords, I'm constrained to file a prosecution complaint within 60 days. Therefore, I filed a prosecution complaint. And
where is that?
Well, that has been filed before the
Court.
Economic Offence Court.
Economic offense.
Economic
That is
Offence
stayed.
Court. That stayed because of this order. That is a proceeding. That is stayed.
No, which has been, we have not been.
That is stayed. They went there and represented and told it. The High Court has given an order, so therefore there is a stay on that. And upon that, my lords, Supreme Court in Ashok Kumar versus Commissioner specifically held prosecution proceedings is something different to that of adjudication proceedings. Now I can issue a show cause notice for issuance of recovery. Apart from that, I can also file a prosecution. Now I go 2 notches ahead. I make investigation. I file prosecution complaint within 60 days because he was arrested and he got a default bail. I go to the Sessions Court for cancellation. At that point of time, a petition has been filed, and this order has been given on two places, and that is also stayed. My investigation is also stayed because summons I asked for him to come. Now the issue is, let him come and say yes, and during this period he has not even told that state is investigating the matter. If had I been told, I would have communicated to the state authorities in terms of the Supreme Court judgment. Therefore, Supreme Court says, in case if there is an issue like this, if there's an enforcement based action, that should be taken to a logical conclusion irrespective of a state action under 73 is what the Supreme Court has told in the armed security case. Therefore, at this point of time, let him come, answer at the stage of summons. Let him come and answer. If need be, we will see. If at all we issue notice, my lords, kindly see the judgment of this honorable the Supreme Court at page number 61. Now, my lords, they have given the scenarios under which what should be done. Senior was talking about F on page number 64. That should,
because Professor, this 62A itself is interpreted here.
62A and 62B,
both 62AB, both are interpreted
But
here.
it is now,
and conclusions are drawn as to what is to be done.
correct. I will show before you, Lord. Lord, this is ultimately based on Article 20 subclause 2.
Nimdi Vidya Raghuman, sir.
Please do not disturb. Please, I'm making my submission. Don't have. Ultimately based on a constitutional provision of Article 20 on the principle of Jabal Jeopardy. Ultimately, It's also based on double jeopardy. And my lord, this interlinking of GST proceeding, the criminal proceedings, penalty proceedings, and the assessment proceedings cannot, no, that is disjunctive. It has to be read along with that. That is what I will interpret before your lordships. But the submission seems to be that even if assessment proceedings by the state authorities is complete and over, I can parallelly initiate criminal proceedings, but that would be something impermissible having regard to the language of 132. I will show before you.
Yes. 132.
132 is the provisions for initiation of criminal proceedings
Of
central GST. What they intend to do now is whoever commits any of the following offenses, namely, let's say subclause B, issues any invoice or bill without supply of goods or services, or both in violation of the provisions of the Act or the rules made thereunder, leading to wrongful availment or utilization of input tax credit or refund. This is the penal provision under which now they say prosecution complaint can be filed. Now, what would fall for lordship's consideration would be, now if the assessment proceedings have been initiated by one authority and taken to its logical conclusion, and assessment is made complete, and penalty is imposed, and that authority chooses not to go ahead with file a complaint or arrest or take any coercive measures, would another authority, my lords, would take a different route is a question, Lord, which my lords may have to decide. But according to me, the concept of estoppel by conduct, my lord, insofar an authority is concerned, may apply, my lord, having regard to the provisions of the Act.
We'll see. I'll dictate on 11th. We'll list it on.
But I would also make, if lordships have some more time, I'll make further submissions on that day.
No, 11th will have.
Please.
For further hearing.
Yes. List on 11th at 3:30
My
PM.
only submission, my lords, this judgment, my lords, it will give a clarity on the aspect of.
I'll also go through
Please.
it. Yes. Because this has ramifications.
Certainly, but I'll.
Not that we can straight away close it by saying you appear, because there's a legal question involved.
No, but lordships may have to decide as to where we. Issue of
This
jurisdiction.
is not decided by this court.
No. The parallel proceedings, 6-2, there have been 2 or 3 decisions.
Adu kottpidiyalla.
No, but then
compilation.
This is post armor security.
Yaudu.
This is post Supreme Court judgment.
But now,
facts remains.
I will interpret, but now the word subject matter as it appears under 6-2B, can it, my lords, involve, as my learned friend says, one subject matter does not involve just assessment periods, but different shades of assessment. It can't be like that. Subject matter.
Anyway, you are protected by coordinate benches interim.
11th, lords could consider having it in the afternoon, 2:30. So
3:30.
3:30.
3:30 for the hearing.
Please.
Yes.
But that interim order is limited till today.
That continues. That will continue.
7.
A week's time is granted to comply with the office objections.
8.
Interim order continue.
8 is 7.
7 nimdera.
7. This is what we are seeking, but dispensation of
So there is an interim order?
No, for the no,
First
there is
time.
no interim order. There is no interim order. But the
compliance by then, it's been pending. Yes. Yes, sir.
Dispute falls, my lords, according to me, in a very short compass.
Yes, Arvind.
My lord, this is a matter where the petitioner has asked for waiver of pre-deposit before this estate, my lord. My lord, there was a amendment in 2014.
Yes, sir.
But according to us, of course, there are at least series of decisions which lordships are aware that.
Then we'll take it on 11th in preliminary hearing.
Please.
Yes, list the matter on 11th in preliminary hearing.
There are few
office objections.
Will comply. There are
office objections we complied with by then. Yes, sir.
There are about 3 decisions, lords, on the jurisdiction of Article 226 to dispense with the pre-deposit, if lords are aware. To dispense with the pre-deposit.
That will see.
Yes, all of no. I'll just make a compliance. And there is also.
When the court Petra will.
Therefore,
yes.
After serving a copy to my learned friend, I'll serve. In fact, it is here. Not. I'll just copy. And Lord, there is. I am also relying upon.
I'll
certain
look into it. On 11th we'll pass.
Lord, sir, I'm sorry. The office objections relates to better copies of FTA certificates and
Oh,
C.
overruled, yes,
We are
overruled Monday. Sorry, on 11th.
Yes, please.
8.
Is it for the first time, alva, sir?
No, this is
Birthday
not-
is first time, alva. Then we'll take it on Monday.
I am appearing no,
On Monday.
Tuesday.
And if you're not there on Monday, then Thursday.
Yes.
Two sets of papers.
Number 8 may seeks for a week's accommodation.
Interim order there? You have an interim order and you have not complied with
And I've been instructed
the
that we
petitioner
comply.
seeks a week's time to do the needful. Interim order subsisting would continue to the next date of hearing.
So, income tax return ಮೇಲೆ service tax.
ತೀರ್ಮಾನ ಮಾಡೋದು ಬೇಡವಾ?
Manoj, I'm appearing on behalf of the advocate on record.
It can go back, yes, following that judgment.
I don't have instructions and all.
I list on 11th in preliminary hearing. Next.
9.
Your Lordship, counsel appearing for the petitioner, kindly adjourn the matter for 2 weeks.
Oh, thank you. Yes. A week's time is granted to do the needful. Yes, next.
10.
My Lord, I appear for the petitioner in item 10. Lord, here the office objection, we already served you on the other side. There's a counter also on record. Lord, it's a very short issue about grant of the statutory interest on the duty paid under protest. Lord, the refund has been granted to me, but the statutory interest is not given to me. That is my short grievance. And Lord, this interest is governed by section 11BB of the Central Excise Act.
Yes.
My Lord, the instructions
Interest
are that
and delayed.
interest, my Lord, on the basis
Delayed
of the
refund
sestat
interest.
order, the adjudicating authority has passed an order for granting refund.
Correct.
However,
Other than
the
interest ಬೇಡವಾ?
interest portion, let there be a court order.
Applicable interest.
My instructions are
Statutory
that
interest, my Lordship, may say statutory interest.
Statutory interest,
that
correct.
interest
Yes.
portion, there is no provision to give them, so let there be a court
Refund,
order.
ಎಲ್ಲ refund interest ಬರಲೇಬೇಕು. The
Lord,
petitioner
Difference with-
is
Lord,
before
only-
this court seeking the following prayer. The issue in the list, the issue in the list revolves around a narrow compass as projected before this court, as the petitioner is claiming interest on the refund that is ordered by the respondent number 3. The petition in central tax,
Central tax.
My Lord, Central Excise.
the third respondent in terms of the order dated 11/3/2025 allows the claim of the SSC directs refund by the following order. Page 48, 49. The refund is 10 crore 60 lakh 3,444. In the order, there is no interest granted for refund. How many years is it?
Lord, 10 years, because
Stemming from the
15th
date
of
of the
September.
application, that is from 2014,
Statutory, whatever, yes.
in accordance with the order.
Correct, yes.
Lord, from 15th September.
It is an admitted fact that the order of refund is not challenged by the respondent, but the only issue that is brought as observed here and above is with regard to grant of interest on the said refund. The prayer of the petitioner merits acceptance with a direction to the respondent directing the respondent to pay interest on the amount refunded in accordance with law, as is applicable in law in cases of the kind of refund. Within
8 weeks.
Within 12 weeks,
Please.
the interest shall be calculated and paid to the petitioner within 12 weeks from the date of receipt of the copy of the order.
Lord, only one request, that my refund application is dated 15th September 2014. So Lordship may only add
In
one
terms of
line.
law,
No,
in
but the
terms of
refund
law.
no, that law, but correct. In terms of fact, my refund application is 15th September
ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ.
2014.
ಅದಕ್ಕೆ ಮುಂಚೆ ಟ್ರೈಬ್ಯುನಲ್ ಆರ್ಡರ್ ಮುಂಚೆ the refund application of the petitioner was placed before the authority on Date
15 September 2014.
15/9/2015.
14.
At 15/9/2014, the denial of which led the petitioner before the tribunal, appeals.
Lordship, yes.
Led the petitioner before the
Tribunal.
Before the tribunal. The tribunal allows the claim of the petitioner by directing refund in terms of the following order. By directing refund, but fails to order interest, and therefore the petitioner is before this court. The tribunal holds as follows. The petitioner is thus becomes entitled to.
Tribunal directs the adjudicating authority to
grant the
consider
refund.
To refund. Adjudicator passes an order, but interest is not given.
The tribunal accepts the claim of the petitioner assessee and determines that the petitioner is entitled to refund, and directs the adjudicating officer to to calculate the refund and pass necessary orders. The adjudicating officer passes necessary orders in terms of the order of the tribunal, but fails to grant interest. In the light of the refund. In the light of the refund being granted in terms of the order of the tribunal by the adjudicating officer, the petitioner would definitely become entitled to the interest on such refund as is available in law from the date he registered his claim for refund. Yes.
Grateful, Lord. Deeply obliged.
11.
Wait for 2 weeks time to needful money.
Learned counsel and HCGP seeks 2 weeks time to file statement of objections. Objections, if any. List on 25th. Saka.
12.
After vacation. All right. List after 4 weeks. Yes. Objections, if any, by the next.
12.
Please, my lords. I'm appearing in serial number 13, my lords, for the petitioner.
It's 12 or 13, madam? 12. No representation. 2 weeks time is granted to do the needful. Next. The petitioner to serve set of papers upon the learned HCGP forthwith. 12, 13.
13.
Please, my lords. I'm appearing in for the petitioner in serial number 13, my lords. This is a petition which is filed by the Customs House agent.
Where is the acknowledgement, sir, of service?
My lords, my learned friend is present in the court, my lords. We have served the respondents.
To whom?
The acknowledgement is there.
Jivan Kotidira. Counsel for the petitioner submits that the copies of the petition have been served upon the counsel Jivan Neralki. Place the matter on 11th.
My lords, just one request, my lords. This matter, and we have already filed an appeal before the Commissioner Appeals.
This is with regard to a pre-deposit. They are seeking an.
We'll take it on 11th.
Please.
Yes.
My lords, may I request for interim relief, my lords?
11th will grant. 11th will grant. Yes.
Okay, what is the interim? Pre-deposit.
Pre-deposital interim relief.
Allah, Sestat should not dismiss the appeal.
No, my lords, this is not for Sistat. This is for Commissioner Appeals, my lords.
Ah, fine. Yes. Party in person.
My lord, I am partner to the party in person.
Ah.
Party in person has undergone a vascular surgery and he has been advised a minimum.
Last time there
was an infection, but surgery has been conducted. I have brought the medical reports also.
All right. The party in person is said to be indisposed. Therefore, once he gets well, a memo will be moved before the court seeking listing of the matter.
My lord, in the meantime, we have prepared the interlocutory application.
Can
it be submitted?
You can't appear for the party in person. There is no system like that. Yes.
15.
My lords, office objections have been complied with. Registry may be directed.
Yes, Jivan.
Interim order has been granted, my lords.
List the matter after 2 weeks. Interim order subsisting will continue to the next date of hearing.
Same issue, my lords, we have impugned the notification. It's sub judice before the Honorable Supreme Court as well as the division.
Interim order I have extended, sir. Yes.
This demand is based on income tax returns, my lord, service tax. It's covered by this court's orders.
Covered by?
Covered by this
Chinmaya
court's order.
Chinmaya.
Chinmaya Seva Trust.
Remanding the matters to
ಅದು
the
ಕೊಟ್ಬಿಡಿ ಒಂದು ಚಿನ್ಮಯ ಸೇವಾ ಟ್ರಸ್ಟ್. ಮತ್ತೆ ಚೇಂಬರ್ ಎಲ್ಲ ಹುಡುಕ್ಬೇಕದು. ಹಾ, ಚೇತನ್. Yes.
This my lords have up to weeks. Pleadings.
17. Rest after 2 weeks. Interim order there.
ಇದೆ.
Interim order subsisting will continue to the next date of hearing.
That hearing 18.
My lords, we have served all the respondents, that is 26 to 43 through email. Here's the acknowledgement, my lords.
26 to 43.
Yes, my lords. Excuse me, ma'am.
Oh, this matter, yes. Yesterday there was one more matter, I guess.
My lords, it's on the similar lines. It's on the similar lines, my lords.
Yes, sir.
Lord, whether the earlier judgment is applicable, because now they are asking a difference between the, this is not a pre-GST and post-GST, my lord. These are all subsequent to the GST, introduction of the GST. Whence the earlier judgment is applicable or not. According to me, my lord,
Let all of them come, we'll fix a date.
My lords,
Yes.
I could make a kind submission. If you could, my lords, kindly refer to page number 121 of the petition. It's the 9721 order, Chandrasekharia's order.
Yes.
Paragraph 18. So, my lords, it clearly states that the tax component is an independent component of the cost. Now, it covers 4 aspects of contracts, my lords. Para 18, the second last line, my lords. It starts from there. So, there are 4 categories.
That is page
Contracts-
124, is it?
121, my lords.
121, one moment.
Paragraph 18, second last line, my lords. My lords, there
Yes.
are 4 categories of contracts which are covered under this umbrella foundation, that is, contracts pre-GST which have been entered pre-GST and payments have been made post-GST. Second classification is contracts which has been entered pre-GST, partly executed pre-GST, partly executed post-GST. Third classification is contracts invited pre-GST, finalized post-GST. Fourth classification is contract invited pre-GST on old schedule of rates, finalized post-GST. My lords, all the possible 4 categories have been covered under 9721 order. Following with, if let's say contracts been entered post-GST, payments have been received post-GST, so it will be hit by section 13 of the GST Act, which is time of supply. That is when the invoice is raised, when the payment is made, and when the service is received. Either of the cases, my lords, it is them, the employers, who are bound in under the Act to pay us the differential GST, my lord. This aspect has been covered in the
Page 124.
yes, my lords, in Justice Magdum's order, page 126, my lords, paragraph number 5. It clarifies on that aspect.
You have completed your work before the GST?
It's a combination, my lords.
It's a
We
combination.
have it's been entered pre-GST, finalized post-GST, payment received post-GST, worked out in post-GST period. So it's a mixed bag, my lords. However, it's covered under 9721 of 2019. Squarely
Yes,
covered.
sir.
Lord, the issue is now if the.
Now there is only, how many petitioners are here? There are about 9 petitioners. All of them are civil contractors?
Yes, my lords.
When was the contract entered into?
My lords,
Or
they're all
executed the
different
work?
Subsequent to the introduction of the GST.
All right.
According to, because they have not produced the tender copies, not the agreement copies.
My
Last
lords,
time,
to
Mother,
that
where
point,
are-
Last time your lordship.
my lords, to that point, I have an answer to that as well. All these tenders are as per the KW4 tender agreements, my lords. According to that, it is standard format as per which it's just to simplify the thing. And my lords,
Show me one, where is it? Where is, you give me an illustration of the contract.
my lords, page 39 onwards, we have produced the agreements.
These are the contracts.
The agreements, my lords, along with the work orders.
They are dated 4/10/2017. GST is 1/4/2017.
17/2017.
17?
2017.
2017, correct, yes.
My lords, I mentioned, right, some of them are on old schedule of rates. And they have been finalized post GST. There are certain contracts which are on the schedule rates of 2014-15. My lords, if you could kindly refer page 37.
Where do you get those 4 classifications? You
Paragraph
said
18,
18
page
at
number
page
121.
121. Now this is what order?
My lords, I have one odd judgment
One
also
moment,
to produce.
One moment. This is coordinate benches order.
Yes, my lords.
Yes, sir. It should go by this only.
My lords, I have one more judgment to produce before this court.
Some contract. They have not produced our contract. They are general categories have been mentioned.
Whatever, these categories, what the coordinate bench has held in terms of that, the refund should be processed.
My lord, now your lordship may see.
I am not going to assess contract by contract here.
My lords, page number 12.
If these classifications at page 100 and para 18 is looked into, the petition, all the petitioner's case would come within that. There can be no doubt about that.
I will not argue the case of fresh merits, and I cannot do it.
Yes.
My only submission was against the order passed in Chandrasekhar's case, matter is pending in appeal, there is no stay order.
There is no stay.
However, my lords, each and every contract will have to be looked into. Here, my friend, my lords, makes nearly 78-80 respondents and different executive engineers, different authorities, BBMP. This is a contract entered into with the BBMP. Then there is
Davangere Smart City.
There is Davangere Smart City, different contractor. How do I verify, my lords, without, even if I call up the respondent, ask him for assistance in the matter, which contract do I?
No, you should consider it on the 4 conditions that are laid down by the coordinate bench. Each contract you will have to assess for refund.
My lords,
That
one
doesn't
last
mean you should
leg
not
of
do your
argument.
duty by producing
My lords,
all the
when-
contracts. Last time I told you.
My lords, when we made the representations to them, they had the very good opportunity to ask us for the same, right, my lords?
No, don't
It's
worry,
not-
court is asking now.
My lords,
Yes.
we are not denying to that, my lords, but the only fact that when we have made the representations, it has been overlooked, my lords. And my lords, my last submission would be like judgment, my lords, I just produced right now.
I saw it, yes.
My lords, 64A of the Sales of Goods Act, page number 12, para 8. If such an imposition or increase so takes effect that the tax or increased tax, as the case may be, or any part of such tax is paid or is payable, the seller may add so much to the contract price as will be equivalent to the amount paid or payable in respect of such tax or
No,
increase
anyway,
of tax.
let all the respondents come.
Your lordship may see page number
We
65.
can't decide without others. Now you have served them by mail, we'll see. Yes.
My lord, now what happened, my lord? The rate of tax was 12%. It was increased
At
in
least you should
2012.
give a chart of the contracts, dates of entering into those contracts, whether it's old schedule, new schedule, something you should do.
Kindly, my lords,
Yes.
will do the need.
Bless the matter.
Their
2
own
weeks.
document, my lords,
Was that-
65.
Madly bidiya.
Looking only for difference of
6%, my lord.
of GST amount.
Now it was
They say
12%.
It was 18%
12%.
for a particular period of time. Now, now it is
Yes.
12%. A difference amount you make good.
We'll take it after 2 weeks. Yes, next. Next.
Date for lords.
Senior is appearing online.
May it please your lordships.
Is
Yes,
appearing
sir.
online.
Lordships.
This petition challenges the rejection of the claim for refund, my lords.
Yes.
Down that it is time barred. Actually, in this case, what had happened, my lords, lordships are aware, CGST and SGST local tax is payable on intrastate supplies. On interstate supplies, IGST is payable. So in case you pay local tax where IGST is payable, or you pay IGST where local tax is payable, the Act provides saying that you please correct it. It's a matter of only apportionment, my lords. It's a matter of only apportionment instead
Yes,
of
Arvind, you
local
want to file
tax.
objections?
No, I have not filed objection, my lord. Here, the petitioner is asking for a remand.
Refund.
No, refund, but he's asking for a remand on.
Remand for what?
That he could not at.
No, prior D is for refund.
Then I'll file objections.
Yes. Learned Counsel Arvind Chavan seeks 2 weeks time to file statement of objections. List the matter on 25th. Objections, if any, by then.
Please, obligation.
Next.
20.
This is an IA for provisional release of the goods.
Matters are on 9th, my lord. Reconnect matters, my lord is hearing.
Oh, those matters.
Adal jotege.
We'll list it on 9th. 9th? 9th ಹಾಕಿದ್ದೀನಾ?
9th.
No, nice. List on 9th.
21.
My lord, appearing on behalf of the petitioners, my lord.
Learned Counsel for the respondent seeks 2 weeks time to file statement of objections. List up. Post vacation. 4 weeks time. Yes. List after 4 weeks. Next.
My lord, any date may be given, my lord.
After 4 weeks, illa, sir. Yes.
22.
Next.
Please.
Lordship, this petition against the rejection of the Vivad Vishwas scheme 2024, your lordship.
Why?
Lordship, there's a rejection because the matter was heard by the tribunal, your lordship. The part of the, there are two issues. One issue was dismissed against me. The another issue was set aside before the AO for fresh examination, your lordship, where the demand still lies and the demand was not vacated, your lordship. Against that, I have filed a Vivad Vishwas scheme which was rejected by AO, saying that there is no appeal pending, so application cannot be entertained.
So Vivad se Vishwa,
Vivad se Vishwas scheme of
Vivad se
2024.
only when appeal is pending, is it?
A specified date is given, my lord. Specified date is 22/7/2024.
22/7?
My lord, I have filed a paper book, my lord.
Keep it.
Page number 1 to 15. My lordship may kindly go to page number 2.
Yes, sir.
My lord, a person in whose case an appeal or writ petition or special leave petition has been filed either by him or by the income tax authority or by both before an appellate forum, and such appeal or petition is pending as on the specified date. And the next page, my lordship will find the specified date.
22nd July 2024.
Then, my lord, in page number 16. It is page number 16, my lord. Circular is issued, my lord.
16.
Page number 16. Which appeals are covered by direct taxes Vivad se Vishwas scheme?
Page 16, yavralli?
See, my lord, I've given one
There
compilation.
page number ellide?
I've given a compilation, my lord.
Not there. Even what it was not given to us also. Maybe he's referring 16, one circular 16 December 2024. That was given
Lordship
separately.
may kindly have this one.
ಅದು ಕೊಡಿ ಮೇಡಮ್.
ಇದನ್ನೇ ಕೊಡ್ತೀನಿ. Page number 16, 19, 20.
Page number 16.
16.
Circular 12 of 24.
Please. Sorry, my lord, it's my copy. I'm not it.
No, that's all right.
12,
Yes.
Relevant.
24. This one.
And page number 19, page number 22. whether set-aside orders are eligible.
Scheme does not provide for those cases. If an appeal not pending as on, scheme does not envisage matters set aside or appeal.
The first one, 2008.
MA is not an appeal, therefore no pending appeal.
The facts of the case are, my lord, the tribunal has disposed the appeal on 14.
Now, what was
11.
pending as on the,
Pending was pending.
I'd like to.
as on the specified date?
Distinguish.
Tribunal disposed the matter on 14/11/2023. Dates are important.
14/11?
2023. Two issues, main issues were decided against the SEC, on which they have not preferred any appeal, and one matter was remanded.
One issue.
Set aside.
One matter was
issue-
remanded
one-
when?
Sorry,
One second. One
I'll
issue
get-
is.
I'll get
one
back to
issue
you.
was remanded.
One issue was remanded
Remanded back.
by the order of the tribunal.
Tribunal.
What happened to that? What happened after remand?
After remand, my lord, what happens is, then, my lord, the next day comes, my lord, 22/7/24, which is a specified date.
Correct.
Then, my lord, on 2/12/2024, they file a miscellaneous application.
I am
May I
asking.
clarify, your lordship?
Yes, one moment.
Page number 86 of my petition, your lordship. Page number 86.
Madam, one moment. 14/11/2023 is
Yes.
the order of the tribunal.
Yes.
One issue is held in your favor, one issue is sent
Not in
back.
favor, your lordship. One issue gone against me. Another one set aside to AO for fresh examination of the document because the assessment.
What did
order-
the AO do?
Nothing they did, your lordship. The demand is still pending, your lordship.
So according to you,
Yes.
the issue is still pending.
Still pending.
So
Because
it had
only-
to be treated as a pending case.
Lordship, as per
This-
their circular, what their contention, your lordship, that there is no appeal pending and the set aside matter to AO is not considered to be an appeal pending, hence I am not eligible for that Vivad Vishwas scheme, your lordship. Whereas it has been clarified, your lordship, I'd like to draw your kind attention of the first Vivad Vishwas scheme, it's 4th March 2020. I have given the circular on the earlier occasion, your lordship.
That's a different scheme, my lord.
No, maybe, your
One
lordship,
minute.
I'll try to relate it, your lordship.
One minute.
4th March 2020. Question number 7, your lordship. Question number 7.
Documents are not here. 4th March, yes, madam.
4th March 2020. Question number 7. If, may I read, your lordship? If the assessment has
You
been,
don't, who has given this clarification?
this is by the CBDT, your lordship. CBDT circular. If
Does
the,
not need a clarification. Yes, sir.
lordship, where my submission is not completed, your lordship.
Case is completed.
No, your lordship, because I can rely on the Bombay High Court judgment, even the Delhi High Court judgment, saying that what is the intention of this scheme, your lordship, to reduce the pendency, whereas this circular doesn't come into this picture, your lordship, where the act itself of the Finance Act 96 doesn't bar me for applying for the scheme, your lordship.
Yes, sir. It should be taken under the scheme. Anything else?
Nothing was pending, my lord, as
No,
on
sir. It was set aside and it is back.
my lord, there were 3 issues. I'll take my lordship.
Whatever issue. See, if the entire issue was closed by the tribunal and nothing happened, if it had not been set aside and kept
I'll
issue kept
explain.
alive,
My
it
lord,
was a different
I'll
thing.
explain. There were, my lord, 3 issues. 2 main issues were decided against the SSC, on which they did not prefer an appeal.
All right. One
So
issue,
what was pending is, my lord, only a small issue with regard to.
whatever issue is pending.
Lordship, I am.
My lord, and my lord, that circular also says it can't be, my lord, taken in part.
No, I'm not in part, your lordship, against the whole.
My lord, an issue which has been decided by a appellate forum, I'll just make myself. An issue, my lord, which has been decided by a appellate forum, my lord, which has not been challenged, which has reached its finality. Then, my lord, on a small issue, the matter is remanded back, and that issue is pending. My lord, can a settled issue also get covered in this scheme?
Not the settled issue. Whatever issue that was pending as on that day, that you will have to apply the scheme. Not the issue that you have already given up and closed.
No, your lordship, there are 2 issues which is against me while
Now
filing.
you take me to the
Vivad
order of the where is the order of the tribunal, madam?
Lordship, page 86.
Page?
86 of my petition.
That the assessee is not proved so and so.
Yes, Your Lordship. Whereas the third line of page 86.
No, which are the two that were against you?
I do not find. That is page 85, para 8, Your Lordship, page 85. Hence, we do not find any merit in the argument of the assessee counsel, which is not based on any evidence. Accordingly, grounds number 3, 4, 5 of the appeals are rejected.
Lord,
So these issues were against me, Your Lordship. But while availing the application, Your Lordship, I'll have to file the application against all the issues, Your Lordship, against the demand.
Which application?
The Vivad Vishwas scheme application against the order of the assessment order, Your Lordship.
Then it does not become pending on all the issues because appeal is rejected on these three issues. What is sent back to consider afresh is what is that? Since the assessment was ex parte, remit the matter to issue examine afresh. That was the only thing that was alive.
Because Your
as
Lordship,
on the
while
date of
taking the demand,
as on the specified date.
Yes, while taking the demand, Your Lordship, I cannot bifurcate this issue which is held in favor of me.
Lord, the main issue
Then
which
this
got,
will open Pandora's box.
my Lord, the main issue was which was decided against was, my Lord, for 7 crore 16 lakhs. Now what is remanded is for 1 lakh rupees.
1,02,370.
For remand.
Yes, Your Lordship.
What is crystallized is, my Lord, 7 crore 16 lakhs. That my Lordship will find.
No, even if we direct this to be considered under that scheme, what benefit you get, that's all.
Lordship, even
Your Honor,
subsequently,
the benefit
Your
only
Lordship,
we get is of the interest and the penalty. That's all. We have to pay the taxes.
No, for what? The entire thing you can't. There was nothing pending on that day. Now the appeal is fragmented. What to do? Appeal is partly allowed.
Partly allowed.
Partly allowed. The 3, 4, 5 issues are rejected and sent back. The rejection has become final. Now, what is remitted back to the assessing officer is only issue with regard to 1,02,000.
That is not de novo. That is for a fresh consideration of those issues.
Correct.
Then, according to us, that appeal is pending on that date because it's before the AO.
even Your Lordship, against the whole order, Your Lordship, I have filed the miscellaneous application also because there was some typographical error, Your Lordship, in the tribunal order. In the tribunal order, yes.
When did you file the miscellaneous application?
Oh, it is beyond the limitation period, Your Lordship. But I have filed.
No. After the specified date?
After the specified date, Your Lordship. No, even their circular is saying, Your Lordship, that even after that.
Any judicial interpretation of this?
Yes, Your Lordship.
Kodi?
Delhi High Court.
20th January, they have.
No, any High Court has interpreted this? Give it.
Delhi High Court, Your Lordship, I have already placed, and one more Bombay High Court I would like to place. Delhi High Court, paragraph 20, Your Lordship, page 13. Whereas in this case, Your Lordship, in the earlier Vivad Vishwas scheme 2020 review was not included, but by this judgment, Your Lordship.
If you have filed a review, that also becomes
yes, Your Lordship.
a part of the appeal.
Yes, Your Lordship. Shall I read para 20?
Yes, madam.
We may not forget that Vivad Vishwas Scheme Act is a beneficial legislation enacted with a definite purpose for the benefit of both the assessee and the department, whereby the legislature has provided a mechanism under which pending income tax litigation is sought to be reduced, as also ensuring that the revenue is generated in a timely manner for the government. That Vivad Vishwas Act, in a sense, provide for a deviation from which strict application of the tax law towards achieving this purpose. If the provision 2J of the board circular is to be construed in a restrictive manner, as it is contended by the learned counsel for the respondent, the same will run contrary to the scheme of the Act of the 2020. We are conscious that a review petition has been since dismissed by the Supreme Court. And then I'll skip this paragraph, Your Lordship, the paragraph 22. We are therefore unable to persuade ourselves to confine that the benefit of scheme to only such cases where an appeal, writ petition or special petition were pending. In our view, petition for
review.
Petition for review against the orders passed by SLP would also be covered in the definition under disputed tax under section 21J, whereby making them eligible to take the benefit of Vivad Vishwas scheme.
So there was circumstance there where the appeal review is pending against the order. Now
there was no review. Yes,
so
in
this.
Yes,
my Lordship may kindly go to my Lord, page number 22 of my compilation.
Lordship, may I complete my submission, Your Lordship?
Yes.
Then Bombay High Court judgment, Your Lordship. Page 13, para 15.
You gave the Bombay High Court?
Just now I have given. I have just given. Right? Bombay High Court.
This is Delhi High Court. One.
Oh, sorry, Delhi High Court.
Delhi High Court. Yes.
16 May 2024.
Yes, correct.
Para 15, page 13.
Para 15.
Para 15, page 13, Your Lordship. In the opinion of this court, when a section contemplates pendency of an appeal, which is required is that an appeal should be pending, and in such a case where there is no need to introduce the qualification that it should be valid or competent. In Raja Kulkarni versus State of Bombay, reported in so and so, the Supreme Court has held that whether an appeal is valid or competent is a question entirely for the appellate court before whom the appeal is filed to decide, and this determination is possible only after the appeal is heard, but there is nothing to prevent a party from filing an appeal which is ultimately to be found incompetent, that is, which is held to be barred by limitation. From the mere fact that such an appeal is held to be unmaintainable on any ground whatsoever, it does not follow that
So
there
that's
was
all right. Even if the appeal is not maintainable, it was still pending consideration.
still pending, Your Lordship.
Here, what is pending?
MP is pending.
MP was pending, Your Lordship.
MA is filed after the specified date.
Yes, Your Lordship.
No, it's after 2024.
Yes, Your Lordship.
And then how is it pending?
Even Your Lordship, page 17, para 39. Though 37 also is relevant, but I will not trouble Your Lordship. Therefore, it becomes evident that once the CIT has rejected the appeal of the assessee, whether on merits or on delay aspect, the tax demand as reflected in the assessment order gets confirmed unless set aside or modified, unless set aside for de novo and set aside for fresh examination is to be determined, Your Lordship, or modified by other appellate authority. Thus, the disputed tax area still exists as of the specified date, and consequently, the assessee would be eligible to apply for the settlement under the Vivad Vishwas scheme. Ultimately, Your Lordship, what is the intent of the legislature is to get rid of the litigation which is so
Intent
pending.
is fine.
And even Your Lordship, Finance Act.
Yes.
Finance Act, Your Lordship, Finance Act 2 of 2024, where chapter 4, Your Lordship, section 96. Section 96.
Good.
It is at the end of the act also is there.
Read.
At the end of the act also is there, Your Lordship.
You read, madam. You read it, no problem. Yes.
Scheme not to apply in certain cases.
And last one mentioned this guidance.
This is circular is 16 December.
Yeah, 16 December.
Scheme not to apply. Shall I read your? Scheme not to apply in certain cases. The provision of the scheme shall not apply in respect.
Which page are you reading there?
Lordship, section 96 I'm reading. Page number 2.104, though I have the old act, Your Lordship.
2.10.
2024 act I'm having.
One
2.10. The Finance Act. Section 96 scheme not to apply in certain cases. The provision of the scheme shall not apply in respect of tax area relating to assessment year in which in respect of which an assessment has been made under subsection so and so 143(3), 144, 147, 153A, 153C, and also 132 and 132A relating to an assessment year. I'll just keep my book, Your Lordship.
You please give your book. Yes. Yes, madam.
Whereas in all the clauses, Your Lordship, it has been mentioned that I am not barred, any set aside matter is not barred to file the application, Your Lordship. Whereas, which the circular they have referred, that 16th March, Your Lordship, question number 48, the prosecution. 16 December 2024. The question number 48, the prosecution matters, if it is not filed even before any court of law, Your Lordship, then also I am eligible to file the Vivad Vishwas scheme, which was observed by the earlier bench, Your Lordship, and ask them to get the clarification that why I am being prohibited at the time of applying the Vivad Vishwas scheme when it is set aside, and why the prosecution, even no appeal is pending while they are giving the benefit. That has been questioned.
Prosecution given the
Yes, Your Lordship. Question number
benefit of the scheme.
48. Question number 48 of 16 December.
I have placed
circular,
that circular, my lord.
Wait.
In page number 16, I think my lordship will find.
Question number 48.
I have underlined it.
No, I have the whole one.
They will not get.
No. Prosecution give permitted.
Yes, Your Lordship.
I'll place that. I'll show.
Now, show this. It is here.
Set aside matters. Then
to the left page, it will be there in the left. I marked it. Left side of 48.
Name compilation.
This
my
is
compilation. Page, probably page number 16.
Which appeals are pending? Which cases are not covered? Prosecution relating to an assessment in respect which prosecution is instituted on or before date of declaration. Prosecution is not covered.
No, Your Lordship, it is covered. 16 December 2024, this circular, Your Lordship. Question number 48, Your Lordship.
Question number 48.
48. Question number 48, where the prosecution proceeding has not been filed before a court of law, whether the assessee is eligible for the scheme. Yes, reference may be made to section 96 of the DTBC scheme 2024 as per the provision of section 96A2 of the said scheme. The scheme shall not apply in respect of tax arrear relating to an assessment year in respect of which a prosecution has been instituted on and before the date of filing of the declaration. Accordingly, where the prosecution proceeding have not yet been filed before a court of law, the taxpayer can opt for the scheme. Even there is no appeal, even there is no case have been filed before any court of law, even there is any notice issued for the prosecution case, they are giving the benefit to file the Vivad Vishwas scheme, where there is a lordship, there is a violation of fundamental right also in this case, where it was not given to me, Your Lordship. Yes, that has been observed, Your Lordship, and the question was put to the department counsel.
Lord. If this honorable court was to give relief, I'm just saying, my lord, the specified date is 22/7/2024.
Correct.
Application has been filed after that date.
Application is also not.
MA, miscellaneous petition is
miscellaneous in the correction with regard to tribunal order.
So that means technically, if a miscellaneous petition is filed even today, instead of December 24, if it is filed today, belatedly, then my lord.
That's why I said it'll open Pandora's box.
And also, my lord, my lordship may kindly take page number 22 of my compilation. A clarification given. What happens, my lord, after the specified date, sometimes
Lordship,
a valid appeal could be filed. They said if the appeal is filed within the time after the specified date, it will be taken as a valid.
Circular, they have withdrawn that, Your Lordship. By January 20th, January.
22, page number 22. It's a
22 I have seen, which is this 24 circular.
Yes, Your Lordship, they have withdrawn that, Your Lordship. Even it is dismissed before date, that also they are considering as an appeal pending, and they can avail the Vivad Vishwas scheme. They themselves have withdrawn. So they can't rely on the same issue, Your Lordship, again and again.
Next.
They have given certain clauses.
Yes.
Yes.
miscellaneous petition ಹಾಕಿದ್ರು ನಿಮ್ದೇ ಅಲ್ವಾ ಸರ್ಕ್ಯುಲರ್ ನೋಡಿಲ್ವಾ? Then
a valid what? The issues, my humble submission would be the issues which have been crystallized and not agitated before any appellate forum. Can it be said that an appeal was
that is
pending?
where there is a point. Otherwise,
It's not they have accepted that.
Even by the
They have
act
suffered that
also is
order.
not-
but miscellaneous
barred.
appeal is filed.
Only to the extent of that remanded matter, which is 1 lakh
But the
rupees.
typographical error, it
No,
is-
no, that miscellaneous appeal is filed only for that purpose.
That purpose. My lordship may kindly go to page number.
Where is the MA?
Page number 80. MA is in my lord.
No, madam, but schemes applicable for the
page
whole-
number 87, your lordship.
The schemes applicable entirely, it cannot be.
That's delay of 174 days is one thing.
Okay, then there is no purpose for 1 lakh.
I-
Who will hold up?
No, that's why.
Yes, yes.
The application scheme is entirely for the complete assessment order. It's not, it cannot be bifurcated.
No, the entire thing is not only on 1 lakh.
No, your lordship. Against the entire thing.
Lord,
your
that's
lordship.
and my lord, to file a valid miscellaneous petition,
No judgment is
it has to be done within, my lord, 12 months. My lord, the order of the ITAT was passed on 14.
No, this is 174 days delay that is accepted in the appeal itself.
No more application, no judgment will be there. Their miscellaneous application. also is to be-
Yes, let's see.
My lord, my lordship is referring to the order of the tribunal. My lord, the miscellaneous petition had to be a valid one which is pending, my lord.
That is page 88 is the miscellaneous petition, sir.
Please. My lord, they have to file it within 6 months, my lord. My lordship will find it in 254.
Delay is accepted. It is filed 174 days beyond period. Let's see.
It's here.
I've given papers all piecemeal here. We'll post it on 11th, we'll dictate on 11th. Yes, just on 11th.
Under the caption order, your lordship.
Orders.
Otherwise, it will not reach.
Your Honor's one
Lord, I'll
request.
give-
Your Honor's one request. There is a GST matter, WP 23899. It was to be posted today. It has not been posted.
Along with this, is it?
No, Your Honor's.
Then
It's separate.
Yes, yes, next.
Much obliged, your lordship.
Lord,
Can
my
can
paper
be
book-
listed on 11th, Your Honor's.
You move it, sir, not at the, not this way. What is this?
My lord, the paper book, my lord, I shall file a court copy, my lord.
If you, both of you file it, it will be fine. Otherwise, you've just given papers.
Please,
Yes.
please.
The paperwork was not served on me, your lordship. 23.
Copy ಕೊಡಿ sir ಅದು.
ಇಲ್ಲ ಅದೇನು ಇದಾಯ್ತು because only
For
one
the
even
caption
court
order,
copy
your
ನಲ್ಲಿ
lordship, this matter can be
Yes,
put, your
yes,
lordship.
madam, we'll see.
Much
yes.
obliged.
Preliminary hearing ಅಂತ ಹಾಕಿ madam. Yes,
Please, my lords, I appear for the petitioner in this matter. Lordship, just to, before getting onto the issue, I'll just narrate the facts which has resulted into the current petition. There were 4 consignments which were imported, which were supposed to be carbon steel, which inadvertently the supplier from abroad, the consignment that was sent was stainless steel pipes instead of carbon steel pipes. The goods came to India. Thereafter, bill of entry was filed and the investigation started, and simultaneously I received an email from the supplier saying that by inadvertently I have sent wrong goods, so you please send the goods back. So I applied to the customs saying that wrong goods have come, so please allow re-export of the goods that are not ordered by me but wrongly sent by the customers. So the customs, the DRI, the investigating agency of customs, they carried out investigation. They issued a measure. However, they did not issue any seizure memo, and they detained the goods. This happened in the month of November, December of 24. I wrote to them on January 6, 25, saying that you please allow re-export of the goods. You have anyways drawn the samples. So if you want to do any investigation, I am an Indian person, I am available. I have told you what facts have happened under which these goods have come. So you allow me the export. They did not respond to my letter. They did not even allow me to warehouse the goods because the goods were lying at the customs area, which was getting clogged, and there is a higher demurrage at customs area. So I said, allow me to put in a bonded warehouse, which is also under customs control. But there was no response, and as a result, I filed this present petition. And the prayers are mentioning that I should be allowed
Re-export.
yes, re-export of these goods. Since then, there have been many hearings, short hearings, which happened in this matter. Several memos have
Objections are filed.
Objections are filed.
Objections have been filed. Several memos were filed. Objection is also now filed.
Memos for what?
They were saying that we have already passed an order rejecting the re-export of the goods, but we will allow you the warehousing of the goods in the bonded warehouse. But there is no availability of a bonded warehouse, so the goods were not able to be moved to the bonded warehouse. So contention today is that there is no seizure memo that has been issued. I will come to the legal points and I will also show the judicial precedents, which says that the only provision under which the customs authorities can hold any goods is section 110, and that also has to be done with a reasoned seizure memo to be issued to the importer under what circumstances the goods have been seized. In the objection, they say that we have issued a seizure memo, but no such seizure memo has been brought on record. There has been a reference in the measure that they are seizing the goods, but there is a specific circular of the central department saying that you cannot seize the goods under a measure. You have to file a separate, you have to make a separate order, a reasoned order, if you intend to seize the goods. So today my proposition is this, that there is no seizure. And if there is no seizure, the goods are free. I do not intend to clear it to the domestic area. I wish to re-export because they have been sent by mistake by the exporter. There are also circulars of the department, which I will point out, which say that if any goods have come due to wrong shipment, and if it is a bona fide error, then at the earliest the goods should be allowed to be exported. I am not coming in the way of their inquiry. I am not coming in the way of their investigation.
But the goods should be sent out.
Goods should be sent out. They have already taken the samples. They have the samples. They have already done the testing. They are carrying out the investigation. It is almost coming to 1 year. And 110 specifies, even assuming against me, that there was a seizure in the month of November, December, when the measure was issued. The 110 section categorically says that you have a period of 6 months. If you do not issue a show cause within 6 months, you have to hand the goods back to the person from whom you are seized. And there is a provision for extension. There is also a law which says that if you have to give an extension, a hearing has to be given. And post the hearing, an extension can be granted, which has not done. So my preliminary argument is that there is no seizure memo. In absence of a seizure memo, there is no provision or authority for the customs to hold the goods which they are holding. And in light of that, if I want to export, subject to whatever they want to protect their investigation, like they already taken the sample, I'm also willing to give the bond to the value of the goods.
Yes.
The goods should be allowed to be re-exported, because otherwise it is clogging the customs area, and that's precisely what the circular of customs says. Now I'll take my lords through the correspondence and the relevant law matters.
Yes.
Sorry. 96. First, I'll take my lords to page 96, which are the instructions relating to the seizure. These are issued by the central board.
Yes.
So paragraph 2, my lords, is relevant, about third line from the top. That the Honorable Delhi High Court in a recent order has held.
Page 95.
Yes, my lords, page 96. Page 96. It's instructions dated 8th February 17, my lords. Exhibit Annexure N.
Yes.
Lordship has got it.
Is it brought to the notice of the board?
Yes, my lords.
Delhi High Court in a recent
Yeah,
order.
Delhi High Court in the recent order has held that the Panchanama is a statement of Panchas and cannot be taken to be an order passed by a proper officer under Section 110 of the Customs Act. Though Section 110 of the Act does not specify passing of an order of a seizure of goods, it says that where it is not practicable to seize any such goods, a proper officer may serve on the owner of the goods an order that he shall not remove part with or otherwise deal with the goods except with the previous permission of such officer. In view of the above, in all future cases, the following may be adhered to. Where goods are being seized, in addition to Panchanama, the proper officer must also pass an appropriate order, seizure memo, stroke order, etc., clearly mentioning the reasons to believe that the goods are liable for confiscation. Where it is not practicable, that's a different regarding if it is not practicable to seize the goods, then he may keep it with the person. So, as far as law regarding seizure and 110, it is clear that they have to pass an order. There is no order that they have brought on record. There is a Panchanama, which also I will point out. If Lordship looks at page 59, the Panchanama starts at page 54 and the relevant portion for seizure is at page 59. Therefore, the said SIO informed we the mother witness, Shri so-and-so and Shri so-and-so, that the said container are to be seized as the goods imported under the bill of entry as mentioned in table 1 above appears to be stainless steel seamless pipe contrary to the declaration by the importer of HR carbon steel seamless pipes, the bill of entries. The same is ascertained by PMI testing on these sample goods for all containers. So this is the only reference that comes relating to seizure.
Yes.
There is no order that has been passed. So circular is very categorical and clear. It has said that High Court has already held that you cannot have a seizure.
On mistaken things, yes.
My lord,
should be permitted.
My lord, there are various judgments. Well, my lord, the Mahajar, inside the Mahajar, the seizure order can be passed. I'll produce those judgment, my lord. My lord, here the categorically the petitioner asks for two reliefs. One is for warehousing facility, where we have passed a section 49 order and provided them for warehousing facility.
Yes. The other
Second
one is re-export.
for re-export. My lord, why the re-export we are slightly we are saying is that because there is a apprehension that the petitioner is involved in smuggling these goods. If it was not identified and if he had not, based on the intelligence, caught hold of those products, it would have entered India without paying the duty, my lord. Now only all we are saying is that because after the adjudication process, there may be a order for absolute confiscation. That is the reason why we are not accepting for re-export, my lord. My lord, section 110 says release of goods inside India on paying redemption fee, all those things, my lord. But once the goods are outside India, even if the order is passed for absolute confiscation, provided that we come to a conclusion that the petitioner is a smuggler habitually involved, the only problem is that we will not be able to confiscate the goods, my lord. It would be already be outside India. That is the reason.
So,
Lordship may fix
judgments. What fix?
My lord, some time limit will conclude the investigation and conclude the adjudication proceedings also,
already,
my lord.
it's a year already.
Section gives 6 months. It's already 1 year. And Lordship may look, my learned friend says.
What is the stage of investigation that you're doing now?
My lord, now IR report is submitted. Show cause notice has to be issued.
But 110 and 124 are two different things. 110 says that you have to give the goods. If you do not conclude it within 6 months, and I may just draw my lord's attention to 125, which my learned friend is saying absolute confiscation of the goods. There is no provision for absolute confiscation of the goods unless there are hazardous goods like firearms or drugs.
Even
if prohibited goods. Even if prohibited goods, Lordship may have a look at 125 of Customs Act.
Customs Act.
And this is, of course, post issue of show cause notice, hearing, adjudication, and then the question of confiscation comes. Whenever confiscation of any goods is authorized by this act, authority can
Yes, where is the notice and other things here?
no. So this
There's option to pay fine in lieu of confiscation.
yes. So therefore, there is no absolute confiscation. Ultimately, if certain goods
So
are
why
confiscated.
did you want to read this?
No, so I'm just saying that what my learned friend is saying, that if you allow the goods to go, there is a difficulty for the customs authority and there is a revenue loss.
Yes.
Assuming everything against me, a show cause is issued, adjudicated against me, goods are confiscated, I am still entitled to redeem those goods by paying a fine. So where is the
That
question
is-
of the goods getting out of India will affect
Bank
the
guarantee or
interest?
otherwise?
My lord, I had put forth the same thing, bank guarantee or security. However, my instructions are that because if it finally adjudicating proceedings where there is absolute confiscation, goods we may not be able. That is the only apprehension of the department. My lord.
So I've already offered that I'll give bond for the entire value of the consignment.
Bond, nothing will happen.
Then lordship may put me to terms of maybe 10% of bank guarantee I can provide, and time bound adjudication can be provided.
Time bound adjudication I will immediately give. But permitting re-export of goods
Yes, my lords.
on no security will be difficult.
Now,
No, I will leave
now
it to
we
my
have
lords. So
provided the
whatever
warehousing
lordship.
facility. Now the goods will be in the warehousing. A time-bound investigation will conclude, my lord. That would
Time
suffice.
bound investigation I will direct within 3 months. We will conclude the investigation and close it. I would have taken it to its logical conclusion.
Please,
Lordship
That
may,
I can do.
I leave it to my lords. Whatever my lords feel appropriate, lordship may put me to terms, because the goods have to go back. It's more than 1 year, and the goods I have made an application in January of this year.
Which is
25.
that provision you said 6 months you have to close?
110, my lords. Section 110.
Seizure of goods.
Yes, my lords.
Subsection yavudu?
Yes, my lords. Subsection 2. Where any goods are seized under subsection 1 and no notice in respect of which is given under clause
Within 6 months of the
from
seizure of goods and return to
the
the
goods shall be
person.
returned to the person from whose possession they were seized.
When was the seizure now?
There was no my case is there is no seizure.
There is a further period of 6 months. So
Where is it?
proviso.
Proviso,
Proviso.
therefore,
But
on sufficient cause being shown.
There is no seizure, means there is.
You have drawn Panchnama.
Please, man.
Now you have confiscated that.
Confiscated.
Which is my case that Panchanama is not sufficient.
No,
As per the
confiscation
circular.
is under 132. Confiscation is what?
Like confiscation will come under
110 only. Seizure. 111 is a confiscation.
Confiscation will come under 111.
111, yes.
Yes, ma'am. But that is subject to a show cause being issued under 124.
Seizure can happen without anything. Confiscation is after issuance of notice.
Seizure also will happen with the seizure memo.
That
as
also.
per the.
But that
circular.
has happened here.
There is no seizure memo. There is a muzzle. So I will again draw
So
my.
muzzle will not suffice is your submission.
Yeah, because that's what the instructions of the central board says, my lords, and relying on a Delhi High Court decision.
My lord, my humble submission. Lordship may fix a time limit, 4 months or.
But
we'll conclude the proceedings.
You have already
My lord, there is a extended period.
done contract. Extension is only on sufficient cause being shown. What sufficient cause?
My instructions are that it is extended. So
Extended. Where is the order of extension?
that I will produce.
No, I will also show a Supreme Court decision which says that if you have to give I have already filed a compilation. I will point it out. If you have to give an extension, then you have to give me a hearing before giving an extension and show reasonable cause. Lordship may just have.
My lord, because now the investigation report is already completed, submitted. The only thing is the adjudicating proceedings, my lord. So lordship may fix some time limit. We will conclude the adjudicating proceedings.
No, you have already contrary to the statute you have travelled. Where is the
I
Supreme
will
Court?
produce.
Yes, ma'am. Lordship, I have given a compilation under a memo.
Yeah, madam, compilation. There is no compilation here.
This is the same compilation. 8 copy. One more copy.
Notice to be issued before the expiry period.
Yeah, Lordship may have a look at the judgment which is starting at page 3. And the relevant portion, my lords, will find. is at page 8, paragraph 16.
Yes, we'll direct release of goods. Afternoon, I'll direct.
Obliged.
Get in there. 6 months ಅಲ್ಲಿ ಮುಗಿಸ್ಬೇಕಾಗಿತ್ತು.
Obliged.
ದೇವ್ರ ಬಿಲ್ ಮಾಡಿ. We'll resume at 2:30.
Madam. Madam. Madam.
Cause list number 2, serial number 1 being spoken to, my lords. Could it be taken?
Yen being spoken to?
Interim order on ಸ್ವಲ್ಪ ಬೇರೆ ತರ ಬಂದಿತ್ತು, ಅದೊಂದು rectification ಹಾಕೊಂಡಿದ್ವಿ. Cause list number 2, serial number 1. I filed an application IA 2 of 25.
The objection illa andre okay.
No, my lord. I am here, my lord.
You are here.
I have filed application for vacation of interim order. Interim order is not maintainable, my lord.
Interim order not maintainable.
It's not maintainable.
That will come up before the actual roster,
Oh,
my lord.
ಈಗ interim order ಇದೆ ಅಲ್ವಾ?
Interim order ಇದೆ.
My
Interim
lord,
order.
no, my lord. My submission.
ಈಗ why did you do all this?
Kindly
ಇದೆಲ್ಲ
see the
ಮಾಡಿದ್ರೆ
status.
then I will not keep quiet. ಇದೆಲ್ಲ ಮಾಡಿದ್ರೆ ಸರಿ. Take them, ask them to sit.
No,
Ask them to sit. Ask them to sit. Why did you get them?
No, I tell them to not to come, but they are not listening, my lord.
What not listening?
Because, my lord, he is having.
Don't do all this drama here.
I told him to not to come, but they're not listen, my lord. My son, when he was looking after my property.
That's all right. I have granted an interim order. No question of modification. The learned counsel appearing for the petitioner has filed an order seeking modification of the interim order. There is the perusal at the order would not require any rectification of the orders already so passed. The matter be placed before the bench having roster.
My lord, kindly I'll explain, my lord.
Yes,
I'm seeking.
next.
In fact, it is for
There is
rectification,
no
my lord.
question of rectification of the order.
The suit property is an agricultural land.
No problem.
Your
Yes.
lordship has dictated that the
No problem.
petitioner
No
could
issue.
reside
No,
in the property.
You ask the other court to do it.
So I'm only
Final argument mugsi alla.
My lord, I'm only seeking for a
No, I'm not going to modify
modification that
I
petitioner
am not
be
going to modify anything.
petitioner be permitted to cultivate the property, my
No,
lord.
sir, nothing. Yes.
It's a subject matter of agricultural
No,
land.
sir, I will not. Yes.
My lord, as per
Next.
as per the interim order, I'm paying 10,000 rupees every
That
month.
I
my
don't
lord.
know. Yes, next.
One small submission. It was WP 26064 of 25. It was listed on 2nd of September. Your lordship had granted an interim order. Request for hand delivery of the same.
Long back agide hand delivery act. It's already released.
Well, the matter is coming before the trial.
You please go and check whether it is released or not before coming here,
They
sir.
had asked us to make a submission before the court.
Interim order long back it has gone. What date is the interim? 2/9.
2/9, my lord, the day before.
Already gone. 100. No interim order is pending. Signature or release. Yes.
This land acquisition matter, my lord, sir, railway 21(2), whether it is mandatory or not. The Honorable Supreme Court has said it is mandatory, my lord.
It is mandatory. I am also holding it to be mandatory. I am going to set aside everything.
Pass on judgment.
I have that. Ille ide. Yes.
Maybe.
ಈಗಲೇ ಯಾಕೆ? Wait ಮಾಡಿ ಸ್ವಲ್ಪ. Yes. ಧಾರವಾಡ ಬೆಂಚ್ ಅದು. ಧಾರವಾಡ ಬೆಂಚ್ at 4 PM.
Please, madam.
It was sent to the Gururia bench.
ಏನಂತ? ಯಾವ್ದು ಮೇಡಮ್? ಡಿಕ್ಟೇಟಿಂಗ್ ಅಂತ ಎಲ್ಲಿದೆ ಮೇಡಮ್? ಹ? ಆ ಡಿಕ್ಟೇಷನ್ ಮುಗಿಸ್ಕೊಂಡು ಕೊಡು.
Please, ma'am.
One submission. Lord, one submission. I have ascertained the extension order has been issued, but only thing is that they are not able to find the proof that they have served it on the.
Then it goes.
My lord, if that is the case,
Then
my
it
lord,
goes.
one submission, my lord. Because the bill of entry was filed for exempted goods, copper pipes.
Who asked you not to complete it within the statutory period, sir? or comply with the statute while extending it. The whole problem with the revenue sometimes is that you don't comply with the statute and make a hue and cry. It's going to cause lot of loss, revenue loss. Country is in that, country is in this. Why don't you act properly? 6 ತಿಂಗಳಲ್ಲಿ ಮುಗ್ಸಕ್ಕೆ ಏನಾಗಿತ್ತು? What is the problem?
It has been extended. Only thing is that I have not communicated that.
That communication is a statutory mandate. Then why you did not do it? Why do you take the statute for granted? You need not follow it, Anta.
They're trying to ascertain.
What need to ascertain? In every case, you leave loopholes by doing this. There are so many cases, ella ex parte proceeding. Tumba urgent order pass ಮಾಡಕ್ಕೆ.
ಇಲ್ಲ, ಅದು ex parte proceedings ಏನಾಗುತ್ತೆ ಸ್ವಾಮಿ? We would issue a to the whatever the address has been given by the SSC, we would issue. If the SSC has changed its address and it has not been uploaded,
if the changed address is also updated, what do you do?
If it is uploaded, we would have issued to the updated address. And normally, many times the SSC does not ask.
Of course, SSC also is not that you're not at fault at all.
And if lordships are releasing, my lord, then
Up to
100%
what choice?
Bank guarantee maybe.
No, what choice is there? Tell me. What choice is there but to release the goods in this case?
But, my instructions are that they are ready to conclude the adjudicating proceedings within a period of 4 months.
1 ವರ್ಷದಿಂದ ಮಾಡಿಲ್ಲ. Why? ಈಗ when it comes to the brim, you want to do it in a hurry. Why? Supreme Court holds it is statutory and it cannot be done. Supreme Court also has released the goods. Whatever is confiscated, I think Bombay High Court, Calcutta High Court, everybody have released the goods. It's a natural consequence. You project that, yes, smuggling activity. Act fast, sir. Act fast.
Because my lord, my humble submission is that
the mandate of the statute. Relax ಮಾಡಿರೋದು ಒಂದು judgment ಕೊಡಿ. Beyond 12 months, you can continue the proceeding, hold on to the goods, even though you have not extended the period or extended the period, not communicated. All that is not necessary. Where is it? One judgment you give. On the contrary, he will give you 10. You are aware of it.
There is one more decision which in fact says that 124 and 110 are mutually exclusive. They do not have any connection.
And one more thing. You say you have seized. No seizure report. You draw a mazer. The statute does not recognize mazer. The statute recognizes seizure. Why? Why mazer? Either confiscation, seizure, ಒಂದು ಇಲ್ಲ, ಸುಮ್ಮನೆ mazer drawn, goods taken. What? Either you do not know how to do it, nor you deliberately do this. Not correct. When the statute prescribes a particular thing, please do it in that manner. Which court will interfere? No court will interfere. If you have done everything correctly, the petitions would be dismissed. You don't do it.
My one submission, my lord, if your lordship releases the goods and permits them to re-export, then the only problem is that, my lord, it will set as a precedent to all other people who deliberately files a bill of entry for some other goods and imports only on investigation and inspection. We catch hold of it.
You definitely do it. See, this is what you project before the court, saying if you do it, it is going to become this. But why don't you do it?
This may be error.
Why don't you? If it is an error, it has to go. It is quite the facts of the case. How can one case become a precedent in case you don't pass any order in all the cases that are there after 6 months? That will follow. That is bound to follow.
But section 110 only permits for maximum is that release of goods, my lord. Not for.
I am not beyond release of goods. I am not going to say anything. Only release of goods. Alla blanket ille, I'll give permission also to export everything. Nothing like that. The resultant action of this will be release of goods that you have kept with you, either drawn mahazar or confiscated or seized. With nothing you have drawn. ನೀವು ಅನಕ್ಷರಗಳು ನೋಡಿ ಎಲ್ಲ ಮಾಜರ್ ಇದೆ, 3 ಮಾಜರ್ ಇದೆ. Beyond that there is nothing. Where wholesale violation of the statute. Correct. then how can you project all this?
If your lordship
Release
is
of
releasing,
goods, release
then at
of
least
goods is a
100% bank guarantee
consequence.
may be directed.
Re-export or otherwise, it is your burden. Court is not going to say you are entitled for re-export. That's all. We'll stop at release of goods.
As in accordance with law, I'll make an application.
And that is up to them.
Yes,
Yes.
On bank guarantee, my lord.
That is up to you again. Release of goods by bank guarantee. No, release of goods is a consequence of violation of the statute. If you want it to be permitted re-export, then it is up to you to whatever conditions you want to impose. Absolutely.
I just want to place one decision of the Supreme Court, which is following the earlier one which I had given. And in addition to the aspect of a hearing to be given for the extension, it also says that 110 and 124 are mutually exclusive, my lords.
Urban slab.
Yes. Yes. Paragraph 1, my lords. The second line talks
Anyway,
of
it follows the 5-judge bench.
Yeah, and there is only one another issue about which my learned friend is saying that 110, if release is allowed, then 124 gets affected. The Supreme Court said that these are two mutually exclusive.
That is why, that's exactly. I'm not going to enter upon the re-export permission. Yes. The petitioner.
So, Lordship, just one small aspect, if Lordship permits. Since the goods have not been released as they were supposed to be released, in spite of my letter on the 6th of January, there is a detention and demurrage because the goods were held at the port, at the customs area. So they have an authority to issue a certificate. I'm only saying post my application. Prior to that, I'm not saying I'm liable. But 6th January onwards, because the delay is due to their inaction, I will only request my lord to permit them, request that they may be directed to issue a detention certificate, so that I am not liable to pay the detention and demurrage for the ground rent where the goods were held.
6 months admele. Up to 6 months, no problem. Statute permits. Beyond 6 months, if you want to do something, statute permits in a particular manner.
If your lordship directs for detention certificate, then we are now adjudicating the proceedings, my lord. Then they will take up that certificate and say it is not seizure, it is detention, and it will be
detention. I have not drawn seizure at all.
Correct. It is detention. It is detention.
In terms of law, where have you?
Going on, my lord.
Yes, we'll pass out. The petitioner is before this court calling in. Your prayer also will be on the other way. So the petitioner is before this court seeking a direction that the entry. What is this prayer, sir? Well, you have not passed any order?
Hello?
You have not passed any order now?
No.
Rejecting his application?
We have passed.
Where is it?
Memo.
There is no order, my lord. It's an internal communication between the department.
No.
The petitioner is before this court seeking
There is a memo dated 15/7.
declaration that the goods covered under the bills in paragraph. The first time I'm unable to decipher the prayer.
Lordship, the
What
prayers
sort
are
of
page,
prayers you say?
page 23.
No clarity in anything. Or I don't have knowledge of text.
There is order 15/7.
Basic prayer should be there something in a manner that can be understood. The respondents have failed to exercise power under so and so. Quote the prayer as it is.
So prayer B.
The petitioner in facts we'll see, yes. The petitioner in the course of furtherance of his business sought to import carbon steel products from China. The petitioner's suppliers in China are said to have supplied or shipped goods by way of 7 bills of bill of lading and so, and described them as carbon steel seamless pipes. Upon arrival of the aforesaid consignments, the petitioner filed 7 bills of entry between 17/11/2024 to 1/12/2024 for clearance. The details of bills of entry are narrated in the petition. On arrival of the said consignments, the same is examined and put on hold by the officers of the fourth respondent who draw samples therefrom and forward the same for further examination. As the goods were under examination, the petitioner, being unaware of the reasons for detention of the goods, is said to have contacted its suppliers with regard to the consignment, who only to be informed that the shipped materials inadvertently are stainless steel pipes instead of high carbon steel seamless pipes, and therefore the suppliers agreed to take back the goods. The copies of the communications between the parties is also appended to the petition. On examination of the goods, it transpires that the fourth respondent investigating agency observes that instead of carbon steel products as declared, the petitioner's consignments contained stainless steel seamless pipes which attract anti-dumping duty, and therefore the goods covered under the bills of entry were sent for examination and detained by the fourth respondent. The goods continue to remain in detention, and the petitioner submits an application placing all the facts and seeking warehousing of the goods under section 49 of the act. Since the consignments being made under the consignments were under investigation, it was not cleared for a long time. The petitioner then cleared for a long time and unable to bear the demurrage charges, which continued detention of the goods, the petitioner then files an application for warehousing of the goods, which is permitted. The warehousing is permitted, which is permitted at a later point in time. The petitioner on 6/1/2025 sought permission for re-export of the goods by the application for re-export. Before the third respondent, in the non-consideration of the application for re-export is what has driven the petitioner to this court in the subject petition, claiming the aforequoted prayers, inter-alia. The learned counsel appearing for the petitioner would contend that the respondent customs, while detaining the goods, have drawn 3 mahazars. This would not suffice to be in tune with the statute, which could be seizure or confiscation. He would further contend that in terms of section 124, 110 or 124? 110 of the Act, the maximum period with which the investigation should conclude when the goods are detained is 6 months. It can be, the proviso permits extension on reasons recorded in writing. He would submit that only the reasons to be recorded in writing would not suffice, but the person whose goods are detained will have to be heard in the matter when passing an order of extension. The same has not taken place in the case at hand. He would thus seek release of the goods and permit him to take further action in accordance with law. In the light of the warehousing, in the light of the detention of the goods beyond 6 months, the demurrage and detention charges should not be upon the petitioner, as it was the act of the respondent customs contrary to the statute. He would therefore seek the prayers be allowed. Yes. Per contra, the learned counsel appearing for the respondent would Arvind Chavan would submit that the statute permits extension. The extension of it is granted, but the notice as necessary under section 110 is not issued for the extension, that is prior to the extension, as is necessary in law.
Not able to ascertain whether it is proof.
Notice issued.
Acknowledgement I cannot produce.
The learned counsel would submit that the notice, though issued, is not in a position to ascertain or is not in a position to provide information with regard to the service of notice upon the petitioner. he would submit that that would suffice in law, and if this is permitted, it would become a precedent to several other cases. He would seek the permission of the court to conclude the proceedings with an outer limit of 3 months, and the consequences to follow later. I have given my source. The afore narrated facts link in the chain of events are all a matter of record. What drives the petitioner to this court is detention of the goods. The goods were detained on account of a alleged wrong supply by the supplier in China. The wrong supply is admitted by the supplier and also undertakes that the goods would be taken back. The goods that are now brought to the shores of the nation does attract anti-dumping duty is what the customs would hold. The issue is not with regard to the merit of the claim, whether the goods would incur duty or otherwise. In terms of section 110, it is again not in dispute that proceedings are initiated against the petitioner and investigation is pending. Such acts are governed by section 110 of the Customs Act. It reads as follows. Section 110 deals with seizure of goods, documents or things. Subsection 2 of section 110 mandates that when any goods are seized and no notice in respect thereof is given, under section 124, within 6 months of seizure of the goods shall be returned to the person from whose possession they are seized. The proviso to this said section permits the authority to extend the period for another 6 months on sufficient cause, but not for a period beyond 6 months of the extension. Therefore, the conclusion of the proceedings must have once initiated must happen within an outer limit of 1 year with conditions imposed thereon. Section 124, which is also germane to be noticed, reads as follows. Section 124 deals with issuance of notice before confiscation of goods. The confiscation of goods, if has happened in the case at hand, it ought to have met its conclusion within 6 months. The proceedings ought to have met its conclusion within 6 months in terms of subsection 2 of section 110, or the goods to be returned to the from whose possession it was seized. The learned counsel for the respondent, as observed herein above, is not in a position to demonstrate that the extension was granted. Extension of the period of investigation as provided in the proviso to subsection 2 of section 110 was were drawn, or notice was issued to the person from whose possession it was seized, i.e. the possession of the petitioner. This being an admitted fact, the impact of the statute must follow. The goods that are seized, the goods were seized, what is date? On 16/12/2024. The goods were detained by drawing up 3 mahazars on 16/12/2024. Therefore, the proceedings ought to have concluded on or before the 15th of June, 15th of June, 15th of June 2024. Admittedly, the proceedings even today are pending. The proviso permits extension. The extension is hedged with certain conditions. The condition is showing sufficient cause and hearing the person whose goods are seized. Showing sufficient cause is not shown in the statement of objections filed by the respondent, nor the respondent has any information about the notice being served upon the petitioner, the person from whom the goods are seized. Therefore, there is violation of section 110. The violation of section 110 would undoubtedly lead to the result of the violation. The result of the violation is also mandated under the statute itself. It would be release of the goods. Therefore, the therefore, the respondent customs will have to now bear with the rigor of the statute by releasing the goods goods that are detained in favor of the petitioner. The learned counsel for the petitioner submits that the detention and demurrage charges that are imposed upon the petitioner or that would be imposed upon the petitioner should not be, as beyond 6 months the petitioners have not.
I'm saying that I made an application on 6th of January, because even if it is seized, I am entitled to move it to a bonded warehouse, which is also customs regulated. The charges in a bonded warehouse is 1/4 of the charges which I have to incur in the area. So which they did not permit me till I came to the court.
Then that they will consider, yes. At the learned counsel for the petitioner at this juncture submits that they should not be imposed detention and demurrage charges, as the petitioner submitted an application seeking movement of the detained goods into a warehouse, which charges would have been 1/4 of what the charge is made by the customs of detaining it in their area. This is considered and allowed when warehouse.
So this was they said that we will permit it in July of 25 when
This was allowed only in the month of July 2025. Therefore, the learned counsel submits that the detention and demurrage should not be imposed upon the petitioner. Well, the relief that can be granted to the petitioner is the release of goods. Any other relief with regard to demurrage or detention or demurrage, the petitioner is at liberty to submit an application / representation to the respondents, which they will respond immediately in tune with the statute. It is made clear that the effect of this order is only release of goods, not the closure of proceedings that are pending. Closure of proceedings pending before it. It is for the authorities to close the proceedings as expeditiously as possible. For the aforesaid reasons, the following order: the petition is allowed in part. The goods that are detained by the respondent shall now be released to the petitioner within 15 days.
4 weeks from the receipt of the order.
Within 2 weeks from the date of receipt of the copy of the order, the petitioner is at liberty to seek further actions before the authorities by submitting necessary applications.
Obliged,
yes.
Serial number 24. I appear on behalf of the petitioner's counsel, my lords. May I request for a accommodation for a date, please, my lords, in this matter? Serial number 24.
At the request of the counsel appearing for the petitioner, list on 18th. Yes,
18-9. Grateful, my lords. Grateful.
Here for the petitioner. My lords, in this matter, in fact, there's an
Objection
interim order. There's an interim order.
There's an 67(1) and 2 violation.
Yes. No, in fact, personally, I just wanted to make this matter may need to be heard substantially. But
Then we'll hear it, no problem.
Yes.
Not today.
And let it be
Yes.
taken. In fact, I want to file some additional documents. I'll serve my friend.
File it, yes. Heard the learned senior counsel, Srimati Jaina Kotari, appearing for the petitioner, list the matter on 18th.
11th, can it? No. 18 may be
18th.
difficult.
Interim order
25th or 26th. Can it be the week after that? 25th. 25th. Great.
Interim order subsisting would continue to the next date of hearing.
Great.
So detailed order.
Yes, there is a detailed order after hearing my friend.
Yes.
Great.
Yes, next.
Appearing for the petitioner, my lord. This is a GST matter, my lord.
I need a copy of, I represent for 457.
Copy kotilva.
They make me a party, they don't give me a copy. If I ask, they
I
say.
have the proof of serving
No,
copy, both via WhatsApp when he stood here.
Please, I'll
First date of
be
hearing.
enlightened to see the copy.
Very much.
They're not, because when I
And
asked them.
also physical copy, my
When I
lord.
asked them,
And-
they told you're not a
To Madhu?
necessary party.
Yes, my
No,
lord.
for me, it has not
He
been
gave me
given.
his phone number right here when we were standing on the first date of hearing, which is
If
in the
it is
month
shown,
of
my
June.
lords, I will be quiet.
Well, I am more than glad to show my lord.
No, I would want to see the phone.
Yes, my lord. My lord, this is a case wherein my refund applications are being
Correct.
rejected.
I want to know what is the interpretation of this relevant supporting documents missing. The entire world you can claim if that is left high and dry.
My lord, actually, I am not even required to make an application because
Refund
this
hange
is,
barbeku.
illa my lord, this is a recovery made, illegal recovery during on the date of search and during investigation proceedings.
Not recovery.
It has been, it is, I will establish my lord.
Copy illa andre?
It is a, ಇವಾಗ ಗೊತ್ತಾಯ್ತಲ್ಲ my lord. Anyway, my lord, there's a clear instruction issued by CBIC stating that such recoveries cannot be made during the investigation proceedings, even the date of search. Now they have made recoveries. I still go ahead and make an application while I am not required to. They still don't give me the refund. Instead, they reject my application at threshold, saying that one-liner, relevant
Yes.
supporting documents.
Supporting
What is it that they
documents
require?
Similar
What supporting
cases,
document?
have come. My lords, my submission is, though I am not fully aware of the case, but the point of law, refund application and the file ಮಾಡ್ಬಿಡ್ತಾರೆ. They insist us to give an acknowledgement of refund because then they will say, see, you give an acknowledgement, now I am eligible for refund.
Oh, no,
ಅದಕ್ಕೆ
no, that is
documents
not the
No, when we
No,
issue
no.
when we issue a deficiency memo, they say, you see, you have only given deficiency memo. You should have given me the acknowledgement of refund application. When we
My
give
lord, this is
refund
a covered
application
matter.
acknowledgement, then
The-
they say, look at this,
My
you
lord.
gave a refund application acknowledgement.
My lord, I don't know
For
if my
refund
learned
ಅಂದ್ಬಿಟ್ಟು ಇನ್ನೊಂದು
counsel has
repetition
even
file
read
ಮಾಡ್ತಾರೆ.
Rule
No,
90, my lord.
One moment. Now, the petition, if the allegation of the petitioner is that it was illegal recovery at the time of search, which you cannot do, then refund ಕೊಡ್ಲೇಬೇಕಾ?
Yes,
My lords,
my lord, this
submission
is
added, if my lords, they say it is recovery.
That is what.
They claim it is recovery. It is not recovery.
Then what seizure?
No. During the search or any thereafterwards, they would have paid out payment ಮಾಡ್ತೀನಿ ಅಂತ DRC 03 payment ಮಾಡಿರ್ತಾರೆ. ಅಂತದನ್ನ ಇವ್ರು ಬಂದ್ಬಿಟ್ಟು they cannot claim it is illegal recovery.
My lord, page number
They have to wait till the
56.
investigation gets over.
No. My lord, page number 56.
Tell me now.
Page number 56,
ಅಲ್ಲ, ಅವ್ರು
clearly
copy
the reason.
ಕೊಟ್ಬಿಡಿ.
Copy. Give them one copy of the petition. My lord, this matter has been dealt in detail by the division bench of this honorable court, which has been held that such recoveries cannot be made. There is no whisper of even application having been filed. In fact, the court has ordered that the amounts must not only be refunded, but along with interest. Now, my lord, page number 56, the day of search, where they
Yes.
make this recoveries from me, in the reasons I clearly mentioned, payment against investigation initiated by DGGI. The next date of recovery also, I say GST payment against DGGI investigation. Now they are very unhappy that I make this as a reason. They issue summons to me and I appear in the summons where they pressurize me to make third round of payment, but this time to make a different reason, that is voluntary payment. I am myself reversing the input tax credit.
Third
Because
one is voluntary.
Third one is voluntary. Fourth also they do the same. Fifth, I do not want to.
Again voluntary, fourth.
Yes. Then I stop, my lord. Then I approach the court. Then, my lord, February of this year is the last summons that they had issued. There is absolute silence till I filed this writ petition. After I file this writ petition, they wake up and they issue another summons to me. Till then, no activities are happening. This is a manner in which they're conducting. I don't mind appearing, my lord. I am not even questioning the proceedings, which I will do during the time of adjudication and once I get an order. My only request, my lord.
Refund of the amount that is.
Yes, my lord. Yes.
Why so urgency?
And
In any
my
case, they will
lord,
get with interest later.
In
after
these
10 years.
matters, urgency is more, my lord, because it's illegally they're withholding my money. Why should I not be in
If the
an
proceedings
urgent-
are held as illegal, we will give it back.
No, recover, the amount that you have recovered
ನಾವು
is
ಮಾಡಿಲ್ಲ,
illegal.
ಅವ್ರು ಕೊಡ್ತಾರೆ.
Proceedings illegal ಅಂತ ಸ್ಟೇಜ್
ಅಲ್ಲ, ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ, ಕೊಟ್ಬಿಟ್ಟು ಅರೆಸ್ಟ್ ಇಂದ ತಪ್ಪಿಸ್ಕೊಳ್ಳೋಕೋಸ್ಕರ ಅವಾಗ ಕೊಟ್ಬಿಡ್ತಾರೆ.
Arrest ಇದಕ್ಕೂ ಸಂಬಂಧನೇ ಇಲ್ಲ, my lord.
ಅಲ್ಲಿ ಸಮನ್ಸ್ ಕೊಟ್ಟಾಗ
ಅದೇ ಬೇರೆ provision,
ತಪ್ಪಿಸ್ಕೊಳ್ಳೋಕೋಸ್ಕರ
ಅದೇ ಬೇರೆ.
ಕೊಟ್ಬಿಡ್ತಾರೆ.
ಇದು provision ಇಲ್ಲ.
ಆಮೇಲೆ ಕಟ್ಟಿದೀವಿ ಬಿಟ್ಬಿಡಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಇಲ್ಲ.
ಆಮೇಲೆ ರಿಟ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡ್ಕೊಂಡು ಬರ್ತಾರೆ.
ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಸಂಬಂಧನೇ ಇಲ್ಲ.
Take the copy, I'll take it on 11th.
Yes, my lord. My lord, another matter, serial number 114. Similar
Tag with-
subject can be tagged, my lord.
Tag with 11 ಅವ್ರೇನಾದ್ರಲ್ಲ ಮಧುನ
My lord, yes.
ಅದು ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಕೊಟ್ಬಿಡಿ.
Tagged, but I will serve
List
one more.
both in preliminary hearing
State, central, no? DGGI.
so that
My
he'll
lord,
go through it and come.
Can it be listed in orders, my lord?
Preliminary hearing.
Okay.
Yes.
Much.
On
My lord, my humble submission to this honorable court. My lord, may kindly verify form number GST form number MOV 11. My lord, the reason they have shown for the detention of the vehicle, page number
vehicle release ಮಾಡಿದೀವಲ್ಲ.
release ಮಾಡಿ.
Vehicle is released.
Yes.
You run the vehicle, we'll see later.
ಅಲ್ಲ,
My instructions are, my lord.
very small issues.
ಇರ್ಲಿ.
It is only based upon hearsay.
ಒಂದ್ ನಿಮಿಷ ಅವ್ರು ಹೇಳ್ತಾರೆ.
They have paid the entire amount and taken the vehicle and the goods and all.
We'll hear it leisurely.
My lord.
Order rightly or wrongly, an order has been passed.
Yes.
Tadari
It is open
We'll
for them
see,
to
we'll,
challenge it
we'll,
by way of an appeal.
yes.
appeal ಬರದೇನಿಲ್ಲ ಯಾಕಂದ್ರೆ 13/6 ನಲ್ಲಿ
No, appeal ಬರುತ್ತೆ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ. We'll hear it.
much
Yes, list after 2 weeks, interim order subsisting would continue till the next date of hearing. Faceless, huh?
Please, my lords.
Disposed? Same order. Where no merits order.
Can be
Those
different.
orders which I have passed in all 200 cases, same thing.
For this case, I'm happy, my lords.
Why, you want to say something else?
No, my lord, for a different matter.
Yes. Same order what Raviraj idalla madadnalla avatu. Faceless.
My lord.
It faceless alva?
Yes, my lord. JO versus
Serial number 104 also.
Serial number 104?
104.1 also, ma'am.
Oh, 104 both. 104, 104.1 and this 28. ಮೂರನೇ ಇರೋದು ಇವತ್ತು? Yes. ಅದು ಮೂರು ಬಂಡಲ್ ಜೊತೆ ಇಟ್ಬಿಟ್ಟು ಕಾಸ್ಟ್ ರೆಡಿ ಮಾಡಿ.
If my lords permit me, can I take the liberty? If my lords permit me, can
Yes,
I take
sir.
the liberty of mentioning two matters?
Yes, sir.
Which can be disposed of.
ಕೊಡಿ.
Serial number 83, my lords, I think it's become infructuous. Because we have nullified the demand and withdrawn, rectified the impugned order.
So,
Yes.
the learned, the petitioner is before this court seeking the following prayer. During the subsistence of the petition, the learned HCGP would, AGA would submit that during the subsistence of the petition, the grievance of the petitioner has been redressed by nullifying the demand. In that light, the learned counsel for the petitioner also would accept the same. Therefore, the petition is rendered infructuous and is to be disposed as having become infructuous. ಇನ್ನೊಂದು ಯಾವ್ದು ಹೇಮ
Serial number 56 ಅಲ್ಲಿ ಮೂರು matter ಇದೆ. 56, 56.1 and 56.2. These are all matters now, my lords, covered by the division bench judgment. Where, my lords, after the orders were passed, the petitioners are accepted the Karsamadan scheme and paid the taxes and got interest and penalty waived. Then, my lords, revisional authority has taken up it on revision, which is not permissible, my lords, and that view has been affirmed by the division bench.
I placed the division bench order, my lords, by way of a
Kodiyat.
memo. By way of a memo on 16th of July.
The petitioners in all these, the issue in all these cases are common. The learned counsel appearing for the petitioner submits that the issue in the list stands answered by the judgment rendered by the division bench in STA 8 of 2025, disposed on 18th June 2025. The division bench has held as follows. The reason in the court, madam.
Para 9 to 12.
9 to 12. The issue in the list is, as observed here and above, identical. The petitioners avail the benefit of Vivad, Karasamadan scheme and pay the entire tax. Notwithstanding this said payment, it transpires that proceedings were continued against the petitioners by a higher authority, deputy commissioner,
The joint commissioner.
joint commissioner. This, the division bench has in the aforequoted judgment held that such action is impermissible in law. In the light of the issue being similar, admittedly similar, and covered by the judgment rendered by the division bench on all its force, I deem it appropriate to dispose these petitions with the granting the prayers that is sought for by the petitioners. Allowed, quashed.
Sumoto revision proceedings were initiated by the joint commission.
Sumoto, notwithstanding the payment of tax, sumoto revision, sumoto proceedings were initiated. Revisional proceedings were initiated by the joint commissioner. Sumoto madi. Yenadu 30.
Revision proceedings, no?
Revision. The same matter, madam.
Kodi, Annamalai, Kodi. The petitioner is before this court seeking the following prayer. The learned counsel appearing for the petitioner submits that the petition be disposed in terms of an order passed by the coordinate bench in writ petition 8577 of 2018. 8577 2018, dated 29th October 2024. The learned counsel Shri EI Sanmati would not dispute the position as is laid down by the coordinate bench. The coordinate bench is held as follows, para 8 to the end, same order.
Can I make a request? Serial number 57 is similar matter to serial number 22.
20?
22.
Dispose madadva 22.
ಇಲ್ಲ ಅದು next speaking order ಹಾಕೊಂಡು ಅದು
It will come, don't worry. Yes.
It's one matter, serial number 85, covered by the DBA order. May I make a submission?
85? ಯಾವುದು?
Tirumalesh.
Yes, Tirumalesh sir. ಕೊಡಿ. Covered?
Please, Manoj.
ಇಲ್ಲ.
Covered. Please. May I take my lords to paragraph 2, my lords, page 3. Third point is that the notice was less than 7 days. Department went in appeal to the DB. Para 2 and 3 in the finding.
Not less than 7 days interpreted.
Yes, my lords. Yes. Para 5.
The petitioner is before this court seeking the following prayer. The issue, the issue revolves around the period of notice to be issued, which the statute mandates not less than 7 days. The issue is interpreted by the division bench in writ appeal 612 of 2025 in terms of its order dated 5th August 2025, while rejecting the appeal filed against the order of the learned single judge, which had favored the SSC. The division bench has held as follows, para 5 to.
My lords, 2 to 6, my lords.
2 to?
6.
Para 2 to 6. 6, ah?
Yes, my lords. 6 is the finding.
Para 2 to 6.
Yes.
2 to 6. Rightly held.
Para 4 is the section that may not be.
Para 2 to 6. Please. In the light of the learned counsel M. Tirumalesh would not dispute the position of law being affirmed by the division bench as it was set aside by the learned single judge. In the light of the issue standing covered on all its force to the order in writ appeal 612 of 2025, the petition deserves to succeed on the same lines, same order. Yes.
Annexure A to A4.
A to A4 cost.
Small indulgence. Similar matters on the same issue.
Division bench, ta?
No,
less than 7 days.
Yes, my lords.
Kodi. Ella list ಮಾಡಿಸ್ಬಿಡಿ. ಯಾವತ್ತು? Monday?
Any date it can be listed on.
ಎಷ್ಟಿದೆಯಪ್ಪ ಅದು ನಮ್ದು
Is there? Yes. I'll give you the list.
Please.
Yes, my lord.
Yes.
Item 78 is covered.
Both of you say it's covered, we'll close it.
I think so, because this morning what your lordship dictated in United Spirits, ITAT, order giving effect to time barred.
Yes.
So it goes back to the return position. They have adjusted the refunds of the subsequent year. That's the only issue. And your lordships, in fact, another matter, SICOM, which was heard couple of weeks back, have reserved that also.
ಯಾವ್ದದು?
SICOM ಅಂತ.
ನೀವೇ ಅಪಿಯರ್ ಆಗಿದ್ದ?
My friend appeared. Anyway, this USL, what your lordships passed in the morning, somewhat similar. I'll just point out the.
Raviraj held. Similar?
Almost, yeah.
Almost.
Yakandre, what we are saying is, my lord, the company got amalgamated so many times. And that's why, my lord, it could not be completed in time. That one point has to be noted. My submission has to be noted.
I will take it on Thursday.
Next Thursday.
11th.
Very good. Can it be in preliminary hearing or
preliminary hearing? ಯಾವ್ದು covered ಎಲ್ಲ preliminary hearing ಹಾಕ್ಕೊಂಡು ಈ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇವತ್ತು ಏನು covered ಇದೆ, give me a list. We'll all post it in preliminary hearing and close it.
Very good.
Yes.
82 and 81. 81. It is also covered. Learned friend also.
Not covered.
You want another date?
You want to keep it out, not covered.
Yes. M. Dilip. Covered.
Covered alla, it can be disposed, my lord. What has happened is.
ಇಲ್ಲ ಹಂಗಿದ್ರೆ ಕಷ್ಟ, then I'll have to. Covered ಆದ್ರೆ ಮಾತ್ರ.
ಇಲ್ಲ.
Both sides are saying covered and we'll do it. If it has to be heard and order to be passed, we'll continue the list later.
80 to 87 both covered yourself. Chinmay trust. Chinmay.
ಅದು ಕೊಡಿ, ಚಿನ್ಮಯ ಟ್ರಸ್ಟ್ ಇದ್ರೆ ಕೊಡಿ.
82 and 97.
82 and 87?
97 both.
82 and 97.
Madam, serial number 82 and 97. ಚಿನ್ಮಯ ಟ್ರಸ್ಟ್ ಅಂತ ಬರ್ಕೊಳ್ಳಿ. ಸೇಮ್ ಅದ್ರಲ್ಲಿ ಏನಿದೆ ಚೇತನ್ ಮಾಡಿದ್ದಾನೆ 3-4.
Serial number 16 yours done.
60 ಇವತ್ತು 16 ಇತ್ತಲ್ಲ ಸೇಮ್.
Serial number 93, my lords, is a matter challenging a 93. It's a matter challenging a notice under section 148. Amongst all the grounds, one of the grounds is that the notice is issued by the jurisdictional assessing officer and not the faceless.
Faceless. Faceless. One serial number?
93.
90?
ರವಿರಾಜ್ ನೀವಿದ್ದೀರಾ?
Please, my lord.
If it's faceless, close. Disposed.
Can I have liberty? But there was one matter at serial number 5.1 and 5.2, USL only. My lord,
We're dealing it.
right, my lord, I kept it on 11th. Instead of 11th, could it be on 18th?
Oh, can be, yes.
Obliged.
No, serial number 34 can be disposed. The matter, my lord, appeal is pending before the CIT appeals. My lord, identical matters, my lord.
Lava.
I am appearing for them. My lord, the matter is pending in CH appeal, my lord.
ಕೊಡಿ ಅದೇ ಆರ್ಡರ್ ಮಾಡಿ.
So till disposal of CH appeal, there is no recovery, my lord.
The petitioner is before this court seeking the following prayer. The learned counsel appearing for the learned counsel appearing for the petitioner submits that the petitioner has preferred an appeal before the
Commissioner of Income Tax Appeals, my lord.
Before the Commissioner of Income Tax appeals against the impugned action and the appeal is pending adjudication. The petitioner is before this court on a coercive action sought to be initiated notwithstanding the pendency of the appeal by ordering recovery. This court has, the coordinate bench of this court has passed protective orders granting stay of the impugned action. The learned counsel appearing for the petitioner submits that the coordinate bench in identical circumstances has passed the following order. In the light of and would submit that the issue in the list is identical. Learned counsel M.Y. Raviraj would not dispute the position as is considered by the coordinate bench and would submit that the issue is pending before the Commissioner of Appeals. In that light, I deem it appropriate to dispose the petition by the same or granting the same relief that the coordinate bench has granted in the case before it in writ petition so and so. Same order, yes. Please. Now the second list.
Actually, one matter to be remanded, your lordship, the council also is ready.
I'll just finish the second list and come back. Yes. ಯಾವ್ದು? Will grant, not a problem. 18th, same.
No, but there is one matter which I mentioned in the morning, which
had to be tagged with what?
With these 115.
Both will take it on that day then.
No, there is one slight clarity we need on the interim order which my lord had passed last time.
My interim order?
Yes, ma'am.
Which is that interim order? Just give it.
Just give it.
What have I done?
Hello. No,
clarified.
No, my lords, really, I want something to say. My lords, what happened earlier was this. Because there was an equalization levy. So I was paying tax by way of equalization levy. The department still said that you must pay tax, TDS should be done as if it's royalty. At that time, because both were being levied, what my lord said in the earlier order was that you continue to deduct tax as equalization levy at 6%. Now equalization levy has gone. So now there is no question of 6. Now it is either 0 or 10. So my lords, what my lords have said here is there shall be an interim order of stay as prayed for, which is nil.
What do you mean nil?
No withholding just now at this stage.
So we'll direct this, whatever the coordinate bench has granted.
No, but that was because I was paying equalization levy. That is. My lords, just bear with me, my lords, just see. My lords, just see the player.
No, the file is not before me. It's only the interim order. Well, we'll post it on 18th or 11th, whatever you want.
My lords, 11th, let's keep it on.
Let it be on 11th. Even we'll tag it with that. You said one
But
more.
I think
This is the matter, right?
Yes, but the ASG is not available on the 11th. That's why he wanted 18.
List the matter on 18th along with WP 24527 of 2025. No, that is what he is saying. Correct. 115 ಇದೆ ಇಲ್ಲಿ.
No, 6% because that was equalization levy was
Your file is here.
Yes, ma'am.
Yes.
My lord, we'll just see the prayer clause there. Just show me the prayer
clause.
You just see page 119, my lords.
No, come to 121. What is your interim prayer? Stay the operation of the impugn certificate so and so to allow the petitioner to remit payments to Google Asia Pacific without deduction of TDS.
Right. So that's what my lord has ordered.
Yes.
But my lord has also at the same time extracted from the earlier order where I was directed to pay 6.
Otherwise, I did not hear you. You said similar orders are passed by the coordinate bench. I have just said yes.
Yes, my lord. But I pointed out to my lords that
Your Lordship, one submission. If it is a fresh consideration of interim order, my lord, then ASG has to appear, my lord, because demanding, my lord, it is 36,000 crores, my lord, because of unavailability of ASG, my lord. A date may be fixed for consideration of interim prayer, my lord.
We'll pass this order. This court on 14/8/2025 had passed an order on the score that in writ petition 7093 of 2022, an interim order was passed. And the issue in the list was identical to what the court was considering in WP 7093 of 2022. The Learned Counsel EI Sanmati submits that the issue is not similar to the interim order at least. If the interim order as prayed for is granted, they would not be paying any amount as is necessary in law. He would submit that we were not heard on the interim prayer and it was not objected to as the interim prayer was granted on the score that the earlier interim order was operating. Therefore, list the matter on 11th.
18th.
What is till then nothing is going to happen.
No, I can't remit the money. That's the only.
That's okay. We will protect you later if it is. Which are those 4 petitions that I have already said tag along with?
115 serial number.
It's come, is it?
Please.
Tag along with so and so. List them all on 18th for consideration of interim prayer. Yes.
My lords, may I make a mention for item 117 in list 1, my lords? It's an interlocutory application only for modification of the interim stay order.
Modification?
My lords, what had happened, the AO has passed the final assessment.
No. That is, sir, modification of not our order. Yes,
so
second list. I'll get into the second list and come back. Yes.
All right.
Seal number 1 adjourned, seal number 2 orders.
On serving of KIDB.
My lord, in this case, records sent to forensic department.
List number 2 ಅಲ್ಲಿ ನೀವಿದ್ದೀರಾ?
ಇಲ್ಲ, ನಮ್ಮ ಕಲೀಗ್ ಸ್ಫೂರ್ತಿ ಅವರು ಇದ್ದಾರೆ, ಅವರು ಇನ್ನೊಂದು ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಆಯ್ತು. Non serving of copy. ಏನಿದೆ ಮೇಡಮ್?
Pray for 2 weeks time.
List after 2 weeks needful to be done by then, interim order subsisting will continue till the next. Yes.
Oblige, my lord. Number 3.
Finally, 10 days time is granted to do the needful, failing which the interim order, if any subsisting, would stand automatically vacated. Next.
Number 4.
Withdrawal.
5.
Petitioner, my lords. Short question, my lords. This is a matter where the trial court, my lords, recalls the order when the matter was listed for judgment and permits the respondents to file the written statement, my lords. In doing so, my lords, ignoring the statements made in the affidavit of the applications, where the defendants clearly state that they were aware of the matter as early as August 2024, and yet they wait till.
Why has it come in orders now?
I may be permitted to file my objections
Learned
to the petition.
counsel for the respondent seeks 10 days time to file statement of objections.
May I make one submission, my lords? They are needlessly protracting the proceedings. My lords, after taking leave of this honorable court, my lords, I had served the counsel on record in the trial court on 28th of July itself, my lords. And yet they don't appear before this honorable court when the matter is again listed, my lords. Subsequently, there is again notice issued to be served on the respondents, my lords, through the trial court. Subsequently, they come on record here, my lords. The only question here is.
There's an interim order.
There is, my lords, the
List the
proceedings
matter
also.
on
May I have it on 8th, my lords?
24th, yes, no.
My lords, may I have it on 8th, my lords, because the matter is on 11th of, on 9th, my lords.
Which court is taking the matter despite my interim order?
I have not sought for stay, my lords. What has been stayed is only.
Stay is
the cost.
granted.
Yes.
On the costs, my lords. The costs were imposed, my lords. What the learned trial judge, in fact, imputes a fraud on me, my lords, for not serving them when they were aware of the matter.
Oh, it's service matrana idu.
ಹೌದು ಸ್ವಾಮಿ, ಸರ್ವಿಸ್ ಮಾಡಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
The contention of the petition.
You urge everything there.
My lords, it was already urged, my lords, and also the order was passed. What happens, my lords? The petitioner herein, my lords, one day he seeks the court's order, seeking that he will serve it through the hand summons.
We'll take it on 10th. List on 10th.
My lords, 10th is a little inconvenience, my lords. Any date on 15th or
At 12th, yes.
My lords, 12th also I won't be.
Then we'll stay covered, my lords. It's in fact covered by another judgment.
List, when do you want, madam?
My lords, on 24th, my lords, I want.
List the matter on 24th. Further proceedings before the concerned court shall remain stayed. Yes.
Still number 6.
Two weeks time to do the needful. Next.
7.
Let's send for the petitioner in this case.
Furnishing FPF.
It's my, but one of the lords, I'll be the petitioner and respondent in the, for number 4 in the first petition.
Non-compliance of office objection.
That's in my case, my lord, there are nothing.
Interim ಮಾಡಿದ್ರೆ ವೆಕೇಟ್ ಮಾಡ್ತೀನಿ. ಅವ್ರದ್ದು ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ನಿಮ್ದ್ರಲ್ಲಿ ಏನಿಲ್ವಾ interim order? ಇನ್ನ ಇಲ್ವಾ? ನಿಮ್ದ್ರಲ್ಲಿ ಇದೆಯಾ?
ಇಲ್ಲ, ನನ್ನ ಬೇಡ ಅಂದೆ ಅವತ್ತು last time.
Then what's the issue?
My submissions are that certain monies are deposited.
Before that, I want to make some other submission.
ಓ ಇದು ದುಡ್ಡು ನಿಮಗೆ ಬಂದಿಲ್ಲ ಅಂತಂದು. Yes.
This matter, my lords, writ petition is directed against trial court, which, my lords, rejected their application for withdrawal of the rents, because this honorable court on an earlier occasion had directed it to be deposited as rents. They wanted to remove it as damages. The matter came up before your lordships. We ourselves, my lord, suggested that we will try and negotiate for a settlement. Ultimately, it's a tenant. We are joint. There is a joint development agreement. Matter was referred to arbitrate. But I want to point out this: before the honorable arbitrator, my lords, we had filed an application for attachment of this money. But I said, matter is before your lordships, number 1, and the honorable arbitrator suggested that this is a fit case where you have to sit down and resolve the issue. We both of us agreed that we will do so, and thereafter, my lord, I am told parties have met and held a preliminary round of discussion, and it was deferred for further discussion. That are my instructions. My learned friend also participated. Of course, I was not there. So my learned friend must make it clear whether, my lord, they want to negotiate or they want to argue on merits. Not only this, there are larger issues. The reason is this one. But on one hand, we are given an impression that matter will be resolved, so we lower our arms, and we don't. This at one stage,
For the
this
moment,
would be.
my lords,
One
all my
nimsham, sir.
weapons are inside my lords.
Wait, sir.
We owe, my lord, according to me, more than anything, as much as, my lords, to your lordships, our duty to your lordships, also to our clients, where our sane advice is to resolve the issue. That was my impression. If but my learned friend must make it clear that talks have broken down, they are no longer interested, there is no difficulty. If he says parallelly we will do it, not, I have my own views to be expressed before.
Look, we have laid down our. ನೀವು ಮಾತಾಡ್ತೀರಿ? ಮಾತಾಡಿ. ಇಲ್ಲ ನೀವು ಮಾತಾಡಿ, ಅರ್ಜೆಂಟ್ ಅಲ್ಲಿ ಇದೆ.
ನೀವಿಬ್ರು ಡಿಸೈಡ್ ಮಾಡಿ ಅಷ್ಟು ಅರ್ಜೆಂಟ್ ಮಾಡ್ತೀರಿ.
May I submit?
ಯಾರು ಮಾತಾಡ್ಬೇಕು ಅಂತ ಡಿಸೈಡ್ ಮಾಡಿ ನಾನು ಅರ್ಜೆಂಟ್ ಮಾಡಿರ್ತೀನಿ.
May I submit?
ಪೇಲೆ ಆಪ್ ಆಗಲ್ಲ ಇಲ್ಲಿ.
Like Mulats was suggested, Mulats, the media negotiations are going on as one aspect of the matter. Mulats, here is a situation where this honorable court has directed, please, Mulats, that the damages or the
ಅವ್ರು
rents.
ಕೇಳಿದ್ ಎರಡೇ, ನಾವು ಅದನ್ನೇ ಕೇಳ್ತೀವಿ. ಸೆಟಲ್ ಮಾಡ್ಕೊಂತ ಇದ್ದೀರಾ? ಸೆಟಲ್ಮೆಂಟ್ ಟಾಕ್ಸ್ ಇದ್ದು ಡೋಂಟ್.
I'm not precipitating on the order. All I'm requesting, my lords,
Settlement is not one piece, it is whole hog.
Correct.
If you are settling whole hog, don't try to hog something else.
Hold on, please, my lords. My only endeavor is only this much. ಈ ದುಡ್ಡು ಇರೋದು ನಂದು, ನನ್ ಭಾಗಕ್ಕೆ ಬಂದಿರೋದು ರೆಂಟ್ ನಾನು ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ ಬಿಡಿ.
These are all matters which will be resolved.
18 ಇಂದ ನನಗೆ ದುಡ್ಡಿಲ್ಲ.
This is also an issue which will be resolved.
What they have deposited,
See,
my
we are
lords,
only, 1 minute, we are only hearing on the periphery,
Please,
on the ground, that all of you are wanting talks of settlement to be taken forward. At the same time, there is an order of the coordinate bench saying rents, you are entitled to receive the rent.
Yes, my lords.
Correct? When you are entitled to, when they are entitled to receive the rent.
Court said, directed them, but what has happened is not, he refuses to.
This is MI around on the order.
Court says, deposit as rents. No, he says, I do not want to receive it as rents. I don't recognize him as my tenant. I'll receive it as damages. Court says, no, either you take it to, even I'm saying today, please take it.
The question is,
how can it be damages? How can?
now, my lords,
Even we have no objection. Anyway, my lord, this.
Even before the suit is filed, we send them the money. They return it with a DD, with a notice that is not brought to your lordship's notice.
ಆಯ್ತು, ಇದು ಸೆಟ್ಲ್ ಮಾಡ್ಕೋಬೇಕು.
ಸ್ವಾಮಿ,
ಡ್ಯಾಮೇಜಸ್ ಅಂತ ತಗೊಂತೀರಾ?
Damages.
ನಾನು ಲೀಸ್ ಡೀಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿಕೊಟ್ಟಿಲ್ಲ. In the absence of.
Then let them not, let that issue be decided.
Which is played by the other side, excluding Mr. Nawadji's.
ಮೈಕ್ ತಗೊಳ್ಳಿ ಸರ್.
This is what has happened in my lords is, we had tendered a property for joint development. Now, my lords, the property which has to be allotted to the share of the landowner, my lords, is also, my lords, leased out and let out by the developer, my lords, in favor of certain third parties. Now, my lords, the third, yes, my lords, this.
ಅಲ್ಲ ಮನೀಶ್, ಇದು ಯಾವ ಧಾರವಾಡದಲ್ಲಿ ಕೇಳಿದ್ ಇದೇನಾ?
ಇಲ್ಲ.
My lords have already rendered one.
ಓ, ದಟ್ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಕೇಳಿದ್ ಇದೇನಾ?
Yes, my lords.
Case arising.
And my lords, now
that
what happens
software
is.
company ಇದು. Yes, sir.
Now, my lords, after that, after everything, my lords, now, the other side, my lords.
I have held 406 would, on the face of it, get attracted.
And my lords,
Same case is it?
same case, my lords, same case. They collect rents at hourly basis. They don't disclose that to the court. My lords, the court has said, deposit
we
everything.
work ಕೊಟ್ಟಿರೋದ ಇದೇನಾ?
Smart post basis.
Yes, anyway.
Smart. Now, my lords, everything is being collected. Accounts are not being rendered. My lords, settlement will always happen when, my lords, there is some parity or
So there I
equality.
have held. ಇವ್ರ ಶೇರ್ ಸೇರಿಸಿ ರೆಂಟ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀರಾ?
Put it there. This is something where.
No, that's what prima facie I have held in that criminal case, if I am.
Of course, not wrong. I am very confident that I could, in the writ side, I'll be in a position to persuade your lordship to hold it otherwise, and I am very confident. But if given a chance, but my lord, I felt, my lords, I felt, and in fact, the arbitrator, in fact.
Now you do one thing. You take the rent.
Yes.
Whether it is damages or not, we will decide later.
No, my lord, the difficulty.
You are the landowner. Sorry, you are the joint. With you is the joint development agreement. Correct.
Sorry, I'm sorry.
Joint development agreement is entered to with you.
Yes. I'm the developer. I'm the developer.
You are the developer.
But I am the developer. All that I'm saying before your lordship is, the terms of the dispute is this one. Ultimately, the dispute boils down to this. The dispute is.
No, this is the case where it was divided into 24,000 square feet into 3. And you sold off all 24.
No, we did not, my lord.
ಅಲ್ಲ ಇವ್ರದ್ದು ಸೇರಿ ರೆಂಟ್
No, we
ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀರಾ?
did not, my lord. We did not. He has entered, he has signed. Now the question is this, my lord. But we wanted, I do not know why my lord
Hey,
is laughing.
Manish.
Is it some joke going on? I don't understand. No, these.
Yes, sir.
You
carry on.
I will restrain myself. I will restrain myself. Lords, this is not he had in fact signed a lease agreement, but the dispute between the parties boils down to only this one. They accept them as the tenant, the matter goes on. This is the stage where lords, we have reached for a negotiation.
Now the issue is, sir, according to what I've correctly heard, now they are prepared to deposit the rent.
They are depositing.
You have deposited the rent. Now he wants to withdraw the money, not recognizing him as a tenant, but on damages.
Correct.
Whatever method, let him withdraw, subject to the outcome of the suit of his description, whether he is a tenant or he is paying
Nothing
damages.
pending, no suit is pending regarding this. There is no suit.
But what is pending?
No,
now?
the arbitration is pending.
In that arbitration, we'll leave it to the arbitrator to decide.
Please.
The suit is pending.
No, his suit is not about a tenant landlord. That question, lords, is before the arbitrator. The arbitrator, the question where he claims damages against us. That is the larger issue, which is. But if he is, the difficulty today is this one. He has to make his stand very clear. Either he recognizes them as a tenant and then collects because he has made a claim against us and he has made a claim against them. And as on today, the reason is not as on no, there is some difficulty. But 8 crores. But as on today, there is a GST liability on that building to the extent of 8.5 crores, which he's bound to pay. This is one of the terms of settlement. No, it's one of the terms of the settlement. 8.5 crores. Rent, I have no objection. 8.5 crores. The problem will be, I will have to pay. I don't mind. In the rentals, whatever he's getting, 8.5 crores may be set apart for GST amount. Let him withdraw. But that will be the counter proposal I have. 8.5 crores.
In the event I sell my share of the property, I have not sold 1 inch of the share allocated to me as per the terms of the sharing agreement. Now, if they insist, what I have suggested is GST, they are insisting some GST. I have suggested our chartered accountant and their chartered accountant sit across the table. Our chartered accountant says no GST. They are insisting.
No, but we will see that.
What I have said is that you isolate it, you keep it aside.
ಈಗ ನಿಮಗೆ ರೆಂಟ್ ಮನಿ ಡೆಪಾಸಿಟ್ ಆಗಿರೋದು ಬೇಕಾ ಬೇಡವಾ?
ಅಷ್ಟೇ ಬೇಕಾಗಿರೋದು.
ಅದರಲ್ಲಿ ಬೇಕಾದ್ರೆ ತಗೊಳ್ಳಿ, ಬಟ್ ವೆದರ್ ಇಟ್ ಇಸ್ ಡ್ಯಾಮೇಜಸ್ ಆರ್ ರೆಂಟ್, ಲೆಟ್ ಇಟ್ ಬಿ.
But I will be making one request. Lordships may have to use. The reason is this. The reason is this. No, I have 8.5 crore. Let them. In fact, not the entire issue will get resolved.
Settlement adre.
Not necessarily. If this lordships, whatever lordships are suggesting, we will also agree. If Malad friend is now saying that chartered accountant 8.5 crores or whatever, the end of that, the whole thing is over. Nothing else. There is no other dispute. So the arbitration could be resolved. This is all the dispute. ಈಗ ಅವರು ರೆಂಟ್ ಅವರು ರೆಂಟ್ ತಗೊಳ್ತಾರೆ ಟೆನೆಂಟ್ ಕಡೆಯಿಂದ. GST amount ಕೊಟ್ಟರೆ ನಮಗೆ we have no
of the mic. I'll say one.
There are 2 parallel proceedings. That is the difficulty. On rents, there is.
This will be totally unfair and unconscionable. Unfair and unconscionable. ನಮ್ಮೇಲೆ GST liability ಹಾಕ್ಬಿಟ್ಟು they take the tenant.
He is one of the brothers. Now I am speaking independently of the other brothers. Now my respectful submission is whatever GST they are contending, please not that I have to pay. I will keep it in deposit, please not before the registrar. The balance amount I may be permitted to withdraw as.
Allah register. GST will take it on me. We will not. No. I'll just put it. ಆಯ್ತು. Now this proposal.
ನೀವು ಒಂದು ಕೆಲಸ ಮಾಡಿ, ಮಾತಾಡ್ಬಿಟ್ಟು ಟ್ಯೂಸ್ಡೇ ಬನ್ನಿ.
ಅಲ್ಲ ನನ್ನ ಪ್ರಕಾರ if
1 minute, as Prabhu sir said, everything gets settled if you sit and settle.
We are trying. We have passed on all our contentions. We have told them all our conditions. They said they need to.
If both of us don't go, it will get settled. In a lighter manner.
Correct. Doubt illa.
Lawyers don't go, it will settle.
Lawyer ಹೋಗಿಲ್ಲ unfortunately.
ಅವ್ರು ನಿಮ್ಮ ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ.
ಯಾರು ಹೋಗಿಲ್ಲ, ನಾವು ಯಾರು ಹೋಗಿಲ್ಲ. ನಾನು ಎಲ್ಲ ಹೋಗಿಲ್ಲ.
If I don't come, let me be up in arms. I have seen that. I don't know. Serious counsel was not there. Get at the fistic of blood. I have to just maintain all of it.
ಓ ಅದಕ್ಕೆ ನೀವು ಇರಬೇಕು ಅಂತ.
This is not to such a.
What my
Of course. When
ammunition only fisticuffs.
No, when money is involved, all these come.
2018 earlier we were getting 15 lakh rent from our property.
ಇಲ್ಲ ಅದು ಗೊತ್ತು. This case I remember. No, this case I remember in Dharwad. I had heard it last year. Yes.
But that was in a different context, my lord.
Same ಎಲ್ಲ.
That is different, my lord.
Same parties. ಅದು 406, 420 ಅಷ್ಟೇ ಇದ್ದಿದ್ದು.
Anyway, my lord, I will
One
not.
last
request.
All
request
right.
is there, my lord. The tenant had to,
The trial court is going to, wants this matter to go on.
Huh?
In spite of the fact that
Witness.
we are negotiating.
No, you negotiate. I will stay further proceedings. I will call it on 16th. ಅಷ್ಟರಲ್ಲಿ ನೀವು ಮುಗಿಸ್ಕೊಳ್ಳಿ ಎಲ್ಲ.
there's one last request, my lords, if the other side can also come on time. My lords, the lease is given effect to by the developer, my lords, in the month of Feb 2023. That is when the rents fall due. But my lords, the court has said you deposit from 1/4/24. There is a 14-month.
ಅವತ್ತು ನೋಡೋಣ.
So my lords, I think that if
ಈಗ ನೋಡ್
we are starving, my lords, that's all.
starving.
We are starving.
Oh.
We are starving, my lords. If something can be done about it, I think the settlement, my lords, will come to. It'll all come on to the.
So you want to harvest on starvation. Yes.
No, 16th.
16th. Yes.
But we have given a proposal, there is nothing come up.
List on 16th. The learned counsel appearing for the parties would submit that the talks of settlement are afoot AFOT and would seek 10 days time to place any kind of settlement. In the event no settlement would come about, the issue would be answered on its merit. Till, in the light of the settlement talks pending between the parties, the further proceedings before the concerned court shall remain stayed.
Not a prayer by anybody, but I leave it to you.
No, there is nothing.
Trial court is insisting.
No.
Not a prayer.
It's all right, my lord.
ಅಲ್ಲ ಹಿಂಗ್ ಮಾಡಿ ಸ್ಟೇಟ್ ಬೇಡ. In the light of the settlement.
7.1 ಅಲ್ಲಿ 7.1.
ಅದ್ರಲ್ಲಿ ಇದೆಯಾ? ಒಂದರಲ್ಲಿ ಇದೆಯಾ? ಒಂದರಲ್ಲಿ ಇದ್ರೆ ಸರ್. ಎಸ್. ಇರ್ಲಿ ಬಿಡಿ. 16th ಹೇಳಿದ್ ನಾನು. ಲಿಸ್ಟ್ ಆನ್ 16th. ಎಸ್.
16th is Tuesday.
8.
Milords,
Oh, ಇದಲ್ಲ. That
26 Rule 9 petition.
my order. Now what is to be done? We'll send it back.
Because the first matter has to be sent back because strictly on merit ಅಂತ ತಾವ್ ಹೇಳಿದ್ದೀರಾ. ಅದನ್ನ strictly on merit ಅನ್ನೋದನ್ನೇ law ಅಂತ ಹೇಳ್ಬಿಟ್ಟು court pass ಮಾಡ್ತಾರೆ.
Illa,
So
no,
it says it
Milords,
doesn't want to discuss
both
on
these
merits.
petitions are mischievous interpretation of your Lord's order as well as the trial court's order. I'll run you to that order, Milords. Initially, order 26 Rule 9 was filed for appointment of a court commissioner to evaluate
I
whether.
know, sir. This is what I have held already.
Please, my lords had passed an order. They are interpreting in a manner that suits them to protract the proceedings.
ಈಗ ಏನಲ್ಲ ಈಗ what is the present
But
improved
now
order?
what the trial court has done is, trial court has passed an order where they have appointed Tahsildar to take out the commission work.
First matter is with regard to values. First matter.
Illa, 21514. If that is the first matter, 21514.
No, first one is I filed first one is 21514.
Filed first one is 21514. Here, my lords, they are challenging an order where they have filed an application to modify the order. That order is what, my lords, is trial court has appointed Tahsildar to carry out the commission work. Now, what is that commission work? To evaluate where the Kaludari runs through, whether that's all. They are saying no, Tahsildar should not be appointed, but ADLR should be appointed. Now, that is the discretion of the trial court that has to be exercised.
ಸರ್ವೆ ಕಂಡಕ್ಟ್ ಮಾಡಕ್ ಹೇಳಿಲ್ಲ.
Please.
ದಾರಿ ಇದೆಯೋ ಇಲ್ವೋ ಅಂತ ಯಾರು ಬೇಕಾದ್ರೆ ಹೋಗಿ ನೋಡ್ಕೊಂಡ್ ಬರ್ಬೋದು. ADLR ಹೋದ್ರೆ ಸರ್ವೆ ಮಾಡಕ್ಕಲ್ಲ ಇರೋದು. My order is not that at all.
Please.
Very much. But even otherwise, my lord, section 18 of Karnataka Land Revenue Act.
ಏನು?
Section 18 of Karnataka.
ಏನು?
My lord, it appoints to the competent person to survey. Competent person.
ಈಗ ಯಾರನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡಿದೆ ಸರ್?
Tahsildar.
ಸರ್ವೆ ಅಲ್ಲ ಈಗ ಹೇಳಿದ್ದು. ನಾಟ್ ಫಾರ್ ಐಡೆಂಟಿಫೈ ಅಷ್ಟೇ. ಬೌಂಡ್ರಿ ಅಲ್ಲ. ಕಾಲುದಾರಿ ಇದೆಯೋ ಇಲ್ವೋ ಅಂತ ನೀವು ಹೋದ್ರೂ ಆಗುತ್ತೆ, ನಿಮ್ನೆ ಅಪಾಯಿಂಟ್ ಮಾಡ್ಬೋದು.
What happens here is he has to identify the boundaries and the way it is passing through. So for that reason, we have asked for it. Even Tahsildar can be appointed, but both are contemporaries, my lord. The only thing is.
Then what is the difficulty?
Both are contemporaries.
Yes, ma'am.
ತೊಂದ್ರೆನೇ ಇಲ್ವಾ?
ತೊಂದ್ರೆ ಇಲ್ಲ.
ತಹಸೀಲ್ದಾರೇ ಮಾಡ್ಲಿ ಬಿಡಿ.
Please. But ADLR is the
No. ಇಷ್ಟಕ್ಕೆ ಇನ್ನೊಂದು ರಿಟ್ ಪಿಟಿಷನ್ ನಾ?
in light of section
What,
18
sir?
of.
The petitioner is before this, ಯಾವ್ದು first ಯಾವ್ದು ಹಾಕಿದ್ ನೀವಾ?
21514.
The petitioner is before this court calling in question.
Only one submission.
ಹೇಳಿ ಸರ್.
Since competent authority is there in the KLR Act, this is my contention.
Tahsildar also can do it. It is only for
Tahsildar also can do it.
identifying the thing. He will let him take assistance of anybody. Why are you worried? Yes. The petitioner is before this court calling in question an order dated 5th August 2025 passed in Commercial OS 119 of 2021. The companion petition, adena?
Illa, companion petition is 25227.
Alla, aden challenge adralli.
In this, my lord, what has happened is they filed an application for violation. There was 2 applications. The same were disposed of by this honor, your honor. Thereafter, my lords, we made a submission and spoken to Antali, page number 1.
Correct. How the ADLR antene ಹೇಳಿ.
ADLR antine. The second para reads like, insofar as the relief of value construction is concerned, the petitioner is at liberty to file fresh application before the concerned court and concerned court to answer the same in accordance with law strictly on merit.
Please.
Strictly on merit.
Pursuant to that, I have filed an application for appointment of.
ಮುಗಿಸ್ಲಿ ತಾಳಿ.
Please.
Thereafter, my lords, kindly produce page number 25, para 8 of the impugn. I have taken a contention that there is the plaintiff himself has filed PW2, independent valuator, approved government valuator, and his report is placed on record. Now I took a contention, I took objections regarding the same. The court, what the court says, para 8, my lord. Now it is settled position of law that even for collection of evidence, commissioner may be appointed. When there is specific direction from the Honorable High Court of Karnataka to appoint commissioner, much discussion is not necessary to determine. Well, that's what happens, my lords.
I'll answer it.
Let him finish.
When this court says strictly on merit, the court thinks that is law. So once this order, this court says you consider the application strictly on merit. Where is the discussion of my objections? I have raised an objection that PW2, independent witness, during the course of trial, he is a valuator, he is given an enormous valuation report and marked exhibit P330. I have not raised any ambiguity. If I had raised any ambiguity or if I had contended otherwise, if I had taken the PW2 through a course of cross-examination saying, this report, this valuation you have given me wrongly, this is not the work, this is you have hidden it. I have not created any ambiguity regarding the same. I have produced the cross-examination. Now, what happens to that? Now, the concern is when the court has to go on merit, how can the court write such an order saying the High Court has passed a law?
That is why I started by saying it is mischievous interpretation of the trial court's order. Now, my lords, they pointed out para number 8. If my lords would kindly see para 2.
Para 2.
Para 2 of the order, my lords. Last but 6th line. In the writ petition 27706 of 24, the Honorable High Court of Karnataka, Bangalore has granted permission to file fresh application seeking appointment of court commissioner. Hence, he has filed this application. There is no ambiguity in the court's mind that my lords have directed them to appoint a court commission for valuation. It is only to the limited extent of the liberty was given to me to file an appropriate application. Likewise, it has been recorded. Now, why this para 8 has come into the picture is, please see paras 6, my lords. Sorry, para 5, reasons. I had produced 2 judgments, my lords, to assess the court. Now, the court was considering those 2 judgments in here. May I read, my lords? Learned advocate for the plaintiff submitted argument stating that to ascertain what is the cost of construction of the warehouse, he has filed the annexed application seeking appointment of the court commissioner. He relied upon the citation so-and-so, classic infracon Bangalore so-and-so, relying upon so-and-so. It is held that court commissioner may be appointed to avoid miscarriage of justice. Per contra, learned advocate for D1 submitted arguments, that is their arguments. Now, para 7. It is true that previous application filed by the plaintiff seeking to appoint court commissioner came to be rejected by this court. In the writ petition preferred by the plaintiff to test upon the said order, Honorable High Court of Karnataka set aside the order directing the plaintiff to file fresh application. This para 8 came into the picture only with reference to the judgment that was produced by me to assist the court, because in that judgment, the High Court, it was a coordinate bench judgment only, my lords, where the High Court had directed the trial court that you please appoint the court commission for valuating the property. In that judgment as well, a report was already filed by the plaintiff, but only to assist the court, a subsequent 26 Rule 9 application was filed. And on the premise that substantial court fee was paid to seek damages, court commission was appointed. So that direction
the report
is
of the commission
here.
was already there pursuant to the order.
No, my lords, it is an independent valuer's report that I have filed. Now, just to get a bird's view of the things, I have moved an application for appointment of court commission.
For valuation.
For valuation, valuating the property. that is in no way prejudicing the other side, my lords.
Yes, sir.
Have any objection with regard to appointing of valuation if it is on merit or on in accordance with law? Now, what happens, my lords, this judgment, what they had cited before the lower court, was with regard to a tenant and damages occurred.
No, you forget that.
is a different
You
thing, my lords.
forget that. Now, valuation also will be done, and whatever the Kaludari's measurement also will be done.
Please.
That
Then what happens with regard to the already existing evidence of the plaintiff side, as well as the documents and the valuation report?
With-
Well, let's know what happens, my lords, if the valuator gives a lesser report.
now you
If
don't want the
the-
don't want the valuation to be done again.
Well, lords, I want to have a clear clarity with regard to the evidence of the plaintiff.
Lords,
He
in
cannot have two mangoes in the same.
Suit is for injunction.
Suit is for damages.
Recovery and
Damages,
damages.
recovery and
damages.
damages.
Damages and recovery, madam. I have no, because it is his case, he has to demonstrate his case. He has already demonstrated. What happens to the evidence of PW2 as well as exhibit P330?
The court will look into everything at the time of passing the order. Now, the court commissioner who is appointed Tahsildar, he will go and measure the property or whatever it is. And the valuation that is already there, paragraph 8, I don't think is,
What happens, this will give the courts will take a liberty that merit mel maadi andre ade law anta.
ಇದು court ನಮ್ಗೆ
That is why I started with it.
merit andre ille neltare ade
They are interpreting in the wrong way.
No, ಈಗೇನು ವಾಪಸ್ ಕಳಿಸ್ಬೇಕಷ್ಟೇ. ಮತ್ತೆ ಸ್ಯಾಟಿಸ್ಫೈಡ್ ಮಾಡಿ ವಾಪಸ್ ಕಳಿಸ್ಬೇಕು. Only in so far as that finding is concerned. But otherwise, court commissioners will go on.
My lords, but the court is referencing to the judgment that I had produced. It is not because the clarity is already given in the preceding paragraphs. One minute, sir.
We'll do one thing. We'll decide all your suit here itself. ಅಲ್ಲೇ ವಿಡ್ರಾ ಮಾಡ್ಬಿಡಿ ಎಲ್ಲ. ಇದೇ ಕೆಲಸ ಆಗೋದು. Yes. List on 10th. Interim order subsisting will continue till the next date of hearing.
I was present. ಈ matter interim order extension
ಆಗಿಲ್ವಾ ಈಗ?
ಆಗಿದೆ ಅನ್ನೋ ನನಗೆ ಗೊತ್ತಿಲ್ಲ, ನಿನ್ನೆ ನಾನು
Don't.
9.
Great. My lords, my apologies. I am just objections. Where is the objections? Objection. Where is the objections? No man, it is in this. My lords, my statement of objections in 21514.
Registry file ಮಾಡ್ಬಿಡಿ. What is this now?
The application under Art 21 Rule 97 is summarily rejected by the trial court.
Without enquiry na?
Without inquiry.
ಅಷ್ಟೇ. Yes, sir.
ಅದರಲ್ಲಿ
Covered by the
ಕೊಡಿ
judgment of the
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ವಿತ್ ಎನ್ಕ್ವೈರಿ ಮಾಡಬೇಕು.
my humble submission is whether the writ petition would be maintainable against.
Exactly. Without enquiry, either writ petition is maintainable.
Now,
if on consideration after conduct of an enquiry ಆಗಿದ್ರೆ appeal is maintainable.
Now I'll make only one submission.
Yes, sir.
What has happened is the vendor's predecessor entitled, the donor of his vendor, had already alienated the property in 1986.
And the merits are
That
No,
merit,
there is not right.
that's on merit,
On
sir.
the factual
You
aspect.
filed an application under what, 2197?
Yes, please.
Where is the order passed?
Art impugned order at page 18 minute.
18.
18.
Please
Trial
make
court
one
at
submission.
para
my
number
lord.
22 minute. At page 32, para 22 of the internal page. In page 32 minute.
ಅಲ್ಲ ಎನ್ಕ್ವೈರಿ ಮಾಡಬೇಕು ಅಂದ್ರೆ ಎವಿಡೆನ್ಸ್ ಆಗ್ಬೇಕು.
ಹೌದು.
ಇದರಲ್ಲಿ only one submission.
Decree which is sought to be executed.
No, one minute. It has a rationale. See, if 2197 is to be construed to a decree separately which can be challenged in an appeal, it should be in accordance with law. Accordance with law is enquiry should be there, evidence should be there, because it takes the partakes the character of a decree.
Now, only two submissions I would make in this matter is, he already files a suit for declaration of title and also questions the very decree where he files.
ಅದು merits ಮೇಲೆ.
No, it's separate suit, declaratory suit.
Maybe that does not stop the court considering 2197.
And under section 10, can a trial be held in the subsequent suit where it's substantially in issue in the first proceeding?
It is a different thing, sir. We are on 2197 application. ಈಗ ಅಪೀಲ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತೀರಾ?
No.
ಅಪೀಲ್ ಹಾಕ್ತೀರಾ? ಅಪೀಲ್ ಇದೇ ಹೇಳ್ತೀರಾ?
appeal, my lord, my humble submission. The
Appeal is a continuation of proceeding, everything can be heard.
Second aspect of the matter I'll submit, my lord. There are certain suits which are coming before your lordships, which are decreed under order 12 rule 6 based on admission.
Correct.
These are without, under orders 8 rule 10, without inquiry or on admission, it has been decreed. In whichever form the suit is decreed, what lies is an appeal.
1 minute.
They cannot come under writ petition because the inquiry is not held, the writ petition could not become
12 rule 6 definitely is a judgment on admission. There is evidence is not necessary there because it is based on admission. Defense is not projected at all. That stands on a different footing.
Default, it is appealable, my lord.
It is
Even under order 9 rule 9, if I not exercised my powers under
9 rule 9 again is a different aspect,
Yes.
sir, but it is closed on an earlier proceeding.
If it is dismissed for default also, it's an appealable order.
It is dismissed for default and you don't divulge that and proceed, file another case.
Mr.
9 rule 9
Larius, I
applies.
have to file an appeal. 9 rule 13 also I have to file an appeal.
No, this-
8 rule 10 also I have to file an appeal.
Para 26 and 27 is very clear.
No, inquiry may be required.
Yes.
I'm not against the fact that an inquiry will be required because adjudication of all rights between the parties has to be adjudicated under Rule 101.
No,
My humble
because
submission is
2197 is a decree by itself.
if prima facie, looking into the records, court comes to a conclusion, the person who is claiming has no right at all in respect of the property. And the coordinate bench
All
of
right,
this honorable
one minute.
court has
How
said.
does the court come into conclusion?
Now, based on the court comes to the conclusion.
Sir,
and-
one nimsh.
one nimsh.
How does the court come to conclusion?
Court comes to the conclusion on the basic fact
On
that his vendor
generally, if court comes to the conclusion that
on
way,
admitted facts. On admitted facts and record. In 1986 itself, a property has been sold to the judgment debtor. Now in 2003, they say that he has gifted it to his wife. They say, well, he did not have title or possession.
Right.
What is there to be inquired? And even in this writ petition, they did not disclose that sale deed has happened. They do not challenge
have
that sale.
produced.
1986 sale deed is not produced, sir. Sorry.
Anyway.
It is not produced. They do not disclose that alienation at all. And they have not questioned that alienation. And since there was neither title nor possession by the person who is perpetrator was alienated in favor of the petitioner.
And in my
There is
suit,
no right.
there is an interim order not to alienate by the same court. There is an interim order operating. Still the same court pass an order in the execution appointing the court commissioner to execute
but
the
that is on the merit of the matter, Anil.
Yes, my lord.
Now the problem is with regard to non-conduct of admittedly inquiry is not conducted.
No.
Admittedly, inquiry is not conducted. Not conducted.
And inquiry is a must for a determination.
Can there be a second inquiry on a declaration suit? Earlier, the instituted suit, same issue is involved.
Between the same parties?
Between the same parties.
Which is that suit?
That suit, they themselves are produced,
The
3301.
execution, I am not a party, my lord.
You are coming as an intervener.
I'll
In page 100,
make a
1 minute. What
page
is
100.
the decree being executed?
Suit for specific performance.
Specific performance.
Compromised. I am not a party. I have challenged the decree.
And
There is an
that
interim
aspect
order
also,
not to create third party interest. The same court passes an order not to create third party interest. And the same court in the execution proceedings appoints a court commissioner to execute the sale deed. Contempt against the same court.
Second,
Same suit.
another aspect of the matter also I'll bring to my lord's kind notice.
So judicial
Now,
propriety. at
now
least
this is
should
a
have been
suit for
followed.
specific performance. Decree being executed is execution of a sale
Ex
deed.
parte decree?
Alla, mediation.
Lok Adalat
alla, Lok
ಬಂದೆ,
Adalat.
Lok
court
Adalat
ಮಾಡ್ತಾರೆ.
decree.
So this is a 2018 decree now
Conclusive
being
decree.
2018 decree. Now the issue is what is being
should have
executed
been
is a
adjudicated.
decree.
One
for-
nimsha.
What is being executed is a decree.
What
for
is
spec-
the date of the agreement?
Date of the agreement is before Lok Adalat, my lord.
Sir, date of the agreement, specific performance agreement ಯಾವತ್ತಿಂದ?
It is settled on.
No, not the settlement.
Petition was
Agreement.
filed, the suit was filed in the year 2018. They settled it in the year 2021. Execute in the year 2025. Even before that, there is a suit filed.
ನಾನು ಕೇಳ್ತಿರೋದು who are you ಅಂತ first ಕೇಳ್ದೆ.
I am the purchaser. I am not claiming any right under the JDR. I have got independent right to be enforced.
JDR ಎಲ್ಲಿಂದ ಬರ್ತಾ ಇದೆ? ಅದಕ್ಕೆಲ್ಲ ನಾನು ಕೇಳಿದ್ದು. Suit for specific performance ಅಲ್ಲಿ it was between whom? The agreement holder and
Holder and the JDR.
correct. Now who are you?
I am the earlier purchaser.
ಅದನ್ನೇ ಅದನ್ನೇ ಅಗ್ರಿಮೆಂಟ್ ಯಾವಾಗಿಂದು ಅಂತ ಹೇಳಿ. ಪರ್ಚೇಸರ್ ಸೇಲ್. What is your name?
Ravikant Reddy, my lord. 110/2018 is my sale deed.
110.
2018.
It is still it.
Annexure B.
ನಿಮ್ದಿದು ಅಗ್ರಿಮೆಂಟ್ ಯಾವತ್ತು?
We don't know. We came to know about the settlement being made before the.
ನಿಮ್ದು ಸೇಲ್ ಡೀಡೇನಾ?
Some sold it.
ಆಮೇಲೆ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಅಗ್ರಿಮೆಂಟ್.
ಹೌದು.
Subsequent ಅಲ್ಲ. Mine is old agreement. Suit was filed in 2018. Subsequently, matter was settled in
before the Lokadala.
Lokadala.
What is the matter here now?
Now, only one submission on that aspect also. What is being executed is a decree for specific performance by execution of a sale deed. Can order 21 rule be 97 be invoked in absence of a decree for possession? When there is no threat of dispossession by virtue of a decree against the judgment debtor, which is being enforced against third party. Is there a decree for where is the locus to make an application? Where enquiry is required?
We'll decide it.
Enquiry is not required.
Why?
Because there is no decree itself for possession.
We'll decide.
He is not in the threat of being dispossessed.
Petitioner is before this court.
Also place this judgment regarding the appeal.
Final order alla. The petitioner
Regarding the maintainability of the.
Adanne we will hear it. The petitioner is before this court calling in question an order of the concerned court rejecting an application under Order 21 Rule 97. An application preferred by the present petitioner wanting to come into the execution proceedings in which the respondent, the plaintiff, second respondent plaintiff is wanting to execute the decree. The concerned court has rejected the application, the rejection of which is called in question in a petition preferred under Article 227 of the Constitution of India. The learned counsel appearing for the respondent submits that the petition is not maintainable and an appeal has to be preferred against the said order, as an order passed under Order 21 Rule 97 would by itself be a decree, and therefore an appeal under Section 96 of the CPC should be preferred before the appropriate fora. The learned counsel Kalyan Basaraj submits that the Apex Court in 2015 1 SCC 379 has held that though Order 21 Rule 97 orders would be a decree by itself, but that cannot be passed without an inquiry. If it is done without an inquiry, a writ petition under Article 227 would become maintainable. The admitted fact in the case at hand is by both the parties is that there is no inquiry conducted prior to rejection of an application under Order 21 Rule 97. In the light of the judgment of the Apex Court in Samir Singh Supra, the matter requires consideration. Further proceedings before the executing court shall remain state till the next date, list on 17th in preliminary hearing.
Number 10, adjourned. 11, preliminary reading.
For respond of impleading.
12 is the main matter.
Today. To close this.
Impleading applicant.
Huh?
Happy for impleading applicant.
Impleading application. Why, sir?
Railways.
Railways, my lord.
Railways party madilva ನೀವು?
No, my lord.
My lord, they were not the benefit. They were not mentioned in any of the notification.
All right. The petitioner files an application the railways file an application seeking to implead themselves as party respondent into these proceedings. The application is not opposed. Therefore, the application stands allowed the petitioner to amend the cause title by drawing in the railways as sixth respondent into these proceedings. Igle madi.
There are 3 respondents.
6, 7, 8, whatever, 3 respondents. The petitioners are before this court calling in question the notice issued.
Not the citations are different, my lord.
The first ಯಾವ್ದು ಹಾಕ್ಬೇಕು ಏನು? Calling in question an award notice dated 30th May 2023 for it to be in violation of the statute and have sought consequent mandamus to set aside the award that is passed against these petitioners under the Right to Fair Compensation, Rehabilitation and Resettlement Act here in 2013, here and after referred to as the Act for short. Facts in brief, Germain, are as follows. So and so ಮಾಡಿ.
No, there is a judgment directly on section 19 subsection 7 passed by this honorable court, my lord,
For what purpose?
which says that even if an order is passed unless and until the statutory requirement of gazette notification and uploading on the website is
ಈಗ
not
ಸದ್ಯಕ್ಕೆ
complied.
21(1) ಸಾಕಾ? 19(7) ಹೋಗ್ಬೇಕು.
My lord, if the
Yes.
because the land valuation has continuously risen, my lord, therefore the preliminary notification has to be quashed. And there is also Himachal Pradesh High
Then
Court.
we'll have to hear the other side. He says 19 preliminary notification also has to be quashed, then you have
The
to.
preliminary notification, that is extension of time. Lordship seen the.
21(1) definitely.
That's covered, ma'am.
There is personal hearing is not given, it is covered, we'll quash that.
As well
And
as-
award notice will quash, but preliminary notification will go.
No,
Well,
because that
that
day,
is-
he
that's-
raised within 12 months, it was to be final notification. My lords. Extension provision was, proviso was read, and in the file it was notified.
It was
File
extended.
it was notified. The same
Extended.
contention was raised before this honorable court that it was noted in the file and it was
Which is that judgment?
first
sir?
judgment, my lord.
It is
Chandrapa,
itself a
it's a
judgment.
short judgment, my lord.
He has shown the, along with the.
Chandrapa, it's
file,
and others is the state of Karnataka, my lord.
It's not just noted, they were notified, there is some order.
Page 11 of the judgment, my lord. At page 10, the nature of the order is noted, my lord. Although an order came to be passed on 29/3/2021, the said order was not notified in the Gazette. And it was also more than a period of 12 months. Para 6, but the said order was not notified as required under section 19 subsection 7 of the 2013 Act. This is first initially observed. Subsequently, my lord, there was a subsequent notification, but beyond the period of 12 months. Para 7. Although there was a notification, it is beyond the period of 12 months, my lord.
No, file notings ಬಗ್ಗೆ ಇದೆ ಅಂತ ಹೇಳಿ ಎಲ್ಲಿದೆ ಅದು?
Para 6, my lord.
ಎಲ್ಲಿದೆ?
But the said order was not notified as required in section 19 subsection 7 of the 2013 Act, and this aspect is subsequently considered in page 13, my lord. Notification under section 3V of the Act. Notify is given a precise meaning under section 3V of the Act. Para 14 of the judgment, my lord.
We'll see, we'll take it on 12th then. 21(1) will pass the order, 19(7) we'll have to consider, we'll see. ಈಗ ಇಂಪ್ಲೀಡ್ ಮಾಡಿದಿರಲ್ಲ ಇನ್ನು?
Not, that area has not been allowed.
Allowed.
I'll carry out the.
ಈಗಲೇ carry out the amendment.
Indeed.
Yes. List on 12th.
Interim order may be extended.
Interim order subsisting would continue till the next date of hearing.
Approved.
ಯಾರಿಲ್ಲ ಅಂದ್ರೆ ಅರ್ಜೆಂಟ್ ಮಾಡ್ತಾರೆ.
14.
That is the PMSC matter which came before yesterday, my lords, it said that this will be disposed of.
Administration,
I'm the only sole surviving legal heir. My sister, who was petition number 2, she passed away.
No time to dictate. And chamber ತಗೊಂಡ್ರೆ ಅಲ್ಲೂ ಟೈಮ್ ಇಲ್ಲ. The petitioner is before this court seeking the following prayer. The petitioner is the sister of one V. Annapurna, who dies on 20th February 2023. 2003.
2003. Annapurna dies in 2003.
Ah.
Saroja dies in 2023. Who was petition
The
number 2.
Annapurna had two siblings. Another.
Lord, there were totally 6, my lord, 6 siblings. Only 2 surviving siblings come before the honorable court and ask for a succession certificate, which is then given as a letter of administration.
But what happened to the other 3?
Nobody survived, my lord. Only 2 of us were surviving.
The Annapurna dies leaving behind 2 survivors. One is Saroja and the other the petitioner.
Please.
On 27 to it transpires that Saroja also dies, and therefore the petitioner the sole surviving sibling files a petition under section 372 of the Indian Succession Act before the concerned court in P&SC 25010, 2510.
Not both had said, both had filed together.
So 25010. At the time of filing of the petition, both the petitioner and V. Saroja, the petition was filed by both V. Saroja and the present petitioner. During the when did she die, sir?
2023, my lord.
During the subsistence of the proceedings before the concerned court, V. Saroja also dies on 19/4/2023.
Please.
Therefore, the petitioner then files an application. Petitioner then illig bandidra matte.
Once bandidde, my lord, then it was remanded back
The
also.
petitioner comes before. Why did you come before this court?
One is for a direction to consider my application. Second
The
is, my lord,
application was application for appointment of what is that?
my lord, application was the subsequent application, my lord. Subsequent application should say that to give it in my name. It wasn't-
The application is preferred to transfer the letter of administration to the hands of the present petitioner, who was the only surviving heir of the surviving heir after the death of all the siblings. The application was not considered. Therefore, the petitioner was before this court in writ petition 2510 of 2025, which comes to be disposed directing consideration of the application. The application comes to be rejected. Therefore, rejected. Therefore, the petitioner is before this court. The concerned court, by the impugned order, rejects the claim of the petitioner on the score that the
if my lords were to kindly see page 21. Page 21.
ಎಲ್ಲರನ್ನು ಕರ್ಕೊಂಡ್ಬರ್ಬೇಕು ಅಂತಾರೆ.
ಇಲ್ಲಿ page 21, my lord.
The concerned court rejects the application on the following grounds ಅಂತ ಹಾಕ್ಬಿಡಿ. Page 21, 22.
Paragraph 11.
The reason so rendered by the concerned court is on the face of it erroneous in the light of the settled principle of law as enunciated by the apex court and different high courts. The petition thus deserves to succeed. The petition, for the aforesaid reasons, the following order. Petition is allowed. The petitioner, ಅದೇ ಕೇಳಿದಿರಾ ಏನ್ ಕೇಳಿದಿರಾ?
ಅಷ್ಟೇ ಅದೇ ಕೇಳಿದ್ರು.
The petition stands allowed. The concerned court shall close the proceedings before it by directing issuance of a letter of administration in the name of the petitioner.
Please, grateful.
Ordered according.
Grateful.
With the leave of the court, serial number 13, my lord. Serial number 13.
30?
13. Both of us were here, somehow we missed it.
13 ಆಯ್ತಲ್ಲ?
We were both here, we didn't come forward, both of us somehow missed it.
Both of you?
They're here only, but we could not.
Somehow we both missed it.
ಇಲ್ಲೇ ಇದ್ದು ಮಿಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ? Yes.
My lord may grant us 2 weeks' time. The parties are.
I have adjourned it by 2 weeks anyway.
Please.
Yes.
May the stay may please be extended.
Stay ಇದೆಯಾ?
Yes.
ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿರುತ್ತೆ.
In the last date, I am not sure if it was.
ಇಲ್ಲ, ಲಾಸ್ಟ್ ಡೇಟ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ಲ. ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಜೆ ವೈ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಸಬ್ಸಿಸ್ಟಿಂಗ್ ಶಲ್ ಕಂಟಿನ್ಯೂ ಆಗಿದೆ.
Next.
The impugned order, my lord, the trial court has summato issue direction to the petitioner to bring the LRs on record.
P&SC ಇದೆ.
Yes, my lord.
Monday preliminary hearing. Yes, next.
16. Similar, my lord.
Same, huh?
Yes.
Yes.
17.
Okay, for the petitioner, my lords. Appointment of commissioner, pre-trial, my lords. I am the defendant. I took up the contention, my lords. Plaintiff.
Pre-trial ಯಾಕೆ?
ಅವರು ನಾನು ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದ್ದೀನಿ ಅಂತ their submission is I have encroached.
Issues are framed?
Issues are not yet framed.
Dismissed. Liberty reserved.
No, I am the respondent, my lords. The court commissioner is appointed.
Appointed. Then stayed. Yes. The petitioner is before this court calling in question an suit for?
Suit for injunction and possession.
The petitioner is the defendant in the subject suit filed for injunction and possession. Possession na?
Encroachment ಮಾಡಿದೀವಿ possession ಕೊಡ್ಸಿ ಅಂತ ಕೇಳಿದ್ದಾರೆ.
Injunction and possession. The issue is in the said suit, even before the issues are framed, an application is filed by the plaintiff seeking appointment of the commissioner. The application is allowed, against which the defendant is before this court. It is trite law that even before the trial commences or even the issues are framed, upon an application of Order 26 Rule 9 would not be entertainable except in exceptional circumstances. No such exception is projected in the case at hand. Therefore, there shall be an interim order of stay of the order appointing the commissioner. It is made clear the proceedings before the concerned court are not stayed. Yes.
18.
Plaintiff's writ petition, suit for recovery of money. Lord, the defendant number 2 had not challenged the order passed by the trial court before the ensemble court. My lords refused to grant an interim order staying the proceedings.
Where is that?
But that order, my lords, to get it not at page 131. My lords, it only stayed insofar as cost is concerned. In fact, the earlier round also, my lords, had passed an order rejecting their prayer. But
XM Joseph appear.
They have filed a CP.
This matter.
They filed a CP for transfer from that judge. That there also interim order rejected. Page 153 is the order.
I have quoted your synopsis in this.
Yes, Lord.
Because so many dates were there.
But then what they have done is, Lord, transfer petition also, Lord, interim order rejected. They file a memo before the trial court saying that this writ petition which they filed where interim order rejected, CP that is filed interim order rejected, both are pending. Therefore, you have to await the decision in that case. They file a memo. And Lord, they rely upon judgment of a Bombay High Court to say the matter has to be deferred. On that count, Lord, the learned trial court, Lord, defers the matter, Lord, because these cases are pending. Page 165, Lord, is the order. 166, Lord, 168, Lord, please turn. Para 8.
168.
How? Starts from the previous para, but then para 8, 168. In considering submission, learned senior counsel and taken with the order sheet and submission plaintiff, I am of the view
which is this transfer petition filed?
That is the transfer petition, Lord, which I have produced at
page 168 ಅಲ್ಲಿ WP 20256 ಯಾವುದು?
Other than tam torsirodu. They sought for stay, interim order is not granted, only so far as cost.
Which is that?
Page 131. 10/7/2025 order.
Imposes cost of 10,000.
Only that lots have stayed. No, the imposition of cost only was stayed. The order was not, they wanted not to say that the entire thing is bad in law. The order not in the transfer petition not to get it at page 153. The last paragraph of page 153. Hence, the request made for ad interim relief at the present is rejected. After which, a memo is filed at page 155, saying that these two cases are pending before the High Court, therefore you stay the proceedings. I have concluded my arguments. It is posted with the arguments of the defendants. Page 155, this is a memo. There is no application also. Page 155.
One moment. Where is my order?
My Lord's order, is at page 131. I have also produced a writ petition to show they ask for stay of further proceedings. 131, Lord, is the interim order.
The respondent was before this court in writ petition 11572 of 2025. This court recording the pendency of the proceedings from 2/1/2023 and how the respondent has dodged the issue of completion of proceedings by on one pretext or the other, rejected the petition, holding that the dates and events quoted in the order would depict abuse of the process of the law by defendant number 11. The defendant number 11 does not cooperate with the proceedings, but seeks to file an application before the concerned court seeking transfer of the case to another court.
No, that is done by defendant number 2, her husband.
11's husband.
11th husband.
By this time, by the husband of defendant number 11. That comes to be rejected. Rejection of which is called in question before this court in CP 266 of 2025. The coordinate bench passes the following order, page 153. No stay is granted of the pending proceedings. They again fail. Another attempt is made by filing a memo before the concerned court contending that there are proceedings pending before the High Court. Therefore, the matter is sub judice. In that light, the proceedings should be stalled. This time, the defendant number 2, the wife of defendant number 11, husband of defendant number 11 succeeds as the concerned court passes the following order and following order on the memo, page 168. Therefore, the attempt of defendant number 11 or 2, the husband and wife, is to somehow stall the proceedings or drag the proceedings ad nauseum. In that light, the order passed by the concerned court shall remain stayed with a direction to the concerned court to proceed with the proceedings further, failing which it would be putting a premium on the usage of tactics which to become an abuse of the process of the law. Next.
But the CP is for transfer of the proceedings.
Transfer proceeding. Transfer ಏನು ಹೇಳಿದೆ ನಾನು?
Lord said challenging that order CP was filed. Challenging the order.
Transfer of proceedings. Yes.
Please.
We'll see.
Great.
Madam, ಆಯ್ತು ತಗೊಳ್ಳಿ. ಜಗದೀಶ್ ಸರ್ ಇದ್ದಾರೆ ತಗೊಳ್ಳಿ first.
Further hearing at 4:30 PM.
Admission matter, I have taken steps. Next matter.
Admission ಕರ್ದಿಲ್ಲ ಸರ್, wait.
This matter, my lord, there are some further developments. Subsequent to the report which I have filed, my lord, the government has passed GO, my lord, may place the GO, my lord.
ಕೊಡಿ.
In fact, most of these,
implementing the directions?
most of the suggestions which, in fact, your lordship stated in your lordship's order have been, I say, my lord, have incorporated.
Petition number ಇಲ್ಲ?
Government.
ಹಂಗೆ ಮಾಡಿದಾರ? ಏನು ನೀವೇ ಬಹಳ ಮುತುವರ್ಜಿ ತಗೊಂಡ್ ಮಾಡ್ದಂಗೆ. ಇಲ್ಲಿ ಕರ್ಸಿ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟು ಮಾಡಿಸ್ಬೇಕು.
They should have given the credit, my lord, the credit.
ಕ್ರೆಡಿಟ್ ಪ್ರಶ್ನೆ ಅಲ್ಲ. ಇಲ್ದರೆ they'll easily move out of this.
No, they could not have done
ಇದೇನಾಗುತ್ತೆ, the government order is now issued because I am holding the proceedings. Tomorrow it closes, this is withdrawn. That is why I said writ petition number ಎಲ್ಲಿ ಅಂತ.
No, that's correct, my lord.
To keep them accountable. Yes, ಈಗ ಏನೇನ್ ಮಾಡಿದ್ದಾರೆ? All directions are implemented?
Majority have done, my lord. In fact, the 2-3, my lord, I made a list. I place one note, my lord, your lordship may see.
ಕೊಡಿ. ಈಗ ಏನೇನ್ ಮಾಡಿದ್ದಾರೆ ಇದರಲ್ಲಿ?
5, my lord, has been done.
ಏನು district CN police stations and those so and so?
Yes, my lord.
All right.
It's all been done. What is required, my lord, your lordship may see point number 1. Now the government has to implement these GOs in letter and spirit. That is, we don't know how much extent it has to be done. Most importantly, my lord, the serial number 6, which what I said.
Task solely with, correct. That is obvious because if you bring in someone else and put it here, they will not be able to investigate into the matter.
That's correct. And then, my lord, the serial number 7, cybercrime cases shall be transferred to cybercrime wherever without, once it has been investigated. Unnecessarily should not be, because that where the interference with the investigation comes in. Without the consultation of the DGP should not be transferred out. And then, my lord, of course, the lordship can, serial number 8, my lord, is to submit a report, is what I suggest, my lord,
that
your
we'll
lordship,
see. Yes.
your lordship take it, my lord. And then 9 and 10 is most important, my lord, because what happens
now,
now,
what is this 1930 helpline ಅಂದ್ರೆ?
1930, my lord, now if there is a scam happened to me, this is a helpline which is created. Immediately I can dial 1930 and file a complaint. The moment
On cyber crime
and
allegations.
cybercrime allegation where my money has been siphoned off and etc. The moment I make a telephone call, the lien has been created.
Lien has been created.
In an account where
Now,
my money has been.
For illustration, now somebody says my money is gone.
Yes, ma'am.
Gives a call to helpline 1930. So immediately what do you do?
They take it, my lord, and then check which bank the money has gone to, and then that money will be frozen if the money is.
That account is frozen.
Yes, ma'am.
Frozen or lien marked, because
Lien
you
marked.
issued a circular.
It is lien marked.
It should not be frozen, but lien should be marked.
Lien mark.
All right. Amela, what do you do?
So then the lien mark will remain. So that's where one of the issue, my lord, because now this 1930.
No, after mark, see, this is a crime that is reported to you.
Correct.
You mark a lien. Crime is registered or not?
Crime, not necessarily all cases have been registered.
Then how do you proceed further with investigation? Iga, for example, lien mark, where a phone martar. It can be a hoax, it can be a false call, it can be to wreak vengeance, it can be anything.
Correct.
ಈ ಅಕೌಂಟ್ ಅಲ್ಲಿ ತೊಂದರೆ ಮಾಡ್ತಾ ಇದ್ದಾಗ ಆಯ್ತು ಫೋನ್ ಮಾಡಿ ಹೆಲ್ಪ್ ಲೈನ್ಗೆ ಈ ಅಕೌಂಟ್ ಇಂದ ನನಗೆ ಹೋಗ್ಬಿಟ್ಟಿದೆ. ವಿತೌಟ್ ವೆರಿಫಿಕೇಶನ್ ಯು ಸ್ಟ್ರೈಟ್ ಅವೇ ಡೈರೆಕ್ಟ್ ಮಾರ್ಕಿಂಗ್ ಆಫ್ ಲೀನ್ ಆನ್ ಅಮೌಂಟ್ ಆರ್ ಫ್ರೀಸಿಂಗ್. ಯಾರ್ದೋ ಅದು ಅಕೌಂಟ್ ಫ್ರೀಸ್ ಆಗ್ಬಿಡುತ್ತೆ. ಸೊ ಹೌ ಡು ಯು ಟೇಕ್ ಇಟ್ ಫಾರ್ವರ್ಡ್?
That's where
this misuse should be stopped.
That's where there is a misuse, my lord. I say, my lord, there is a misuse there. What happens is not necessarily that this case is real one, nor it is being converted subsequently to an FIR. And this 1930 should have been integrated with IT.
Now this should be integrated with the command center.
Yes, ma'am. Police IT should integrate with the police IT, and then that should control with the.
Because you should have a integrated system.
Correct.
Where the moment 1930 is dialed in the what do you call this the helpline. Helpline. That application should be a part of the cyber command station.
Yes, ma'am.
Otherwise, its misuse will not. Tiga, you tell me now. Somebody will approach the hypothetically, may not be doing or whatever. Some person will call the police helpline and say, my 5,000 rupees is gone, 10,000 rupees is gone, 50 lakhs is gone, whatever. It goes into some account. It may be any transaction.
Correct.
That person, to frustrate that person because it has gone transaction, he may call the helpline and say freeze that account.
Correct.
So that account is frozen. That's a account is frozen. Amele you delete it or you defreeze it later for whatever reason. Will it not be a tool in the hands of the police?
No, that's where, my lord, the
Hands of the police and to misuse.
That's correct. There is a scope, my lord. That's where they should have been ideally converted into police IT. Correct. And register 0 FIR. And the FIR should have been
transferred. ತುಂಬಾ ಮಾಡ್ತಾ ಇದೆ, ಒಂದು ಹೆಲ್ಪ್ ಲೈನ್ ಫೋನ್ ಮಾಡಿ ಫ್ರೀಸ್ ಮಾಡಿಸ್ತೀನಿ ಅನ್ನಂಗ ಆಗ್ಬಿಡುತ್ತೆ.
ಅಲ್ಲ, ನಾನು I can do business with him and I can call and say
exactly do business with him, money transaction ಮಾಡಿಸ್ಬಿಟ್ಟು ಫೋನ್ ಮಾಡಿ, you can always get it frozen.
That's correct.
Saying that it is cyber crime.
Some of the data, my lord, which past 3 years number of cyber tip lines complaints have been generated.
That's why you should have a comprehensive command center.
That's correct, my lord.
Have you seen this, Angad, all this?
No, I have not had a chance to look at it.
ಅಲ್ಲ, IT Act reported cases other police stations alle ಜಾಸ್ತಿ ಇದೆ ಸೇನ್ police station ಗಿಂತ.
That's because, my lord, this one
ಅಲ್ಲಿ ಅವ್ರಿಗೆ ಏನ್ ಗೊತ್ತಿರುತ್ತೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಕ್ಕೆ?
That's where in fact, pursuant to your lordship, para 13 of your lordship's order is what I say, my lord, though its order is not reflected to your lordship's order, lordship judgment. But all these things is pursuant to your lordship's.
Correct, that's all right, but that's why, no, I did not say that for anything else. ನಾಳೆ ವಿಡ್ರಾ ಮಾಡಬಾರ್ದು ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ನ ಅಂತಷ್ಟೇ. ಅದು pursuant to this court's order ಅಂದ್ರೆ they will not withdraw it.
Correct.
Otherwise it is susceptible to withdrawing. But we'll pass some order.
Another aspect, my lord, that I think now the cyber command center has been, by virtue of this notification, earlier notification has been set up. I think, my lord, that's the officers who are in working at present may have to be protected till your lordship may decide all these things.
That we'll see. I'll pronounce it on Monday on this. I will pass some orders on Monday. Monday will pronounce some orders on this and giving some more teeth to the cyber command center. So that it becomes robust.
That's correct.
And the present day crimes are tackled by present day investigations. ನೀವು present day cyber crimes na You can't tackle it with dacoity and robbery that you used to do earlier.
Your Lordship may recall one of the matter where Asmat Pasha, senior Asmat Pasha has appeared.
Yavadu?
Amazon case, my lord. Your Lordship
Amazon,
has-
yes.
The classic case, my lord, could have been investigated in a much better manner. Unfortunately,
Though I dismissed it, it was a case of appropriate, faulty investigation.
correct. It could have been, ITI could have been invoked because.
Definitely.
And multiple things have been done.
No, there it was horrible.
Yes.
Several, you've been there. That Amazon case.
Yes, ma'am. Yes,
100 iPhones are sent. A box or iPhone illa.
Lord, your Lordship may also.
You have MI, I think.
Lord, your Lordship may also consider directing the Law Commission to examine these issues
Let
under
us
the
see.
Act as well.
Because from everywhere phones are ordered, it goes to a goes to a particular address, and everywhere return from some other place. All those 100 phones are returned. In the return, no iPhone. Phones are taken, boxes are sent. The argument was it's a civil dispute. We'll see.
One report,
Yes.
my lord, in connection with this
Kodi,
case.
Kodi.
DYSP is present, my lord.
Who is the officer present?
DYSP, my lord.
Yes.
Lord,
Of the SIT,
Yes,
SIT team,
SIT.
SIT. Now, what's the, this is the latest.
Insofar as the investigation is concerned, Lord, we had actually filed a fresh complaint before the SIT when the SIT had taken over, bringing to the SIT's notice all the developments that had happened prior to the constitution of the SIT, in which we had specifically mentioned the role of the sister-in-law in interfering with that investigation. Lord, we only want to, we are not.
We'll see.
Yes,
What have they done? We'll see.
Yes, ma'am,
What have they done? And I will on Monday pass those orders also.
But I have not seen this report, in fact, this issue. And I know, my lord, that SIT is looking into this issue.
Because I had myself observed in my order what was the external influence brought on the investigating officer.
So long as that aspect is being investigated,
We'll
Lord, we
see.
have no.
Let me see. ಇದು ಫೈಲ್ ಜೊತೆ ಇಡಿ. And ಈಗ ಜಗದೀಶ್ ಸರ್ ಕೊಟ್ರಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಫೈಲ್. Yes, we'll pass.
Yes.
Monday we'll pronounce it.
So great.
ಇಲ್ಲ. Oh, sorry.
More matters. Preliminary hearing, still number one, Shri Madhu and Rao.
Yes, Madhu, this side.
It is against the state government. This is a matter, my lords, where it's a mining royalty, GST and mining royalty and other issues. It is an ex parte order. I only seek for quashing the orders because already recovery proceedings might be there.
Hem Kumar.
I'll accept notice for respondent.
Learned, heard the learned counsel Madhu and Rao appearing for the petitioner. Learned AGA accepts notice for the first respondent. Union Bank of India Beka.
Recovery might be there. I'm not able to operate the bank account.
Emergent notice to the second respondent. The petitioner is before. Huh?
They want a reminder.
Yeah.
ಮುಂದಿನ ವಾರ ಹಾಕೊಂಡ್ರೆ it can be disposed.
ಅದು 11th ಹಾಕ್ತೀನಿ. ಈಗ ಸ್ಟೇ ಬೇಡವಾ?
Operate bank account open.
Bank account ಅದು interim model ಆಗಲ್ಲ. We'll dispose it next week. List on 11th. Notice the list on 11th in preliminary hearing. We'll close it on that day.
Still number two, Madhu and Rao.
My lord, this matter, my lords.
Beverages Corporation.
My lords, I am asking, I am seeking this prayer, direction to Karnataka Appellate Tribunal to pass an order because there was an order which was passed by this honorable court. Wide Annexure A.
Page. Annexure A.
Annexure A.
As a result, needless to say, second appeal. ಯಾವ್ದು order ಇದಾ?
9571 of 2017. That order has been passed by this honorable court directing the CAT to pass an order in favor of me. But that has not been adhered to by the CAT.
Disposed in favor of the respondent in terms of this order.
Yes, my lord. That they have not passed an order from past 10 months. Because of that, I am facing contempt proceedings before this honorable court by the respondent number. They have filed because it emanated, that order emanated because of a transaction between me and respondent number 1. Because that was a sale of.
ಇದರಲ್ಲಿ ಯಾರು?
Respondent number one, Renuka Sugars.
ಅವ್ರದ್ದು ಬಿಡಿ. ನೀವಿಲ್ವಾ?
He is.
Appeared for the respondents.
Then you serve on someone.
The
ಈಗ ಇದು ಈ ಡೈರೆಕ್ಷನ್ ಬೇಕಾಗಿಲ್ಲ ಆಕ್ಚುಲಿ. Person ಹಿಯರ್ ಮಾಡೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ.
The only thing is, my lords, if the notice may be dispensed to others, I am only seeking for a direction to CAT to pass an order.
I will not say that also. To comply with the order passed by the coordinate bench.
Because 16th, my lords, I am facing contempt proceedings before the.
ಇಲ್ಲ, before 16th ಮಾಡಕ್ಕೆ ಎಷ್ಟು ದಿನ ಆಗಿದೆ ಇದು?
10 ತಿಂಗಳಾಗಿದೆ, ಅವ್ರು ಇನ್ನೂ ಪಾಸೇ ಮಾಡಿಲ್ಲ.
ಈ Beverages Corporation is, the petitioner is before this court seeking the following prayer. Petitioner was the respondent in writ petition 9571 of 2017, which comes to be disposed by the coordinate bench by the following order. The coordinate bench directed that it is admitted by the first respondent that the sums which the petitioner was legally entitled to receive have been invested in fixed deposit. In view of that, the first respondent, the petitioner herein, was directed to pay interest that is accrued in the fixed deposit, and since the said amount had been withheld incorrectly. As a result, the tribunal, sales tax tribunal. The appellate tribunal was directed to dispose the petition in favor of the first respondent, i.e. the first respondent there in the present petitioner. The learned counsel for the petitioner submits that despite the passage of 10 months, the tribunal has not passed an order in terms of the order passed by this court, which had specifically directed that the respondent, that the tribunal will have to dispose the appeal pending before it in favor of the first respondent. The first respondent therein is the petitioner. The learned counsel for the petitioner submits that due to the act of the tribunal not passing an order, the petitioner is facing contempt proceedings before the division bench. In that light, I deem it appropriate to direct the tribunal to pass an order on or before the 15th of September 2025. In the light of the circumstance that the contempt petition is listed on the 16th of September. The prayer is for a direction to pass an order in terms of the order passed by the coordinate bench, in which all the parties were represented. Therefore, to grant this prayer, which the coordinate bench had already granted, which is innocuous, I have felt it appropriate to dispense issuance of notice to other respondents. Ordered accordingly.
Obliged.
Registered sale agreement, please, my lord, is of the year 2023. My lord, suit is filed for specific performance, please, my lord. Emergent notice is issued. My lord, I am seeking for a stay of not.
Who are you?
My lord, I am the agreement holder. Defendant is the owner of the property.
Date of the agreement?
My lord, 15/9/2023.
Yes. A emergent notice to the respondent. Petitioner, I'll notice agilla line. I'll represent madilla. The petitioner shall also serve the respondent by way of hand summons. The learned counsel appearing for the petitioner submits that he is an agreement holder at the hands of the respondent, having entered into an agreement of sale in the year 2023. Non-performance of it led the plaintiff petitioner to the concerned court in OS 1545 of 2025 seeking relief of specific performance. The concerned court issues emergent notice but does not grant an ex parte injunction as was sought for, answering an application under Order 39 Rule 1 and 2. In the light of the said circumstance, the respondent shall not alienate the property during the subsistence of the proceedings. Yes. Next.
Seal number 4, adjourn. Seal number 5, Srimati Rani K.
Your Lordship's kind permission. Lord, this is a suit for partition. I am one of the co-partner. I I am the defendant. I was placed ex parte, then I filed an application for some delay. But other side said there is no objection for allowing the application.
Some delay and rest.
Around 6 years, 8 months.
Oh.
6
ತುಂಬಾ
years,
ಕಮ್ಮಿ
8
ಆಯ್ತಲ್ಲ.
That is there, my lord, kindly go to the impugned order at page number 71 of the order sheet.
ಈಗ ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರಾ?
That is rejected. My application is rejected.
Obviously, what else can? 7 ವರ್ಷ ಆದ್ಮೇಲೆ
He is around 74 years. He was in a hospital. They produced the documents and all. Even then, my lord, other side
6
also
ವರ್ಷ
said,
ಹಾಸ್ಪಿಟಲ್ ಇದ್ರಾ?
illa, maybe around some 1 or 2 years he was in hospital.
1 or 2 years.
1 or 2 years he was in hospital. So out of 6 years he was there.
ಆಯ್ತು. ಇನ್ 4?
ಅಲ್ಲ ವಯಸ್ಸಾಗಿ ಹೋಗಿದೆ, ಅದೇ ಏನ್ ಮಾಡೋದು ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ. But I am one of the co-partner of the property, but Lord, it is unnecessarily multiplicity of proceedings. Even then, if it is
ಬಿಟ್ಬಿಡಿ, ಮತ್ತೆ ಮಲ್ಟಿಪ್ಲಿಸಿಟಿ ಯಾಕೆ?
ಅಲ್ಲ ಬಿಟ್ರೆ ಇದನ್ನ ವಜಾ ಮಾಡ್ಬಿಟ್ರೆ ನಾನು ಬರ್ಲೇಬೇಕಲ್ಲ. ಸೊ ಅದಕ್ಕೆ ನಾನು ಈಗ ಬಂದೆ. ತಾವು ದಯವಿಟ್ಟು
ಏನ್ ಮಾಡೋಣ ಈಗ? ಕಂಡೋನ್ ಮಾಡೋದ?
ಅಲ್ಲ, ಇಲ್ಲಿ ಕಂಡೋನೇಷನ್ ಇಲ್ಲ, ಅಲ್ಲಿ ಅವ್ರು ಕಂಡೋನ್ ಮಾಡಿಲ್ಲ. ಕಂಡೋನ್ ಮಾಡದಿರೋ ವಜಾ ಮಾಡಿದ್ದಾರೆ. And other side also said, yes, he is our brother.
He's our brother.
I am brother of the plaintiff, but ಇಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ, ಅಲ್ಲಿ ಓದ್ತೀನಿ ನೋಡಿ. ವಾದಿಗಳ ಪರ ವಕೀಲರ ಅರ್ಜಿಯನ್ನು ಊರ್ಜಿತಗೊಳಿಸಲು ತಮ್ಮಿಂದ ಯಾವುದೇ ತಕರಾರು ಇಲ್ಲವೆಂದು ತಿಳಿಸಿದ್ದಾರೆ ಎಂಬ ಮಾತ್ರಕ್ಕೆ ಅರ್ಜಿಯನ್ನು ಊರ್ಜಿತಗೊಳಿಸುವುದು ನ್ಯಾಯಬದ್ಧವಾದ ಕ್ರಮವೆಂದು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಕಂಡು ಬರುತ್ತಿದ್ದು, ಈ ರೀತಿಯ ಅರ್ಜಿಗಳನ್ನು
ಕರೆಕ್ಟ್ ಬಿಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ, ಅದ್ರಲ್ಲೇನ್ ತಪ್ಪಿಲ್ಲ.
ಅದು ಬರ್ದಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದೆ. Kindly, because my interest may be protected, because I have a birthright over the property.
Birthright?
The ancestral property.
ಹಾಸ್ಪಿಟಲ್ ಇದೆಯಾ?
ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಇದ್ರು, ಅದು ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. ಆದ್ರೆ ಕೆಳಗಿನ ಕೋರ್ಟ್ನವರು ಅದೆಲ್ಲ ಸಮಂಜಸವಾಗಿಲ್ಲ ಅಂತ ಬರ್ದಿದ್ದಾರೆ.
ಅಲ್ಲ, ಕರೆಕ್ಟ್. ನೀವು 2 ವರ್ಷ
ಇಲ್ಲ ಇದ್ರು, 2 ವರ್ಷ ಇದ್ರು. I have seen also
ಮಸಾಜ್ ಸೆಂಟರ್ ಅಲ್ಲ, ಆಯುರ್ವೇದಿಕ್ ಮಸಾಜ್ ಸೆಂಟರ್ ಇದೆ ಅನ್ಬರ್ಲಿ.
ಇಲ್ಲ, ಅದು ಮಸಾಜ್ ಸೆಂಟರ್ ಅಂತ ಬರ್ದಿದ್ದಾರೆ ಅದು. ಬಟ್
2 ವರ್ಷ ಏನ್ ಮಸಾಜ್?
2 ವರ್ಷ ಇರಕ್ ಸಾಧ್ಯ ಇಲ್ಲ ಮಸಾಜ್ ಸೆಂಟರ್ ಅಲ್ಲಿ. ಬಟ್ ಆಯುರ್ವೇದಿಕ್ ಮೆಡಿಸಿನ್ ತಗೊಳ್ತಾ ಇದ್ರು ಅಂತ ನನ್ನ ಗಮನಕ್ಕೆ ಬಂದಿರೋ ವಿಷಯ.
2 years ಮಸಾಜ್ ಸೆಂಟರ್
ಅಲ್ಲ, ಇನ್ನೊಂದು
ರೀಸನ್ ಕೊಡ್ಬೇಕಾದ್ರೆ
ರೀಸನ್, ಸಪೋಸ್ ಇಫ್ ದ ಯಂಗ್ಸ್ಟರ್ಸ್ ಇಟ್ ಕ್ಯಾನ್ ಬಿ, ಐ ಕುಡ್ ಆಲ್ಸೋ suspected otherwise. But illi
nobody is suspected.
Allah, if it is an youngster saying that having in 2 years in massage center, but here it is more than 74 years.
6 years ಹಿಂದೆ ಹೋಗಿ.
ಅಲ್ಲ, 6 years ಹಿಂದೆ ಅವಾಗಲೇ 74 years, 6 years ಆಡ್ ಮಾಡ್ಬೇಕಾಗ.
ಅಲ್ಲ,
ಆಡ್ ಮಾಡಿದ್ರೆ 82 ನೋ 83.
Why are you presuming otherwise? Don't presume otherwise. ಅಲ್ಲ, ರೀಸನ್ ಕೊಡ್ಬೇಕಾದ್ರೆ 2 ವರ್ಷ ಆಯುರ್ವೇದಿಕ್ ಮಸಾಜ್ ಸೆಂಟರ್.
We can understand this is a trial court matters where if it is in high court, people would have been, lawyers would have been wise enough to write in such a way. But ಇಲ್ಲಿ ತಾವು ಅರ್ಜಿ
ಆ ರೀಸನ್ ಕೊಟ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ದೆ ಇನ್ನೇನ್ ಮಾಡ್ತಾರೆ?
ಅಲ್ಲ, ಅರ್ಜಿ ನೋಡ್ಬಿಟ್ರೆ ಅರ್ಜಿನಲ್ಲೂ ಅದೇ ತರ ಇದೆ. ಏನು I don't want to say anything about lawyers.
What kind of massage you are taking for 2 years?
ತಾವು ಈಗ ಏನೋ ಆರ್ಡರ್ ಕೊಟ್ರೆ ಅದನ್ನ ತರ್ಸಾಕ್ತೀನಿ.
Yes.
And the day-to-day matter is taken up. They are going to, dispose of.
ನೀವು day-to-day court ಹೋಗೋ ಬದಲು ಎಲ್ಲೋ ಹೋದ್ರೆ ಹಿಂಗೆ ಆಗುತ್ತೆ. Yes. I serve ಮಾಡಿ respondents.
Please,
the petitioner to serve 1, the counsel representing the plaintiffs before the concerned court and file an acknowledgement of such service. List the matter on 17th. Further proceedings before the concerned court till the next date shall remain stayed.
Obliged.
Yes. ಆದ್ರೆ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡ್ಬೇಕು.
Please.
ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಇಲ್ಲಿ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ರೆ ಮಾತ್ರ ಕಂಡೋನ್ ಮಾಡೋದು.
Yes, my lord.
Yes. ಇನ್ಮೇಲೆ ಬೇರೆ ರೀಸನ್ ಹುಡುಕಿ.
ಇಲ್ಲ, ಈಗ ಅದನ್ನೇ ಓವರ್ಕಮ್ ಆದ್ರೆ ಸಾಕಾಗಿದೆ.
Hearing on IA, seal number 6, Ganesh VS.
Please, my lords.
Why did you move this?
Assessment in 1819, there is certain demand against which I have filed writ
230
petition.
move ಮಾಡಿದ್ದೆ ಯಾಕೆ?
Because Income Tax Department CPC has unilaterally recovered 7.44 crore out of the demand in dispute.
It's a pending matter. How did you move it then?
Not the main matter, my lords. Only the IA I would like my lords to
ಎರಡು
hear.
ಜೊತೆ ಜೊತೆಯಲ್ಲೇ ಬಂದಿರೋದು.
Because that is a different on the
That's different.
Yeah, I mean that it is on the demand side.
I have been served with IA. They want to implement CPC, my lord.
There is a subsisting stay order on the date on which the recovery was
ಮಾಡಿ
done.
ಕರೆಕ್ಟ್ ಆಗಿರೋದು. Where is this?
But CPC I'll take.
Cash free payments India recover ಮಾಡಿದಾರಾ ಈಗ?
Yes, my lords.
What recovery proceedings pursuant to what?
Pursuant
If you move at 230, how will we know?
For assessment at 24-25, there was certain refund which was due, my lords, some 20 crore plus.
I'll take notice for CPC. It's impleading IA.
Impleading ಹಾಕಿರೋದಾ ಇದು?
Impleading IA.
Impleading as well as there is one more IA for direction sought to release the refund.
Release?
Release the amount which is recovered.
Interim model release. The learned counsel, impleading application allowed for the reason so and so. The learned counsel Arvind Chavan accepts notice for the impleading applicant registry to print the name of the impleading Allah. Respondent number?
5.
Arvind Chavan accepts notice for the 5th respondent. 11th?
Please, my
List the matter on 11th in preliminary hearing.
copies to be served.
My lords, IA2 also was filed.
This main copy serve ಮಾಡಿದಾರಾ?
ಇಲ್ಲ, main
ಇಲ್ಲ, ಈಗ ಇಂಪ್ಲೀಡ್ ಆಗಿದ್ದಾರೆ. Give petitioner to serve a complete set of papers upon the aforesaid counsel.
Already served.
Forthwith, yes. Correct.
Matters pertaining to Dharwad bench, seal number 1 orders, Anil Kale.
Petitioner. My lord, before your lordship takes up this bench, may I make a mention, my lord? Your lordship permit.
There is amendment to be carried out, my lord, in this.
Dharwad bench list ಏನು madam? List number?
My lord, I wanted to make a mention before your
Yes.
My lord, there is an item in list 1, item 47.
Which matter, sir?
My lord, it's in item 47 in list 1. It couldn't reach till now, my lord. And there was some, my lord, urgency in this. There were 2 interim orders passed by your lordships to ask the CBIC to pass orders.
Please give me a moment, sir. I'll come back to you. I'll just finish the third list and come back. Yes.
All right.
Yes.
Dharwad bench, Anil Kale.
For the petitioner, amendment is to be carried out. The complainant was impleaded, my lord, on an earlier occasion. I have to carry out, my lord. In fact, my colleague had come. Since he had no wakalat, my lord, it is not permitted. My lord, I'll send with, my lord, along with the wakalat.
The learned counsel for the petitioner seeks a week's time?
2 weeks, my lord.
A week's time to do the needful. Interim order subsisting would continue till the next date of hearing. List these petitions. List the petition on 19th.
Please, my lord.
Further hearing of all interim orders. Further hearing. Chetan.
Please, my lords. EC Heck, my lords, furnish the judgment.
Word,
how only on the point of, my lords, section 154. I have
which judgment, sir?
My lord's judgment, my lords, I have along with the list of authorities I had furnished on last date of hearing to court of.
List on 19th, interim order subsisting would continue till the next date of hearing.
Number 3.
3.1, 3.2. Oh, this MRP. Girish, hold money.
Minutes I am appearing on the.
Yes, Girish.
Please, minutes. Minutes, may I seek on Tuesday, minutes?
At the Gengu 5 o'clock, Tuesday 2:30.
Please.
List the matter on Tuesday 2:30 p.m. Wednesday, Monday 200. Tuesday is better. We'll see. Supreme Court. Then Thursday. Wednesday. Wednesday. When do you want? Huh? 11th. Tax day. I don't know. Yes. Yes. All right. 11th.
Minutes. ESGs.
Seal number 4.
I'm appealing for the respondent. With the petitioner.
4. Synopsis all hakidira.
That VAT and service tax.
11th will do it.
Yes.
My preliminary objection is on yes. Interim order subsisting will continue to the next date of here. Yes. Now. ಯಾವುದಿದೆ ಅದು ತಗೊಳ್ಳಿ ನೋಡಿ.
Orders at 4 p.m. Saravana. 35.
Small inconvenience today.
We'll vacate the interim orders.
It's nothing like that, my lords.
I'll vacate the interim order.
My lords, senior is held up in another court, my lords. May be taken.
ಅದು ಪ್ರಾಬ್ಲಮ್ ಇಸ್ 5 ಗಂಟೆಗೆ ರೀಚ್ ಆಗ್ತಾ ಇದೆ, ಅದಕ್ಕೆ ಇದಾಗ್ತಾ ಇರೋದು. ಆಯ್ತು, ಸೋಮವಾರ ತಗೊಂಡು ಸೋಮವಾರ ಆಗಲ್ಲ, ಮಂಗಳವಾರ.
Please.
Tuesday we'll take it in preliminary hearing.
Please, my lords.
Our orders list and our pass over ಕೊಡಲ್ಲ, adjournment. Tell Ravishankar.
Please, my lords.
Yes. First ಇಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ಆಮೇಲೆ ಬೇರೆ ಕಡೆ ಹೋಗಿ.
Please, my lords.
ಮತ್ತೆ 1952 ಇಂದ ಬೇರೆ ಹೇಳ್ಬೇಕು ಅಂತಾರೆ.
62.
52 ಇಂದ 78 ಗೆ ಬಂದಿದ್ದಾರೆ. He's told his file fast forward to 2018.
Please, my lords. Yes. Much of interim order.
That will continue.
List 2 continued.
List 2. List 1B. Admission ಇದೆಯಾ? Admission posted on 12th. List 2 admission matters will come on 12th.
230 matter was there. One matter.
All admission matters on 12th.
One matter where the judgment was passed pursuant to the interim order.
Adanna wait. Where is that?
230, 34, serial number 34. List 2.
34. We'll take it as disposed. No, I want to lay down some guidelines where certified copy should be, the web hosted copy should be accepted. So the litigants are not put to problem.
And also court, my lords, can it be taken up for hearing on one day? Because I need to file order sheet. It is recorded that 11 o'clock we were present and only memo was submitted.
Record ಆಗಿದೆಯಾ?
Order sheet ಅಲ್ಲಿ ಅಮಲ್ ನಾವು ರೆಕಾರ್ಡ್ ಮಾಡ್ಸಿದ್ವಿ, ಜಜ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಮಧ್ಯಾಹ್ನ ರೆಕಾರ್ಡ್ ಮಾಡ್ಸಿದ್ವಿ, ಬೆಳಿಗ್ಗೆ ಇದ್ದಿದ್ನ ರೆಕಾರ್ಡ್ ಮಾಡಿ ಅಂತ.
ಆಯ್ತು ಸರಿ. ಹಾಗಾದ್ರೆ ಅಲ್ಲಿ ಇದನ್ನ ಮಂಡೇ ಪೋಸ್ಟ್ ಮಾಡ್ತೀನಿ. ಮಂಡೇ ಈವ್ನಿಂಗ್ I'll take. Evening ಅಂದ್ರೆ 4:30 will take it.
Just produce that order sheet and also
Yes,
few judgment.
34 list on Monday. Make it big group matters will give date.
Interim order maybe.
Interim order will continue.
Great.
Lordship, serial number 30, further hearing, Lordship.
All further hearing on 12th. Urgency ಇದೆಯಾ?
ಅದು respondent is a heart patient, Lordship. ತುಂಬಾ ದಿನದಿಂದ
ಚೆಕ್ ತಾನೆ ಮೈಸೂರ್ದು.
Please.
ಅವರೇನು ಕೊಡಲ್ಲ ಬಿಡಿ ನಿಮ್ಗೆ.
Please. 12th, my lord.
12th.
Please. 2:30, my lordship.
40th matter.
Yeah, 2:30 further hearing 12th.
Please.
12th competition ಇದೆಯಾ? ಅದು ಬೆಳಗ್ಗೆ ಮುಗಿದೋದು 2:30 ಹಾಕಿರಿ. Yes.
Much.
Serial number
40th matter in the least 1 year. 40th matter in the least 1 year.
List 1. List 1 B group 11th and 18th. 2 dates. Interim orders wherever are there will continue.
Serial number
as far as
It could be
My lord,
tagged with
item
serial number 20.
47 is concerned.
57, tag with serial number
47.
22.
My lord,
1 minute. Individual cases, please, individual matters don't mention. B group matters on 11th and 18th.
Your Honor, another one, serial number 61.
And 25th, all 3 dates.
Your Honor, serial number.
25th, yeah.
Your Honor, serial number 61. There is an urgency. They have released. They have seized all the golds and silver ornaments. So, right from December. So
Right from?
December. So it can be taken by 2:30 and any other particular date. Your
Why?
Honor.
Because it is gold, is it?
No, Your Honor.
Then?
It's a matter wherein search has been challenged.
We'll see. When it is on that date, you make a mention, we'll take it at 2:30. When it is listed, you make a mention, I'll take it.
It can be listed on 11th, Your Honor.
11th, 18th and 25th, 3 dates it will be distributed. On which day it comes, you make a mention. At 2:30, I will take.
Your Lordship, there is one item number 100.
Yes, sir.
I make a mention.
Your Lordship,
1 minute.
item number 117 in list
Wait,
1.
sir. Senior is making a mention. Wait, what is that matter?
My lord, item 47, Mr. Surya is also there in that matter.
47.
47. Lord, here the problem is, Lord, if your lordship can take it up on 18th, I can come down physically also.
When do you want, sir?
Twice your lordship, 18th, my lord.
18th.
if possible.
Come on 18th.
Yes, my lord. All I'm saying is, my lord, that if it can be taken up at 2:30 or sometime. Why, my lord? Because your lordships have passed.
You're not audible, sir. I'm not able to hear you completely.
I'm saying, my lord, that my lord, is this clearer to your lordships now?
Yes.
My lord, am I what? Yes. My lord, on two occasions, your lordships have given time-bound directions to the respondents to pass a particular order. And this is an industry-wide dispute, and it's creating mayhem in the market because of these
There is
issues.
Arvind Chavan. You're ready? I'll take it on 18th.
18th, my lord, yes.
Yes, he wants it on 25th. By then he would file his objections.
All right, my lord. I have
25th. So we'll take it on 25th. No adjournment there. Yes.
All right, my lord.
47 on the 25th. Make it 11th, 18th, 25th. We'll distribute.
In 47, my lord, the interim order also requires.
Interim orders will continue, sir. Wherever interim orders are.
Last 2 occasions it was not extended, I think.
Before me?
No, it didn't. Your lordships were not sitting. Therefore.
Oh, there it is. All right. Yes. It will get. Don't.
Great.
Jawai, interim
Your
order.
Lordship, can I mention 117?
Yes, sir.
Your Lordship, it's a time barring issue. DRP time limit is getting over on 31st of October. And we have challenged the assessment order which was passed erroneously.
It will come, sir. Before the end, before 28th of this month itself, it will come.
Your Lordship, if my Lordship could give me
This matter
next
has to get
week's
remanded
date.
back, Your Lordship. Can it be on 11th on caption order, Your Lordship?
Which one, madam?
Serial number 90, Your Lordship. Department
Morning.
council. Today it is
19.
listed.
That is
No,
already-
90.
90.
First list.
It is in B group, right?
Yes, Your Lordship. But that matter only has to get remanded back, Your Lordship.
No, on that day, which are the remand matters you tell me? I'll,
Yes,
in
Your
the
Lordship.
morning itself, pass orders on all those remand matters.
Can it be on caption order, Your Lordship?
Whichever caption it is, don't worry.
Your Lordship, any date in next week for item number 117, please?
It will be distributed, sir, 11th, 18th and 25th.
Your Lordship,
11,
92 and 103, Lordship, can be
Grateful.
taken up on 11th, since the stay has to be granted in these two matters.
Interim order is not there? Interim order ಯಾವುದಿಲ್ಲ ಅದನ್ನ 11th ಹಾಕಿರಿ madam.
Serial number 127, man. 127.
Yes.
This is a matter which my lords had heard the matter.
Case law.
This is with regard to appeal not being filed within the time, since the bank account was frozen.
ಇವ್ರದ್ದು ಅದು ಹಾಕಿದ್ದು ಯಾಕಂದ್ರೆ
They have some more
ಕ್ಲೋಸ್
judgments.
ಮಾಡೋಣ ಯಾಕೆ ರಿಸರ್ವ್
ಅದೇ.
ಯಾಕೆ ಮಾಡಿದೆ ಐಡೆಂಟಿಕಲ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಸೂರಜ್ ಗೋವಿಂದರಾಜ್ ಅವ್ರದ್ದಿದೆ ಐ ವಿಲ್ ಜಸ್ಟ್
4 case laws, my lord, which have.
ಕೊಡಿ
ಅದ-
ಈಗಲೇ
ಅದ್ರಲ್ಲಿ- ಅದ್ರಲ್ಲಿ ಫ್ಯಾಕ್ಟ್ ಸ್ವಲ್ಪ ಡಿಫ್ರೆಂಟ್ ಆಗಿದೆ. but
ಏನಿಲ್ಲ ಎಲ್ಲ
ಅದ್ರಲ್ಲಿ my lords, it was seized by under the money laundering act.
ಯಾವ್ದು ಆಯ್ತು
ಅಷ್ಟೇ. Difference is only that.
issue is same. The bank account was frozen, whether it is seized under PMLA or that's immaterial. Bank account was frozen and now the account is defrozen. Now he will do it is what their coordinate bench holds. I will follow that. That's all.
Some more judgments of different high courts, which my learned friend is.
Judgment of Bombay High Court, my lords, in GST matter itself. at page 2, paragraph 2 and 3, my lord, Bombay High Court. And there are series of decisions, my lord, on this.
Yes, yes. That's
Para two.
precisely why, instead of reserving, better to
Para 2 and
dispose
3,
it.
page 2, my lord, and page 5, para
No, I
9
thought
and
I
10.
lay on some guidelines. ಇದು ಸ್ವಲ್ಪ ಅದಕ್ಕೆ
my lord
ಎಂಟರ್ ಆಗೋದು
wanted to
ಬೇಡ. ಕೇಸ್
pass
ಟು
a
ಕೇಸ್
dictate
ಬೇಸಿಸ್
order.
ಮಾಡಿದ್ರೆ ಒಳ್ಳೇದು.
My lord,
The petitioner is before this court seeking the following prayer. Heard so and so. The petitioner is registered under the provisions of the GST Act. What brings him to this court in the subject petition is the non-entertainment of the appeal on the score under section 107 of the Act, on the score that he has failed to make pre-deposit.
They have not even filed that appeal because they cannot file unless they make a pre-deposit.
we cannot file.
Has failed to file an appeal, which in fact has resulted on the score that he is unable to make the deposit. It is the facts in brief, Germain, are as follows. The petitioner is said to be an undertaking which serves manpower recruitment and manpower recruitment. The petitioner had not upload ಮಾಡಿರಲಿಲ್ವಾ?
During the
The
period in time,
petitioner during the relevant point in time is said to have closed his
closed down
business,
their business.
and assessment for the earlier years was pending before the respondent authority. The adjudicating authority passes an order against the petitioner, which the petitioner wanted to challenge it in appeal. The impediment was, as the account of the petitioner was frozen till 28th May 2025, which was during the period within which the petitioner had to prefer an appeal before the appellate authority. Therefore, with the freezing of the account, which was the only account that was linked to the GST of the petitioner could not prefer an appeal, as he could not operate the bank account and a bank account. In that light, the appeal comes to be, and in that light, the petitioner has not preferred an appeal. The bank account gets defrozen at a later point in time. By then, the period of appeal was over. In identical circumstances, the coordinate bench of this court has held as follows. Amnesty idralide. Justice Suraj Govindaraja ಅವರು paragraphs JY.
One page 2, paragraph 2 and
Full ಹಾಕ್ಬಿಡಿ, ಇದೆ 2 page. The learned counsel for the petitioner also places reliance upon the judgment of the High Court of Bombay in identical circumstances. The Bombay High Court has held as follows, para 2 to 4. The Bombay High Court, earlier to the aforequoted judgment, has also, division bench of the Bombay High Court, earlier to the aforequoted judgment, has again held as follows, para 8 to 12. The High Court of Andhra Pradesh, ಇದರಲ್ಲಿ ಏನು para?
My lord, this is the dissent starts from page 7. This is the para 16, 17 and 16 and 17, my lord.
15, 17.
17. SA Iron.
ಆಮೇಲೆ ಗೌಹಾತಿ
The Guwahati, my lord, says that.
ಗೌಹಾತಿ ಬೇಡ ಬಿಡಿ. Yes. In the light of the issue standing completely answered by different high courts, as by the coordinate bench of this court and different high courts, the petition deserves to succeed by the following order. Same Justice Suraj Govindaraja ಏನು ಮಾಡಿದ್ದಾರೆ. Yes, ordered accordingly.
My lords, list to serial number 20. Any date may be fixed, my lords.
ಯಾವುದು ಮೇಡಮ್ ಅದು?
List to serial number 20.
Admission
Admissions.
ಸ್ಟೇ ಇಲ್ವಾ?
Stay there, my lords.
ಇದೆ ಅಲ್ವಾ?
Grateful, my lords.
Serial number 32, cash list 2 lakhs. Okay. 12th date.
12th ಇಲ್ಲ. ನಿಮ್ದು ಇದೆ ಫರ್ದರ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್.
Yes, yes, please, my lord.
Tuesday,
That matter.
ಮಂಗಳವಾರ 2:30ಗೆ ಅಥವಾ ಜಗದೀಶ್ ಸರ್ ಬರಕ್ ಹೇಳಿ.
Please, please.
ಜಗದೀಶ್ ಯಾರು ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಇರ್ಬೇಕು ಅದ್ರಲ್ಲಿ.
Yes, yes, please.
ಕೇಳ್ಬಿಟ್ಟು ಯು ಗೆಟ್ ಹಿಮ್.
My lord's list 143. Oblige.
Serial number 26, my lord.
CBI ಪ್ರಸನ್ನ ಕುಮಾರ್ ಬರಕ್ ಹೇಳಿ ಹಾಗಾದ್ರೆ.
That matter, Prasanna Kumar is not.
Oh, correct.
AD is appearing.
List
Serial number-
65, can it be had on 11th?
11th. It is on 11th only. Yes.
Serial number 26 and list number 2, my lord. The only I'm seeking writ of mandamus to directing the respondent to consider representation for 38D to regularize the.
38D.
Yes, madam.
Ajay Kumar.
We seek instructions in this matter.
Hello, ಮಾಡ್ಬೋದಾ?
38D ಅಂತ ಇದ್ದಾರೆ ಬಟ್ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ 38D ಇದು.
Yes.
Serial number 43, list 1.
Already they left out.
First list?
First list.
11th, 18th or 25th? Yes.
Date may be fixed, month 26.
9th or 16th?
Please. 9.
Madam.
Madam, list number 27 add date ಕೊಟ್ಟು.
ಇದು 29 30 ಆಗೋಗಿದೆ ಆಯ್ತಾ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತೀವಿ ಇಲ್ಲಿಂದ ಯಾಕೆ ಅವ್ರು ಹೇಳಲ್ಲ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್
ಅವರೆಲ್ಲ ಒಳಗಡೆ ಹೋಯ್ತೇವ್ರೆ. ಇಲ್ಲೆಲ್ಲ
ಮೇಡಮ್